welcome to Law News. I'm Amy Dash. This is my first time hosting, so thank you all for welcoming me into your living rooms, your phones, wherever you're watching this live streaming broadcast. And I hope everybody had a wonderful 4th of July weekend. Because of the holiday, we are doing some very special coverage today. We're bringing back an oldie but a goodie. The Casey Anthony trial. That was Casey Anthony. She was a young mother who was charged with killing her 2-year-old daughter Kaylee in 2008, acquitted to the shock and surprise of many, including the judge. And we will have some very special guests today. But first, we're going to get right into it, and we're going to start replaying the opening arguments.
Good morning, ladies and gentlemen. Welcome to Orange County. As we have heard several times throughout the course of the jury selection proceedings, this is the case of the state of Florida versus Casey Marie Anthony. However, it is time to tell the story of a little girl named Kaylee. This isn't just a case about Casey Marie Anthony. It's a story about Kaylee Anthony as well. Kaylee Anthony was born on August 9th of 2005. It was a Tuesday. And Kaylee lived nearly every day of her life on a quiet residential street in Orlando called Hope Spring Drive. Her doting grandparents, George and Cindy Anthony, filled her room with toys and stuffed animals. Kaylee's room was decorated with every imaginable Winnie the Pooh item available. In the backyard of George and Cindy Anthony's home was every little girl's dream, a playhouse. Complete with her own mailbox, with her name and street address affixed. Kaylee's grandparents, George and Cindy, moved to Orlando in 1989 from Eastern Ohio. They came here with their children, Casey Anthony, the defendant in this case, who was 3, and her older brother, Lee Anthony, who at that time was about 7 years of age. They moved from Eastern Ohio to the address on Hope Spring Drive and have been there ever since. George Anthony, a former police detective in Ohio, has worked a variety of security jobs here in Orange County, as well as some other types of jobs. Cindy Anthony, a nurse, has worked continuously in the medical profession, working her way up to a management position. When their 19-year-old daughter, Casey, told them in June of 2005 that she was pregnant, they were concerned, yet elated at the prospect of becoming grandparents for the very first time. George and Cindy Anthony committed to helping their daughter financially and with providing support to little Kaylee Marie that a loving and stable home could offer. After a brief maternity leave, Mr. and Mrs. Anthony, George and Cindy Anthony, believed that their daughter, Casey, had returned to a job that she once had at Universal Studios. George and Cindy Anthony believed that Casey Anthony was a hard-working, single young mother. Over the next 2.5 years, Kaylee Anthony appeared to have an idyllic life. She was loved by her grandparents. They took lots of pictures of her. They doted on her. She was the apple of their eye. She did things like swim in the backyard, in the family's pool, an above-ground pool. She watched SpongeBob with JoJo, which is what she called her grandfather, George. She wore a Spider-Man outfit. And as I had mentioned, did a lot of smiling for the camera. Casey Anthony, Kaylee's mother, appeared to all outward observers to be what her parents thought she was. A loving mother working hard to provide support for her daughter. But as the evidence in this case and the investigation into the background of Casey Anthony will show, that was an illusion. Casey Anthony was not employed. Casey Anthony, dressed in work clothes, had a universal ID, and went who knows where for 2 years after Kaylee Anthony was born. Although the cracks in Casey Anthony's facade began to break and show themselves or be revealed in the weeks and months prior to June of 2008, Father's Day, June 15th of 2008, started out as a typical Sunday in the Anthony household. You will hear during the course of this case that George Anthony, at that time, in June of 2008, had a security job that had him working regularly from 3 p.m. to 11 p.m. Cindy Anthony's job as a nurse manager had her working hours closer to 8 a.m. to 5 p.m. George Anthony worked that Sunday, Father's Day of 2008, starting his shift at 3 p.m. Cindy Anthony took her beautiful little granddaughter to see her great-grandfather, Cindy's father, who was in a nursing facility in Mount Dora. Cindy Anthony took her video camera and a still camera with her to record the events of Father's Day of 2008, June 15th. Cindy Anthony, unknowingly, of course, at that time, took the last known photograph of her granddaughter, Kaylee Anthony. On that Father's Day in Mount Dora, Kaylee Anthony snuggled with her great-grandfather, who she called Papa. She colored she read, she sang, and she had fun. Eventually, the afternoon grew longer, and Cindy, her grandma, decided they needed to leave. Cindy Anthony returned to the home on Hope Spring with Kaylee, and they swam in the pool, and Kaylee had fun. Casey Anthony, according to her cell phone records from that day, spent most of it with her new boyfriend, Tony Lazaro. She arrived back at the Hope Spring address, again, according to her cell phone records, around 7:30 in the evening. As I told you, George Anthony worked the 3 to 11 shift. And according to testimony that you will hear from both George and Cindy Anthony, that evening, everything appeared to be fine. They went to bed, readied themselves for the typical start to a work week, or so they thought. On Monday, June 16th, Cindy Anthony goes to work, as I've described, sometime between 7 and 8 a.m., and is out of the house until the late evening. Until the early. George Anthony, again, has to work the 3 to 11 shift and is up early, had breakfast with his granddaughter, Kaylee, and noted that his daughter, Casey, began to get ready for work around noon, shortly before. George Anthony specifically recalls that at 12:50 p.m. on June 16th of 2008, his daughter, Casey, left the residence on Hope Spring Drive with Kaylee Marie Anthony. Kaylee was wearing a pink shirt, jean shorts, sunglasses, and a backpack. And Jojo, George Anthony, kissed his granddaughter goodbye and never saw her again. In fact, no one but Casey Anthony ever saw Kaylee Marie Anthony alive again. We've already shown you the last photographs taken of Kaylee Anthony. The next time a photograph is taken of Kaylee Anthony is on December 11th of 2008. The story of this case is not about Casey Anthony. It is about what happened between the photograph taken on Father's Day, June 15th, 2008, and the photograph taken on December 11th of 2008. What happened to Kaylee Marie Anthony? You will hear during the testimony in this case that no one had any idea anything had befallen Kaylee Marie Anthony until July 15th of 2008. How can that be? What happened between June 16th and July 15th? Where was Kaylee Marie? "30 days passed between the time that anyone but Casey Anthony saw Kaylee and when she was reported missing by her grandmother, Cindy Anthony." So what happened? Day 1, Monday, June 16th, 2008. Cell phone records for Casey Anthony show that she did not leave the area of her parents' house until after 4 p.m. that day, despite the fact that her father saw her leave the residence at 12:50. When she leaves, she tells her father, George, that she's going to spend the night with Kaylee, with a babysitter. She told her mother that she was going to spend the night with a babysitter by the name of Zanny. You will learn during the testimony and evidence in this case, there is no Zanny. Like Casey Anthony's job, Casey Anthony's babysitter was a figment of her imagination. There is no Zanny. So when Casey Anthony appears on a surveillance video at the Blockbuster with her boyfriend, Tony Lazzaro, on the night of June 16th of 2008 at 7:54 p.m., where is Kaylee Anthony? Day 2, Tuesday, June 17th, 2008. Casey Anthony's cell phone records show that she was at her boyfriend Tony's apartment until about 2 in the afternoon, at which point in time she traveled to Hope Spring Drive, her parents' house.
Well, we were watching opening statements from the Casey Anthony trial, and that was prosecutor Linda Burdick. And I have a very special guest, someone from the prosecution team. Jeff Ashton will be joining us right now. So if we can bring him in, he's on Skype in Florida. Hi, Jeff. How are you?
Good. How are you?
Good. So I want to ask you a couple questions, then we'll get back into the opening statements, and we'll sort of analyze how things went together. Did you ever think, when you took this case on, that it would snowball into this trial of the century that was later compared to the O.J. Simpson trial, the amount of media coverage and attention, the public attention where people were actually getting into physical fights to try to gain access to the courtroom. Did this ever seem like something that you could have anticipated?
When we first got involved in it, no, I don't think anybody anticipated that. It clearly was something that was, gaining more national attention than most cases that we dealt with. But I don't think anybody could have anticipated, how the combination of 24-hour news cycles and the internet's availability of information would make this case as huge as it was. And I think it sort of evolved slowly as the case moved on, and all of a sudden we sort of found ourselves in the middle of this circus, and it was somewhat of a challenge at times to sort of separate all that out, but I think we did a pretty good job of it.
What's your take on why it was dubbed the social media trial of the century? How important was the social media element?
Well, it was. I think more than social media, to me, it was the internet, which really go together. This is the first big trial where people could watch the trial on their computers or watch proceedings on their computers, and so it made it so people could sort of feed their addiction immediately. I mean, with the OJ trial, you had to wait till you got home to watch clips or news or whatever. But here, people watched it at work on their computers. People, had it on the TV set as background for the summer. And that combined with the fact that any piece of information you wanted to know, you could just go on the internet and look it up. As we talked about before we went on, Florida's public records are so liberal that everything that we provided to the defense was immediately provided to the public. So, you didn't have to wait for someone to comment on it. You could just go and look it up yourself. Yeah. And I think you combine all those things, it just made for a huge obsession with the case.
Yeah, the public records law in Florida is like crack for the media.
Oh yeah, you guys love it.
Because we can get everything. I was telling you that I'm actually covering a case in Florida, and I was able to get the DNA results, and the case isn't even set for trial yet.
Yeah, it's a good thing in the sense that it makes us very open, but sometimes I think it can backfire on us. And I think, I've always sort of argued that this is a situation where that system kind of backfired on us. It really did, in my opinion, ultimately affect the outcome of the case. So, it's good and bad, but it is what it is. In
what ways do you think that it affected the outcome of the case?
I've in looking back on this case, after the verdict was over, I asked myself, why is it that this group of 12 people saw this case so differently than everybody else did? Hundreds of thousands of people had looked at the same evidence and come to a different conclusion. And, one of the things that I finally sort of realized was that, the media had done such a good job of convincing anybody out there, who was reasonably neutral or reasonably, interested in the case, that she was guilty. So, at that point, when we did the trial, the jury had already heard everything. And when you go through jury selection, as you've covered trials, one of the first things you ask jurors is, have you read about the case? And do you have an opinion about the guilt of the defendant? And if the answer is yes, then you're excluded from the jury. So essentially what I think happened here is that the media convinced all of the jurors I would have wanted on this trial that she was guilty before I had a chance to. And so they were all excluded. So when you exclude all of those people from the jury, what do you have left? You have left people who have a tendency to have their opinions skewed, in favor of interpreting reasonable doubt, to its nth degree. So in that sense, it probably didn't really surprise me when I look back on it, that this is how it turned out.
That's fascinating that you say that the media narrowed the jury pool, and you really
Sure.
feel that that affected the case, because that's really interesting. We're going to be talking about jury selection in a trial that's coming up, the Holly Bobo trial. And we're going to be talking to a jury consultant, and she actually says that when you're picking a jury, you want to find people, number one, that can relate to, if you're the prosecution, that can relate to the victim.
Right.
And so also she said, which I found fascinating, that people who watch crime shows are more likely to rule in favor of the prosecution. Have you found that to be the case?
I think that's probably true. I think people that, are fascinated with the process of investigation and prosecution of crimes, they like those kind of shows because they're the kind of people who like to put the pieces together. And in the circumstantial evidence case, like this case was, that's the kind of juror that you wanted for the state. You wanted a juror that liked putting the pieces together to figure out what happened. And again, the media, in my opinion, had pretty much already convinced all those people that she was guilty. And they're honest people, and so when they're asked, they're going to say, "Yeah, I think she's guilty."
Yeah, because when you think about it, the people that watch the courtroom shows.
Go ahead.
No, when you think about it, the people that watch the courtroom shows are also the people that are watching these trials in the media, so they're excluded.
Right. Exactly. The one thing that was interesting about this trial is there were very few comments from the jurors in the case, but one comment from the foreperson after the verdict particularly struck me. He was talking about the opening statements, and in describing the state's opening statement, he said, "Well, the state's opening was pretty much what we already knew." And when I thought about that, it occurred to me that you're right. They did already know that, and having known all of that, they weren't convinced she was guilty. So, what were we going to do?
Yeah. When we talk about courtroom drama, do you think that Jose Baez's performance, because he was quite convincing, I mean, this guy could give me a bowl of dirt and tell me that it's a mud pie, and I'd probably believe him and eat it all up. I mean, do you think that he overshadowed the evidence in this case and possibly even the prosecution's acting or performance, delivery, however you'd like to call it?
I think that Jose is a great salesman. So I think that boded well for him. Also what worked well for him is he was willing to, say whatever he needed to say. His opening statement was very controversial and still is in legal ethical circles, because he said things in opening statement that there doesn't appear to be any actual factual basis for. In other words, he gave a version of events that no one else had given, and in fact ultimately was not proven at trial. So, when you're a good salesman and you're willing to, do whatever it takes, then yeah, that's a very successful combination.
Yeah, it's interesting you brought that up, because the jurors didn't think in the end that Casey Anthony's lying really supported this murder case. I disagree. I think that it definitely supported the fact that there was a cover-up. When you see somebody lying day after day after day for a month about the whereabouts of their child, and someone with a history of lying, that to me is very convincing given the other facts of the case. Right?
Well,
so,
I think that's the attitude that most people would take on hearing that evidence. And again, as I said, since that piece of evidence had been so broadly published and so many people have been convinced by it that she was guilty, the people you have left are people that try to find other explanations for that. There are people that are sort of preconditioned to doubt everything. And, as you know, the standard is reasonable doubt, and it's left up to a juror to decide what that means. And when you have people that are sort of pre-screened to have a high level of doubt, then it's very hard to ever convince them of anything.
Right, and as you said, Jose Baez gave explanations, but then he never proved them. So really it came down to, who do you believe about the lies? And why do you think that the jurors bought into Jose Baez's explanations and not the prosecution's?
Well, honestly, I don't know that they did. I think this jury just did not want to convict Casey Anthony. I mean, I never really got the impression from any of the statements from the jurors that they necessarily believed that George did it. I just think, as I said, this jury was sort of pre-screened to have a very high standard of what beyond a reasonable doubt meant. I mean, the only comments they actually made were basically, well, you know, if they couldn't even prove exactly how Kaylee died, then that's it. And that's not a legal standard, but that's a standard that, you know, they're entitled to use. So I don't know that they really believed Jose's story, but I just think that, you know, there was enough of their desire to find reasonable doubt and enough sort of mud thrown that, you know, they could find it if they wanted to.
You know, I heard from a lot of the jurors that some of them were saying that they felt sick not convicting her. So in disagreement with what you're saying, a lot of them said they wanted to convict her, but they didn't find the prosecution's case strong enough. There was a lack of a motive according to them. There was no cause of death, and they didn't feel that there was forensic evidence or anything strong enough to connect her with the murder.
Well, that's a common sort of excuse that people give. Well, I really wanted to do the right thing, I just couldn't. And you know, we gave them more than enough evidence in this case, tons of evidence in this case, to convict Casey Anthony. In the end, they just didn't want to. Whether it was because she was this cute little thing across the courtroom from them who cried at all the right times, or whether they just didn't care enough. I mean, who knows? But you know, it's a convenient excuse to say I wanted to, but I just couldn't. No, sir, that's wrong. You could have. You just chose not to, which is your right.
We were showing some pictures of Kaylee. As a mother, it's hard for me to look at this face of this young girl and not tear up, because even the fact that she died, but the way that she was disposed of in the swamp with rattlesnakes and with the Winnie the Pooh blanket. I mean, this girl, you look at her face, she is so precious. It is so heartbreaking. Do you still think about Kaylee?
I do. You know, I recently there have been some some shows that have come out, you know, about the case, and I think one or two of them included some new theories by either George Anthony or Cindy Anthony. I think maybe even Belvin Perry has made a comment, and you know, they've given various theories that basically put the responsibility on Casey, but say it's not murder. You know, the one thing that when I look at what happened with Kaylee, that could only be done by somebody who was extremely narcissistic and heartless. And Casey's the only one whose history has shown her to be that person. You know, the person that disposed of Kaylee just threw her away and never thought of her again. Oh. And that is exactly what Casey was.
I just don't understand how anyone could do that to a little baby like that. I'll never understand that.
I don't either, but you know, I honestly, I can't wrap my head around a lot of what Casey has done. I can't wrap my head around your daughter either dying by accident or disappearing and then going off and partying for 30 days. I mean, that is equally to me as inexplicable as what happened to Kaylee. So, well, you know, we don't understand Casey Anthony at all.
Clearly somebody disposed of that body. So Casey Anthony was acquitted.
Yeah.
People feel that she did it. Some people feel she didn't, but she was acquitted. On October 14th, 2008, before Kaylee's body was found, your office charged her with first-degree murder. Were you prepared at that point to try this case without a body? And is that something that you've ever had to do?
The answer is yes. We were prepared to try it without a body. We felt the evidence at that point, you know, was pretty compelling that Kaylee was dead. It was nonsense. Obviously, we would have preferred to, you know, find the body, which we eventually did. And no, it's not something that we had ever done before. It's been done in the state, but we had never had a case like that before. They're very difficult, but particularly in this circumstance where the missing person is a child, you know, excuse me, under 3 who, you know, didn't, you know, go off on their own and move to Cincinnati and change their name. And and where you have the circumstantial evidence of the story, you have the chloroform, you have the smell of a dead body. Those we felt were pretty compelling in proving that Kaylee was actually dead.
And then when they came upon the body, the defense team wanted access to that crime scene. Why didn't you want them to get access?
We didn't trust them. That's the bottom line. We didn't trust them. We didn't have faith in the fact that they would not, do something. The other thing is, it's just not something we ever do. We have never, in a case, any murder case, given the defense access to evidence before it's been processed. Our crime scene processing apparatus, our crime lab, are excellent, above reproach, and there's absolutely no reason to allow anybody else to be involved in this. Everything was very thoroughly documented, so we just said, well, we're going to do this like we do every other case. And
what was their reasoning? Why did they want access?
Because I don't know. You have to ask them that.
Roy Kronk, this man who discovered Kaylee, there was a lot of speculation about whether he killed her, whether he assisted George in dumping the body. The defense team said that they wanted his phone records, they wanted his computer. That was never turned over. Why didn't you feel it was important to investigate him to that extent, with getting his phone records and his computer, to see what kind of involvement there was, if any?
Well, I think they got his phone records. I'm not sure about that, because that's something they get by subpoena. And it's been 6-7 years ago, but I seem to recall they asked for and received his phone records. His computer, that's his private property. Those are his private dealings on the internet, and there simply wasn't enough evidence there was no evidence connecting him to George Anthony at all. There was no evidence connecting him to the Anthony family at all. There was substantial evidence that showed that in August he actually did stumble upon the body, coincidentally. So there was just nothing there to support allowing the defense to invade this man's privacy that way.
How much evidence was there that never made it to trial in the end?
Really, the only significant piece of evidence that didn't make it to trial is Casey Anthony's own statements. She gave interviews to two, a psychologist and a psychiatrist, and gave a version of what happened to Kaylee, and that never got before the jury.
There was some rumor that there was some sort of examination on a rattlesnake. Was there an autopsy on a rattlesnake? Because she was dumped in an area, it was a swamp area that was heavily populated with rattlesnakes, and the defense sort of mocked the prosecution and said, they're even autopsying a rattlesnake. Tell us about that.
Well, yeah, when on the story goes that on the day in August when Roy Kronk originally stumbled on Kaylee's remains, he was with a bunch of other fellow workers, and he told them that, hey, I think there's a skull back there, and they didn't believe him. Instead, they all got fascinated by this dead rattlesnake that was found off the side of the road nearby, and one of them actually took it and took it home, put it in the freezer, and in fact still had it 4 months later. I don't remember what, if anything, was actually done with the rattlesnake. I don't remember that it was actually autopsied. If it was, I just don't recall. It wasn't anything of significance. If it was, I guess it's just trying to be thorough, but it's not something I certainly would have suggested they do.
Trying to be thorough. So can I use the Florida access law to obtain a copy of this autopsy report of the rattlesnake?
Yeah, you can make a public records request for it. Like I said, I'm not sure it actually happened. I think they may have taken the rattlesnake into evidence, in case somebody wanted to do something with it, but I don't recall that we ever did anything more with it than that. I don't remember.
But there is a significance to the rattlesnakes, because I recall Roy Kronk saying he brought the police there multiple times saying that he saw a body, and he believed that because he told them that there were so many rattlesnakes, that these officers were kind of scared to do a thorough search. Do you think that if she had been discovered earlier, we would have had more evidence potentially implicating someone?
I've thought about that a lot. I mean, you know, she was killed in mid-June, and this incident with Roy Kronk was almost exactly 2 months later. According to all the experts that we consulted during the trial, a forensic anthropologist, pathologist, etc., they were pretty uniform in their opinion that really the body was probably skeletonized in a couple of weeks, and that there's very little likelihood that in August the condition of the body would have been any different than it was in December. So I think as far as proving cause of death, no, it wouldn't have made a difference. It's unlikely, in my opinion, that any, you know, forensic evidence that, like, for instance, DNA, and any DNA that would have survived the heat and moisture of a Florida summer, I doubt would have dissipated or been destroyed in between August and December. So, I mean, no one will ever really know. I just don't. My opinion is it probably wouldn't have made a big difference. I think her body would have been in much the same condition. It probably was underwater in August, so in that sense, having it dried out may have made it a little easier to collect evidence, and certainly made it easier for us to retrieve, you know, all of her remains. But, you know, nobody really knows. It's just a huge embarrassment for the Orange County Sheriff's Office that
absolutely
we're showing pictures.
Absolutely, we're showing pictures again of this beautiful little girl, Kaylee. It's so difficult to look at those pictures and think about what happened to her. What are you the most proud of when it comes to this trial?
I think what I'm the most proud of is, you know, the job we did, the way we presented the evidence, and I'm particularly proud of the way we handled the verdict. You know, I thought that all of us acted in a way that was very professional, and that, you know, that people who were displeased with the verdict, which was almost all of the United States, you know, that the message they consistently heard from us was, the system works, don't abandon the system. It may not be what we want, but you got to believe in the system, and you got to respect the jury's verdict. So, you know, none of the jurors have been hassled. None of the jurors have been sought after, as far as I know. Casey Anthony has not been hurt. She hasn't been attacked like everyone said was going to happen. You know, people took the verdict and we moved on. So I think that's the part that I'm the most proud of.
We're getting some really good feedback on your book here from our chatters, our bloggers, saying that they've read your book, Imperfect Murder, and they enjoyed it. So we'll talk about that a little bit later.
Sure.
What are some of the things that you wish you had done differently?
Well, I mean, the biggest thing I wish we had, as many of you may know and many other people may know, you know, after the trial and the verdict, eventually, you know, Jose Baez published a book, and in that book, he, you know, indicated that his forensic examiner's examination of the Anthony computer showed that on the day that Kaylee disappeared that afternoon, somebody had searched for foolproof suffocation on the internet. You know, our people missed that, and you know, I wish we had that at the trial. Obviously, you know, I don't have all the information of exactly when that was done, and you know what other searches were done near it, and you know, there's much I'm sure we could do to identify where that came from. But you know, that's the biggest thing I wish we had. Other than that, there were small things. You know, I handed an expert the wrong exhibit one time. That was a little embarrassing. We had a problem with, again, one of our computer searches. One of the reports had, you know, had mistaken a search for one thing for another. Little things like that. But you know, those are the things that jump to mind immediately.
All right, well, we're going to watch some more of the opening statements, and then we're going to come back and we're going to discuss the evidence in more depth, and we'll talk about your book. So I really appreciate you being with me. So you're going to stand by a little bit, and we're going to toss right now to the opening statements in the Casey Anthony trial.
And was there from 2:45 p.m. until 4:30 in the afternoon. Her car was seen backed into the garage with Cindy, but Cindy Anthony will not be denied access to her granddaughter. And since Casey Anthony is stonewalling, telling her mother she doesn't want to upset Kaylee, she doesn't want to disrupt this routine that she's now in, Kaylee's going to be upset, Cindy has had enough and decides that the only way I am going to get access to my granddaughter is to get the police involved. So she drives Casey Anthony in her car to a substation of the Orlando Police Department, which at that time of the night is closed, and makes her first 911 call from her car, from the parking lot of that Orlando Police Department substation. During the course of this trial, you will hear that first call that Cindy Anthony made to the Orlando Police Department. She wants her daughter arrested. The dispatcher from the Orlando Police Department is trying to determine if there is a crime that's been committed and where that crime has occurred. So in making this inquiry, it is determined that the address on Hope Spring Drive, where the Anthonys live, is actually within the jurisdiction of the Orange County Sheriff, not the Orlando Police Department. And they give Cindy Anthony a choice about whether or not she wants to wait on the side of the road for a deputy to show up or go back to her house and make another call, and she chooses the latter. During this exchange, and while there is some dead air between the dispatcher and Cindy Anthony, you can hear Cindy Anthony threatening to take Kaylee away from Casey. And Casey Anthony asks her for one minute. You will learn that during this exchange, George Anthony, who's been apprised of some of this, not all of it, some of it, calls Lee Anthony, Casey's older brother, and says, "You need to get to the house." So Lee Anthony, who lives in the area, arrives at the house on Hope Spring Drive just before Cindy and Casey Anthony. And as they pull up, they get out, they rush in, he gets no information. There's the car in the garage. He notices himself that there is an overpowering smell, indescribable smell associated with that car. And as they all rush in the house, Cindy Anthony basically tells Lee to get information from your sister. She's not telling me anything. I want her to take me to Kaylee now. Shortly thereafter, Cindy Anthony makes her second 911 call, which you will hear. This time it goes to the Orange County Sheriff's Office. And she again talks about having her daughter arrested and mentions at that time a possible missing 3-year-old. The dispatcher, in trying to get some information, elicits from Cindy Anthony that her daughter, Casey, will not tell her where Kaylee is. So when patrol units of the Orange County Sheriff's Office are initially dispatched to this call, they're unsure whether or not this is a stolen vehicle call, is this some other theft call, is this a domestic incident? Because while Cindy Anthony is waiting, and it does take a while for the sheriff's office to arrive based on the priority levels that they give calls, Lee Anthony is talking to Casey Anthony, who is now in her room. And Lee Anthony is trying to convince Casey Anthony to just take Mom, Cindy, to Kaylee. What's the problem? This is going to happen anyway. Why are you doing this? To the point where Lee Anthony eventually engages in what can only be termed as a role-playing episode with his sister, where Lee Anthony pretends to be the police officer and says, "Miss Anthony, good evening. I see that you're having a problem here with your mother. Why don't we just resolve this? You take us to the child and everything will be fine. We'll all go home. We'll all be happy."
So that was opening statements from the Casey Anthony trial, which we are revisiting as a special here because of the holiday weekend. And we have a very special guest, Jeff Ashton, who was one of the prosecutors on the case. Jeff is joining us via Skype. You heard Jeff in the opening arguments. There was talk about that car, Casey Anthony's car, that was towed and discovered by her father, who got a notice in the mail, went to pick it up. And the moment that he got in there, he was a retired police officer, he said that it reeked of a dead body. Multiple people felt that it stunk. Something there stunk. Some people, even the mother, said it was the smell of like a decomposing body. Let me ask you a question. You said that you smelt that car yourself.
Yeah.
What does that smell like? Can you describe it? Is it describable?
It's hard really to describe what it smells like. I mean, I think we've all smelled, probably a dead animal here and there, but a dead human body just has a different smell. It almost, if anything, you might describe it as a sweeter smell in a way. It's really hard to describe, but if you've walked into a morgue or you've walked into where a dead body is, it's pretty hard to miss if you've ever smelled it.
And I'm assuming that's not the first time that you have smelled what you believe to be the decomposition of a body.
No, I've attended autopsies of decomposing bodies. I've been in places where people have been killed after the bodies. I've had a number of, not as much as a lot of the people that testified. They have a lot more experience than I do, but enough to know, what I think I'm smelling.
Is the smell always identical or very similar, or are there variations?
It's always very much the same in my experience. It doesn't really vary very much. So it all, I mean, and it's hard to really describe what it is, as I said, but you just kind of know it when you smell it. But it doesn't really vary that much as in my experience.
Because when I think about somebody saying that, oh, it smells like a dead body in here, and Cindy Anthony saying that, I'm assuming she's never smelled a dead body. So anybody could get into a place that stinks and say,
Sure.
oh, it smells like a dead body in here. I mean,
Well,
that's sort of a catchphrase for people. But there were people who smelled that odor who have actually smelled dead bodies, yourself included.
Right, and also remember that Cindy was a nurse also. So though we never really explored it with her because she eventually changed her opinion, I'm sure that she has had some experience in being around dead people as a nurse. But you're right. I mean, the people that were testifying all had extensive experience in that smell, including the guy at the tow yard who had an interesting background that he had actually had experience in, cars where where people had died, the bodies had been removed, and so he's had considerable experience in that as well. So, most people that have experienced that pretty much universally say, yeah, it's pretty recognizable.
As you said, Cindy Anthony switched and ended up assisting the defense. Was that surprising to you?
No, I actually was. I was surprised that Cindy didn't do it earlier. I mean, she really, in her statements in depositions, she really didn't shade facts to benefit Casey. She would shade interpretations, but as to the facts, she was pretty consistent. It wasn't until trial when she, in my opinion, just completely went off the rails and decided, I'm going to say whatever I have to say to help Casey, and in fact, lied about making a computer search, which we pretty conclusively proved she couldn't have made because she was at work. It is what it is.
That was bizarre because the search was for chloroform, and then she said that she was searching because her dogs were eating plants, but that would have been a search for chlorophyll.
Right, and that was, in deposition she had sort of, referenced it to say, well, maybe I was just doing this. But in trial, she said, no, that was my search. I was searching that. I remember it. And so, that was pretty lame, really. I don't think she really convinced anybody.
But when you talk about not really being surprised that she switched, I was surprised in the sense that when you hear from the prosecution in opening statements how persistent this grandmother was, how concerned she was day in and day out about where is her granddaughter, being sent basically on a wild goose chase by her daughter until she finally physically tracks her down, gets her in the car, and says, where is she? And she's frantic at this point to the extent that she calls the police and says that her daughter needs to be arrested. Yeah. So in that moment, her concern is with her granddaughter. And when they get that car, both of them fear the worst, that this smell is associated with the death of their granddaughter. So why didn't it surprise you then that she would reverse? And let me ask you this as a two-part question. Do you think the introduction of the death penalty made her start to rethink things and decide to support her daughter? Because obviously she didn't want her own daughter to be killed if convicted.
No, I mean, her defense of Casey, her flip from being the antagonist to Casey in yes. the first, basically before the arrest and the first few days after, that completely changed within a week of her arrest. I mean, she became Casey's biggest defender, in July of 2008. So I don't think it had anything to do with it. She was a mother protecting her cub, and I think that she convinced herself early on that it was impossible for Casey to have done anything to Kaylee, and will never ever really accept any responsibility that Casey might have. You
wrote in your book, "I've seen my fair share of liars, but never one quite like this." What did you mean by that with regard to Casey Anthony?
she has an amazing ability to look at you and maintain a demeanor of someone telling you the truth, even when her story is absolutely untenable, ridiculous, even disproven. Most people, will start out telling you a lie, and then as you chip away around the edges of the lie, they will show some evidence of sort of guilt or concession to the lie, and then they sort of feel trapped, and eventually the truth will come out, or something closer to the truth will come out. It is a truly amazing individual that can look at you and tell you that the sun comes out at night, and when you take them to the window at night and show them it's the moon, they'll go, "No, that's the sun. Don't you see that? That's the sun." They just maintain the lie with complete conviction, and that is a rare thing indeed.
All right, so now we are going to toss to some clips from the Casey Anthony trial. We're going to replay this very sensational trial. Jeff, stay with us, and we'll come back and ask you some more questions. Thanks so much.
With the name Zenaida Gonzalez. She doesn't know any of them. None of these Zenaida Gonzalez's on your driver's license pictures are my Zenaida Gonzalez. At this point, since Casey Anthony admitted to them that she lied during the process of this investigation, she was arrested. And at this point, the investigation, by necessity, takes two different paths. There is the investigation that continued into attempting to locate this person that Casey Anthony insisted had her daughter, this Zenaida Gonzalez. There were tips and phone calls and sightings of Caylee Anthony all across the country, on airplanes, in gas stations, all over the place. Tips that were followed up by members of the Orange County Sheriff's Office, the Florida Department of Law Enforcement, the Federal Bureau of Investigation, local police agencies in different states know Caylee Anthony and know Zenaida Gonzalez. That night, July 16th of 2008, with the permission of George and Cindy Anthony, the Orange County Sheriff's Office seized Casey Anthony's white Pontiac Sunfire. And you will hear testimony from crime scene technicians and ultimately the individuals who evaluated and analyzed evidence taken from that truck during the course of this trial. You will also hear that the trash bag that Simon Birch had thrown out of the car the day before, when George Anthony picked up the Sunfire at the Johnson Wrecker, was located in the dumpster when George Anthony went with a missing persons civilian investigator to find it. Was there something in that garbage that would help the Orange County Sheriff's Office find his granddaughter? George Anthony wanted to know. On Thursday, July 17th, the Orange County Sheriff's Office had one of their cadaver dogs, which you will hear during the course of this trial is a dog that is specially trained in detecting the scent of human remains. Do a sweep around the car. Deputy Jason Forgy, who has many years of experience in handling police canines and who has worked with his dog Garrus prior to Garrus's recent retirement for a long period of time, took the dog around the car, at which point Garrus alerted, give a trained final alert, which will be explained to you, on the trunk of the car as having the odor of human remains. Later that day, Garrus was taken to the Anthony residence, where, again, George and Cindy Anthony had given permission to the members of the Orange County Sheriff's Office to look in their yard to see if there was any evidence that would help them learn what happened to Kaylee. Where was Kaylee? And then again, in the backyard, near Kaylee's playhouse, Garrus alerted to the odor of human decomposition. Deputy Forgy had asked that another canine handler, this one from the Osceola County Sheriff's Office, Kristen Brewer, Sergeant Brewer, brought her cadaver dog to the Anthony home. And her cadaver dog also alerted to the odor of human decomposition near the playhouse in the Anthony's backyard. Now you hear that crime scene technicians dug up in the areas where the dogs alerted, did not find Kaylee. Evidence from the car was also preserved: hair, air samples, samples from the carpet lining the trunk, samples from the spare tire cover were cut and collected in tin cans by members of the Orange County Sheriff's Office. Samples of Casey Anthony's DNA, Lee Anthony's DNA, Cindy and George Anthony's DNA, and a hairbrush that was used.
You were listening to the opening statements from the Casey Anthony trial. They were talking about this car where Casey Anthony's car, it was towed. They found it. People thought that it smelled like a dead body. And then the prosecution ultimately introduced evidence that showed that there was chloroform in the trunk. There were hairs. One of them matched Kaylee Anthony. And even cadaver dogs positively identified the smell of a dead body, but the jury just didn't find this to be convincing enough. So now we're going to toss to Jose Baez's opening statements for the defense, and then we're going to come back and we're going to talk to prosecutor Jeff Ashton from the trial about Jose Baez, and he had some very select words to use about the defense in his new book, so we'll get right to that.
There's not one piece of evidence, one single thread of evidence that links Casey to Kaylee's body. She's dumb enough to leave her on the corner, but smart enough to outwit the FBI, Florida Department of Law Enforcement, Orange County Sheriff's Office, OPD, every law enforcement agency that the prosecution could muster up, every alphabet, the Secret Service. They even autopsied the snake. That's how desperate they were. Yes, there was a snake autopsy in this case. They searched for every single thing they could just to try and, well, it's quite obvious. A high-profile case. They had already made an arrest. Casey was arrested within 24 hours of being questioned, when there were clearly signs that something was not right with this girl. Something was just not right. They jumped the gun. They immediately made an arrest. We'll worry about the evidence later. And this is their evidence. This is how they get to where we are today. And this is how they ask you to take someone's life. As I mentioned, they don't even investigate Roy Kronk. They took everyone's phone records in this case, and they never asked for Mr. Kronk's phone records. We filed a motion to try and get him, and he objected. He didn't want anyone looking at his phone records or his cell tower information to determine where he was during these months. And the police didn't want to go looking for it either. They weren't about to do that. They didn't confiscate his computer. We took his deposition. We asked him, can you turn over your computer to the police? We'll think about it. They did nothing to investigate this matter. We found his son. We did. We went searching for him. And we found his son, who told us, my dad called me. They didn't go finding his son. My dad told me, watch, I'm going to be rich and famous. They didn't want looking, and you're going to notice that throughout this case. There's certain questions they don't want answered. And they're not going to go looking for them. But they'll line up to sit here and tell you about Casey Anthony and her bad behavior, her inappropriateness. She's not acting right. And that's what this case is about. She didn't act right. They don't ask why she didn't act right. Only that day 1, you heard it, day 2, day 3, day 4. It takes an elegant prosecutor to come up and do these things and get you emotionally riled up. But there's still no answers. The swimming pool incidents, the witnesses, the independent witnesses that will come and tell you about this, there's no getting around them. No getting around. These are people with no axe to grind. Now, I want to talk briefly about the investigation. I know I've touched on it, but you heard Ms. Jane Burdick tell you that on this day, on day 7, Casey Anthony was spotted on video at IKEA, or day 12, she was spotted at the Blockbuster or another place. Day 13, she's at Applebee's. Well, they sure did. They sure did do a thorough investigation on her. But yet they still can't come up with the evidence. This is Sergeant John Allen. He's one of the lead investigators in this case. He's about 5 feet from the road, and he's pointing at Kaylee's remains. But yet for 6 months, and all of that investigation, no one could find her. Look how close he is. She was placed there to be found, not to be hidden. But unfortunately, she was placed there by Mr. Kronk, and we will never know the answers. Now I'd like to talk about the car. Actually, before I go into the car, I want to finish up on Suburban Drive for a moment. There are 2 videos that you will see. There are plenty of witnesses who will come up and take the stand and talk to you about Suburban Drive and whether it was dry or whether it was not. And okay, maybe you can rely on them. Unfortunately, it wasn't until the defense raised the issue that she was placed thereafter that law enforcement wanted to shut that down. And that was in 2009. A year after is when they started going to these volunteers and asking them. That place was underwater, right? That place was underwater, right? And of course, all of these, everybody who's all riled up about this case and can't stand the inappropriate girl, all tell the police the same thing. Yeah, it was underwater. Yeah, it was underwater. But there are two videos that you will see. One from a woman named Gail St. John, the psychic dog handler that I told you about. Right around in early August, she has a video where she drives by the Anthony home, and you see all of the media trucks, and drives down towards and around the house, around the suburban drive, and says, "I'm having a feeling." They get out, and she has her dogs walk, and you'll see the woman walking about 30 feet. It's dry, but it's right around the area where Kaylee was found. And most interestingly, you'll hear about two private investigators who 1 month prior to Kaylee being found were out searching right at the area where Kaylee was found. What's interesting is these two private detectives were working for George and Cindy Anthony at the time. This may be a coincidence. Maybe. One of the private investigators, his name is Dominic Casey. He worked for the defense briefly, early on in the case, and then he went off to work for the Anthonys. Dominic Casey will tell you that he was on the phone with a psychic. Actually, first he tells everyone that he was investigating a tip, that when Casey was a young girl, she would hang out in the woods, and that he was out there investigating. And the police said, "Well, wait a minute. Casey's not a young girl anymore. She's 22 years old. Why would you look to see if that's a teenage hangout?" And then he changes the story and says, "Well, I was following up on a psychic tip." Well, it turns out this psychic was introduced to Dominic Casey by Cindy Anthony. It could be a coincidence. But on December 20th, when the sheriff's office decides to issue a search warrant of the Anthony home, one of the first words out of Cindy Anthony's mouth is, "I had people search that area, and the body wasn't there." That video, you will clearly see the water, the area is dry. Now I want to talk about the car. As I mentioned to you, actually, if you need a break, we can take a break. Your Honor?
Can't see you.
I can keep going.
Members of the jury, you need your break now? Okay, you can continue.
Go on then. All right. The car, as I told you, this car will be the subject of much debate. And you will hear evidence in this case that has never been admitted in a court of law throughout the United States. The air samples that Ms. Drain Burdick told you about. The hair has never been admitted in the state of Florida. The evidence that Ms. Drain Burdick told you about. As well as you're going to hear from a dog. While the dog can't get up there and testify, his handler is going to talk about the dog and what his dog allegedly said or reacted or alerted to. And we're going to get into that when we talk about the forensics. But one of the important things that I want to talk about is everyone talks about the smell of this car. And there's some things you don't know. Things you should know.
the subject of
That
much
was the opening statements from the Casey Anthony trial by the defense attorney, Jose Baez, and we're joined now by former prosecutor from that trial, Jeff Ashton. Jeff, you wrote a book recently where you really went after this defense team, specifically Jose Baez. You said that their defense was, quote, a crock of crap. You called him smarmy. You called him arrogant. This guy was doing his job from a legal perspective. Why did it get so personal between the two of you?
Well, the comments in the book were for purposes of sort of honestly admitting a bias. You know, I felt in writing the book it was important that when people were looking at how I evaluated him, that they understood I didn't like him. I didn't find him, during my time knowing him, to be a very honest or ethical person, and I didn't care for him, and that really hasn't changed. It's softened somewhat over the years, but I think when you're writing about somebody, it's only fair that you are honest about how you feel about them. So that was sort of the purpose of those comments in the book.
Casey Anthony originally blamed this on some fictional nanny who never existed.
Right.
And then the defense team had this theory about Kaylee drowning in the swimming pool. You said in the book that you think the defense team came to mirror Casey Anthony in the fact that she was a liar. Do you think that Casey told the defense team that Kaylee drowned, or do you think that the defense team made this up?
No, I think that actually this probably generated in the public, because when you look at it, the first mention of Kaylee drowning in the pool ever is through the media, because there's a point in one of the conversations between Cindy and Casey when Casey's in jail, where Cindy says to Casey something to the effect of, "Did you hear the latest theory?" And Casey says, "No." And Cindy says, "They're saying she drowned in the pool." And Casey shakes her head like that's the most ridiculous thing she ever heard, and just goes, "That figures." So I think that was started really by the media. And Casey, when she thought about it, went, "Hey, if my other thing doesn't work, this is pretty good." And it was developed that way. So I think really the media kind of came up with that, and Cindy, and not Cindy, but Casey eventually, and Jose ran with it.
All right, Jeff, we're going to go back now to when George Anthony, Casey's father, takes the stand. So we're going to watch a clip, and then we're going to come back and discuss it with you.
Sure.
With me waking up probably about the time that my wife had just left for work or going to work. Me getting up and having my normal cup of coffee. Just starting my day off a little bit early like I generally have. And having Kaylee come out and be able to spend some time with her.
Was that a normal course of events for you to have some morning time with Kaylee?
Oh, absolutely. I mean, there would be times that after she'd be in Casey's room with her, she would come out, and I'd take her first thing is to make sure that she would freshen herself up, brush her teeth, go use the facility or whatever she needed to do, because she was starting to do that, and just, maybe wash her face off and just say, "Hey, this is how you want to go with JoJo and get some cereal and things." So that was the start of our day. That was pretty much not an everyday occurrence, but it was pretty regular.
And is that how it went on this particular morning?
Oh, absolutely. It was a great morning to just have some fun together. Her and I act silly and dance around and watch a video or whatever it might be. So color.
What was her favorite video? Did she have a favorite?
Oh my gosh. Lady and the Tramp was a fantastic video for her to watch. 101 Dalmatians that she called Dalmatians. There was just a lot of different things that just captivated her that she loved. I wish I could remember more right now, but those two I know she watched quite frequently and enjoyed the most.
Now, this particular morning, do you recall when you first saw Casey?
Probably could have been about 9, 10 o'clock that morning, roughly right around there, her just getting up and getting her day started and just I can't remember exactly what she did to get ready that day for work or something like that. I know to me, it was a lot of precious time for me to spend with Kaylee. So whatever Casey could have done in that morning, been on the computer, whatever she was doing, I'd let her do her thing, because when you got time with your grandchild, your own child sometimes takes a back seat to that.
Okay. Was it just a normal morning? Anything out of the ordinary occurred? Anything different than the usual mornings that you had?
Not really anything I can really say that really stuck out at all. I just know that I was just so thankful to have time with Kaylee, talking to Casey. I'm sure we had a conversation about work or something. I don't remember the specifics about that aspect of it, but I do know that it was, when people talk about a typical or routine morning before they went off to work, it's probably just one of those typical times that we all sort of just take for granted sometimes.
All right. So did there come a time when Kaylee and Casey left the house that day?
That is something that is forever in my mind, that I can't forget that day, because that's the last day that I saw Kaylee and Casey together. I was watching a specific program on TV. It's on the Food Channel, on one of our local cable TVs. And this gentleman who has this show called Drive Up Diners and Dives, I've just been amazed by his stuff. I just like him going around. But what's really just amazing is, I remember the time because it was a commercial break on TV, and I remember Kaylee coming out from Casey's room, dressed in a nice little pink top. She had her blue jeans, little shorts on, her white sandals, pink socks, her white sunglasses, her hair pulled back, and she had a little backpack on. And I said, "Where are you going?" And she says, "Going with Mommy." And I said, "Oh, really?" I said, "Where are you going?" "I'm going to see Zanny." And I said, "Really? Great." I'm just excited. I'm just knowing that she's happy, and I can see excitement in her. And within a few minutes, Casey comes out and, dressed. And she says, "Dad, we're going to work. I might be home late, or I'll let you guys know I might be staying over."
Staying over where?
She said, probably Zanny's house, because Zanny was, I guess, lived somewhere close by, or she didn't want to come home too late. And plus Kaylee would be in bed between 8:30, probably 9 o'clock. And I said, okay, it's something that happened every once in a while. It wasn't an occurrence that occurred all the time. It could be every once in a great while. She would stay with a friend or stay at Zanny's house or something like that. So
up to this point in time, had you ever met Zanny?
No, I never met Zanny, never had any reason to, because I thought that's who Kaylee was seeing.
You told us about the conversation with Kaylee and with Casey. What happened?
I went out. I generally, like I did when I could see them when seeing Casey going off to work, and walking out with Kaylee and seeing Kaylee getting placed in the car, getting buckled in her car seat. Just a normal type stuff. And I did. I'd blow her a kiss and say, "Jojo, I'll see you later," and she'd blow a kiss back and give Casey a hug. And just told her, drive safe, make sure you come home, not too late. Just normal father, grandfather type things to do.
And did you see them leave in a vehicle?
They left in Casey's car, which is a Pontiac Sunfire.
That's a white Pontiac Sunfire?
Yes.
Did you ever see Kaylee again?
I've never seen Kaylee since June 16th. I haven't seen her since.
Now, Mr. Anthony, I need to ask you some questions about something else. Have you ever sexually molested your daughter, Casey Anthony?
No, sir.
Have you ever committed any sexually inappropriate act with or in the presence of your daughter, Casey Anthony?
No, sir.
Were you present in your home when Kaylee Anthony died?
No, and when I heard that today, it hurt really bad. Because if I would have known something would have happened to Kaylee, we wouldn't be here today.
Now, let me just ask you a couple of questions. When you were a law enforcement officer, were you trained in CPR?
Yes, sir.
Is there any extent that you would not have gone to save Kaylee's life?
I would have done everything possible, humanly possible, to save my granddaughter if what was stated prior would have happened. I would have done anything I would to save my granddaughter.
Did you dispose of the body of your granddaughter?
No, I did not.
Did you obtain duct tape from your shed or garage and place it over the nose and mouth of Caylee Anthony?
No, I did not.
Did you have any?
And that was George Anthony, Casey Anthony's father, being questioned on the stand in direct examination by prosecutor Jeff Ashton, who we have with us today. George, how did you sorry, I called you George. Jeff, how did you think that George came off on the stand?
I thought he did pretty well. On cross-examination, you know, he was very his dislike of Jose Baez came out on cross-examination, and you know, I wish he'd been a little bit cooler about that. But aside from that, I thought he was fine.
I have to tell you, I mean, he's talking about watching movies with this little girl, singing and dancing, and she calls him JoJo, but he's not showing any emotion at first. Eventually, he does break down, and that he sort of becomes relatable and convincing, but I found him to be very hokey, contrived, a bit artificial. Maybe that's just his personality, but he wasn't generally well-liked by people in the public, and even the jurors had comments after. Did he hurt your case, Jeff?
I don't think he hurt the case. I mean, that's just him. He's kind of a hokey is one word. Even when you would see him in video conversations with Casey in jail, he was the same kind of thing. He was just like this sort of overly emotional marshmallow kind of a guy. You know, he was just, but that's how he always was. Even in conversations with us, he was always that way. You know, his story of his last day with Caylee, I've always thought was probably true in the sense that he wasn't lying about anything, but I think emotionally he kind of added a lot of detail to it that I don't know that he actually remembered. I always wondered if, you know, if he really remembered it that clearly, or if he had sort of emotionally added, you know, context and texture to the story. You know, particularly the thing about it just occurred to me as I'm watching it about Caylee saying, "I'm going to see Zanny." Well, we know Zanny didn't exist, so, you know, was Caylee really say that, or did he sort of, you know, did his memory add that to kind of explain why he did what he did? I don't know.
Yeah, I have to tell you, I had the opposite impression. I didn't feel that he was over-emotional. I felt that he was unemotional, and he really didn't do it for me. Listen, when Jose Baez was cross-examining him, the man could not answer a question directly. He had these roundabout answers. Even the simplest of questions, he had this whole long, drawn-out, very unconventional answer. Did you coach him at all on how to answer the questions? Because that was brought up.
Only just to the extent of saying, and I told, you know, I know you don't like Jose, but just answer the questions. And I had the same reaction when I was sitting there. You know, I kept saying to myself, just answer the damn question. You know, stop playing. You know, you're not smarter than any of us, so you're not going to be able to outthink anybody. The problem was he just despised Jose Baez, absolutely despised him. And he couldn't hide it. And you're right. He just, you know, tried to get too cute. And that was my response too to him, was just answer the damn questions. But, you know, you take your witnesses as you find them. So not much you can do.
Yeah, I mean, he sort of presented himself as this very unrelatable, untraditional guy, like out of a 1950s sitcom, where he just seemed uncomfortable with everything that was going on, and some of the jurors felt that he wasn't believable. I mean, when Jose Baez is cross-examining him in the sense that that he's asking him how he couldn't recognize that Casey Anthony was pregnant, 6 months pregnant, that he lives with her and he doesn't notice that she's pregnant, that he doesn't ask who the father is until he's in the delivery room or somewhere around there, and that him and Cindy are allowing the granddaughter to go visit this non-existent nanny allegedly for 2 years, and there's no phone number to contact her, and she's being dropped off every day. I mean, this all just sounded very unbelievable.
Well, there's a lot of history that didn't come out in the trial, in the sense of there was a point at which George started to really question Casey's credibility. And in fact, there was an incident, and again, this is not something that would have been relevant at the trial, so we didn't try to bring it in, but there was an incident about a year or so before that, or maybe 2, where, you know, Casey had been telling a story about working in a particular place. And George actually went there to track her down and found out that it was a lie. And, you know, he basically came back, confronted her with the lie, and Cindy, you know, shot him down. And it was a point when their relationship was very, very much in question. In fact, there was a point when they were separated. And though Cindy will deny it, we always suspected that a lot of that was because of George was trying to be the detective and to actually question what Casey was saying. My theory is that George just got beaten down over time, to the point where he wasn't going to question anything that Casey said because Cindy wouldn't allow it. And so I think that's partly the explanation. But, you know, we never got a true picture of the family dynamic of the Anthony household. I mean, we would get one version from Cindy's coworkers that she would talk to candidly at the time it was going on about the problems with Casey and the problems with George. But to hear Cindy tell it now, it was all roses. So, you know, that's an aspect that we never really totally understood.
I have to say, with all the convincing evidence that I felt that you had, I felt that George hurt in the sense that the jury, perhaps, as you said earlier, was looking for another explanation, one that they hadn't heard already. And they got that from Jose, and that really related to George and his potential sexual abuse of Casey Anthony, and kind of looking for an explanation as to why is this girl such a liar? Did something happen during her upbringing? Was she hurt? Was she abused in some way? Were you surprised when that theory came out in the opening statements? Did you know that that was going to be the defense's theory?
Well, we knew that that was at least what Casey was saying, because we had, you know, deposed the psychologist and the psychiatrist. So we knew that that would be part of it. All of us, including most commentators, were shocked by the level of detail that Jose put into the opening, because with that level of detail, Casey had to testify. And most of us, you know, were like, there's no way she's going to testify. So, because most of us, you know, most lawyers would not give that kind of opening statement without an expectation of being able to prove at least most of it. And most juries, quite frankly, would expect it. You know, most juries, if a defense attorney says this incredible story in opening, they're going to expect some proof of it. And none was given, ever. So, you know, in that sense, the opening was bad. It really was. It wasn't a good opening. For this jury, it worked, but it wasn't a good opening. No competent defense attorney would have given an opening with that level of detail. And also, more importantly, I knew what Casey's actual story was, and I knew that the opening was not what Casey was going to say, unless she changed her story, which, of course, Casey could change it 1,000 times. So, you know, that was, as I watched it again, it wasn't a good opening.
And, of course, Casey never took this stand. Do you think if she had taken this stand, you could have won this case?
With this jury, no.
Really?
think with
Still
this
not.
jury,
That's interesting.
yeah, no, with this jury, there was nothing that we could do. This jury was not going to convict Casey Anthony, no matter what we gave them.
Interesting point. So now I just want to ask you, Jeff, a couple quick questions from our chat room bloggers. They want to know, this is the first question, do you regret laughing during Baez's closing?
Yeah.
That
I
became
do.
very controversial, Jeff.
I do. It was one of those, almost involuntary reflexes of the exhaustion of a 6-8 week trial. But yeah, of course, I shouldn't have done that. I said that at the time.
They wanted to know if there was a strategy to your laughing, if the angle of your face was positioned in a way so just the jurors could see you and not the judge, and he had to go back and look at the tape.
No, I actually was, I was covering my mouth so that no one could see me. And that was just sort of I just sort of put my hand up like this. But no, it wasn't. It wasn't anything deliberate. It was just, you're exhausted and you hear something that just is so absolutely ridiculous that you just kind of get captured in the moment. So.
Two more quick questions. Did you ever consider charging Cindy with perjury? Someone would like to know.
Well, I left the state attorney's office, shortly after the trial, so I wouldn't have been in a position to do that at all. But even if I had been, no, I wouldn't have charged her with perjury. It wouldn't have, that case needed to be over. Everyone needed to move on, and her perjury it wasn't effective. I wouldn't have, no.
Did you see the interview Casey Anthony did a couple of months ago? People would like to know what you think of it.
I find it absolutely amazing that after all these years, Casey Anthony has so little curiosity about what happened to her daughter. I mean, when you watch the interview, it's like, well, I don't really know what happened to her, but I sleep just fine. So, that to me was a classic Casey Anthony interview. She didn't actually tell anything. She did not reveal any information. She alluded to past stories that she's told, but that aren't really consistent with what she's saying now. So it was just more Casey Anthony BS.
Well, Jeff, thank you so much for joining us. I really appreciate it. And your book is called Imperfect Murder, and we hope to see you again soon. Thank you so much.
It's Imperfect Justice.
Oh, I'm sorry. I'm sorry about that. Imperfect Justice. And I love your state's attorney shirt. You really know how to dress.
Oh,
You'd be a great advertiser.
Okay.
All right, take care. Now we're going to switch gears to the Holly Bobo trial. This is a stunning, beautiful young woman. She was a nursing student in Tennessee, and she goes missing. And she's found 3 years after she goes missing. It's amazing to me that it took them 3 years to find this young woman just a couple of miles from her home. Actually, maybe it was a couple of 100 feet from her home, after her brother sees her disappear into the woods with a man wearing camouflage, and it takes 3 years. So finally, here we are. There's a prime suspect. His name is Zachary Adams. His trial is coming up, 6 years in the making.
So that, having committed the offense of especially aggravated kidnapping in violation of 13-305, do you understand what you have been charged with?
Yes, sir.
Do you understand the nature of that charge?
Yes, sir.
Do you waive the formal reading of that? Ms. Thompson?
Yes, Your Honor.
All right. Ms. Thompson?
Yes, Your Honor.
All right. As to the third count, you're charged along with 2 co-defendants with having committed the offense of especially aggravated kidnapping in violation of 39-13-305. Do you understand what you have been charged and the nature of that charge?
Yes, sir.
Do you waive the formal reading of that indictment?
Yes, Your Honor.
Count 4, you are charged along with co-defendants with having committed the offense. First-degree murder. It's a felony murder once again that you did unlawfully and with the intent to commit rape, kill Holly Lynn Bobo in the perpetration or the attempt to perpetrate rape, thereby committing the offense of first-degree murder in violation of 39-13-202. Do you understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, count 5. You're charged with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand count?
Yes, sir.
Do you waive the formal reading?
Yes, Your Honor.
All right. Count 6. You're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you're charged with on that count?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
To that, with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
Count 8. You're charged with having committed the offense of murder in the first degree, premeditated killing of Holly Lynn Bobo in violation of Tennessee Code Annotated 39-13-202. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, that completes the arraignment process.
And he enters the plea of not guilty.
Yeah, let the record so reflect a plea of not guilty is entered. It's my intent to attempt to design at some point a scheduling order. In speaking with the attorneys, discovery will be an ongoing process. However, state's attorneys have indicated that they're ready to turn over all discovery within 30 days. And I've given them some extra latitude. They said they've actually got it ready and can be done within a week. I will consider that to be the attorney's work product when they receive it. I expect you to share it with your defendant in consultation, but I don't know that outside sources should necessarily benefit from your discovery. Okay?
Yes, Your Honor.
All right. What other matters do we want to touch on Mr. Zachary Adams?
I would like to say for the record, just in terms of the report that was on Channel 5 last week, while I have been provided with the photographs that they referred to in the report, I have not been provided with the affidavit to the best of my knowledge, and I've been through that discovery, and I've had multiple people go through that discovery. I've not been provided with the affidavit that they referred to, and I have not been provided with the TBI lab report that confirmed that the blood was Holly Bobo's. So I don't even have that information. I would like it, and hopefully I will get it soon, but I don't believe I have that information.
They will get you the discovery. She said it is indexed. It's indexed. She will furnish a copy, the same copy to each attorney. In that material are co-defendant statements, if there are any. There's also jinx material, which technically they're not required to provide until after that person testifies, but they might very well be aware of my history as possible so as to not delay a trial.
Yes.
And on top of that, Your Honor, I had an opportunity to speak with Ms. Thompson this morning and have made ourselves available in that we've agreed. I've offered to, once the discovery is given, to meet with her, answer any questions she has about, what we are providing, point her in a particular direction if she has questions.
I think open discovery, I think it facilitates the case moving and is beneficial for all parties, both the state and the defendant.
When she gets her co-counsel in line, it's probably, that would be the time to do it, but the offer remains on the table.
Well, as I said, one of my primary objectives is to preserve the defendant's right to a fair trial as well as the state's right to a fair trial. And I think open discovery will actually aid all parties concerned.
And there was an objection that I had expressed at prior hearings, and the state assures me that open discovery doesn't mean just come and look and see what we have, but they will file a record with the court so we can be clear as to what I've been provided.
We're going to
file it directly with me.
Going to file a duplicate copy now, I know, directly with Your Honor.
That way, as we run into discovery disputes, we'll know where we're going, okay?
At this point, Your Honor, in light of the fact that the state has just filed this notice of aggravating circumstances on the new charges, we had several motions that were before the court, but I don't believe that now is the proper time to have hearing on those. We'd like to continue those matters until we have an opportunity to.
At some point, we'll be proceeding totally under the new indictment, and I would assume the old ones because everything's covered in the new one. But we want to preserve your right to present those motions if you wish or desire.
Can we say that those motions, any motion that I've filed in the other case, will automatically transfer to the new case? The discovery?
It is fine with us. That's the only reason that I've delayed minutes, was because I frankly didn't want the defense.
Let's not gnaw across yet.
Yes.
Okay. I don't need to file a new motion for discovery, and I had a motion regarding Brady material. I don't need to refile those duplicate motions in this.
Unless you find deficiencies in the discovery,
okay.
At which point you can file anything to bring the matters to the court's attention that you feel are appropriate.
But
then the circumstances with filing the notice have changed dramatically.
Yes.
And I had wanted to find out how long you folks felt Oceans. We've got a whole new situation. So I'm not going to be able to move at breakneck speed as I had hoped. I think in fairness to all parties, when you're talking about the ultimate punishment, then there's a heightened due process. And I want the attorneys to have an adequate time to file their motions. But I'm going to suggest in 180 days. So let's start looking at that framework, okay?
Yes.
And that will be as to each defendant.
Yes.
Okay? And we will try to have new counsel on board probably by the end of this week. Okay?
Yes.
Matter of fact, you might notify that person and make sure, because this is going to be very burdensome. You already know that.
He knows.
Okay.
He's been involved. He's aware of the nature of the case. He's
Okay.
actually met Mr. Adams, and he's prepared.
Okay. Is there anything you don't understand at this point, Mr. Adams?
No, sir.
All right. Let's dismiss Mr. Zachary Rye Adams.
Yes.
Bring in Jason Wayne Autry. Just at the podium there. You are Jason Wayne Autry?
Yes, sir.
Mr. Autry, we're here today to arraign you on a new indictment. This is essentially something that will take place of the old indictment. There might be additional charges on this that were not contained in the old indictment, but you have been indicted along with Zachary Rye Adams and John Dillon Adams in one single charging instrument. We're here today to arraign you on these charges and then take up any other matters that you folks feel are appropriate. You are charged in case 15 CR 30. In the first count, you're charged with what is known as felony murder. It charges.
So that was the arraignment of Zachary Adams. He's the prime suspect in the murder of Holly Bobo. Now, this guy has a long, long criminal history. He's an admitted meth addict, a thief. The man shot his own mother in the foot with a Glock. Then he threatened to kill his grandmother and his grandfather. They all had to get orders of protection against him. He has stolen things, small things, large things. He went on a stealing spree where he stole an ATV, he stole firearms with ammunition, a chainsaw, torches, a boat, a trailer, a deer stand, a bug zapper. What the heck is this guy doing with all that? He's headed to do something in the woods, and I'm telling you, he's not about to start a summer camp. So we're going to bring Nick Barris in right now. He's a local reporter at the CBS affiliate in Nashville, Tennessee, and he's been covering this trial that's about to start in lead up. It's 6 years in the making, Nick. There's a lot of eagerness to see somebody held accountable for the murder of this young nursing student. Tell us what the feel is in the community there, because it's been a highly publicized case.
Yeah, highly publicized. Good morning, Amy. The feel here is it's about time, all right? This dates back to 2011, and for a long period of time, it was one of the priority cases for the Tennessee Bureau of Investigation, and they came up with nothing. There was a ton of pressure on them to come up with something, and they couldn't. There was a great frustration. The family of Holly Bobo has been incredibly gracious and patient through all this. There's a movement, Justice for Holly, hoping that would come about. And then finally, just a couple years back, they finally get the evidence. And what all that evidence is, we're not all that sure at this point, though we do have some ideas. And they ended up, charging 3 individuals with her kidnapping, rape, and murder, and it's a capital case.
So they charged 6 people at one point, and then they dropped the charges against 2. Right. They charged 3. Mm-hmm. One person of the 6 committed suicide.
That's right.
Allegedly. That's what it looked like, at least. He was hanging from a hotel room in Florida after he had struck a deal to cooperate with the prosecutors, and then they wanted to take away that immunity agreement because they said he wasn't cooperating. And so he possibly could have been facing an indictment, and then he was found hanging from the ceiling. So now we're faced with 3 people being charged.
That's exactly right. Part of the
prime guy,
too,
right?
And when we talked about frustration of waiting this long, right when this all happened, there was an election in Decatur County, and the sitting district attorney was beat. And he was in the middle of the investigation, the prosecution at that point as they were building the case. He leaves, a new guy gets in there. This guy doesn't get along with the Tennessee Bureau of Investigation. He steps aside, and now we've got this special prosecutor out of Memphis, which is one reason it is, you're right. It's very confusing. There have been a lot of faces that have come in, but they finally zeroed in. Right now, the primary is Zach Adams, but of course, Jason Autry and Dylan Adams, his brother, are also charged in this case, but Zach is on trial first.
That's right. And you were talking about Matthew Stowe, who was elected, and he said he thought that he was elected actually because there was so much frustration with this case, that he was elected specifically related to the case because people wanted to see some movement on it.
I think that's one argument you could think, but then when the investigations and they started getting together and the TBI heading all this up, there were problems behind closed doors with the direction and the way they were going about doing this. And there was a break between the DA and the TBI. And that was a big problem that created more delays and made people wonder where we're going on all this. Now, of course, he has stepped aside, Stowe has, and they had to bring in this special prosecutor. Then later in the game, they decide to seek the death penalty. And when they do that, they have to bring on these death penalty certified attorneys, which slowed everything up. It's taken a lot of time to get to this point, but people are very ready for this trial to begin on Monday.
And Stowe had accused the Tennessee Bureau of Investigations of leaking information, being slow to develop information and possibly even covering up some information. And as you said, that's when they stepped down. Now, there were other controversies too surrounding the case, just the procedural elements of the case. The defense was fighting, and still potentially is fighting, to get their hands on the evidence. There was a point where they were making motions to dismiss, saying that they couldn't get the evidence from the prosecution.
Well, and part of the problem, and I dealt with several of these attorneys, some of whom have changed faces now. There is so much. I was telling you before we went on air that there is an entire room at the TBI headquarters here in Nashville dedicated to evidence collected in the Bobo case. I mean, we're talking hundreds of thousands of pages of documents. We don't know, some physical evidence, perhaps all kinds of tape recordings. Just an enormous amount of evidence and items that have been collected. Then you couple that with the fact that there have been changes in the prosecution and those involved in the prosecution. It took some time. I don't know that I saw any deliberate effort to keep this information from the defense, but I think they had a legit complaint that it took so much time for them to get this information, and then they just wanted to make sure they had enough time to go over it all. And I think Jennifer Thompson, Zach's primary attorney now, would tell you that she still needs more time, but the judges said, no, enough time has passed, time to go to trial. And you'll note that just last month, I think the prosecution's still building its case. They announced the discovery of a gun. This comes out of nowhere. A gun now that's going to be added as evidence. We don't know if it's the murder weapon. We don't know if this gun is somehow linked to Zach Adams, though you assume it must be. But that's something that just was found within the last month and has been added to discovery.
Yes, and also Jennifer Thompson, the defense attorney for Zach Adams, moved to have the judge recused from the case, and then in a bizarre twist, which happens quite often in court, which I think should not happen, is the judge had to rule on that motion to dismiss himself, which of course he didn't do. But we're going to listen right now to portions of that recusal hearing and some of the reasons why she wanted him dismissed, one of which is him allegedly saying that the defense should be beating down the door of the prosecution to make a plea deal for Zach Adams.
In the judicial system. And because the judge, the court in this case, had extrajudicial communication with the state when the defense was not present, then that in and of itself, Your Honor, would be a reason to disqualify the court. The second reason would be that the court said, based on what, just the very statement, based on what I have been, based on new developments in the case and what the court has been led to believe occurred, like I said 3 months ago, if I were the defense, I'd be beating down the door at 101 Poplar to see if I can get something reached to resolve the case. And Your Honor, based on that statement, that the fact that it's not simply encouraging the parties to negotiate in settlement discussions, it is specifically giving an opinion that if the court were the defense attorney, and it also says based on what the court has been led to believe. So therefore, the court has some information. Based on that information, if the court were a defense attorney in this case, the court would certainly think that it's appropriate and necessary for Mr. Adams to be working out a plea deal in this case. And that's clear to the public. And the standard in this case, the standard that the court uses, is not what does the court know or what the court believes, but when you're looking specifically at the standard regarding a court's recusal, then the standard is what would an ordinary person in the public believe after seeing that statement. And it's clear that an ordinary person in the public is going to believe if the judge has said, you better be beating on the door of the prosecutor's office, and it's clear that the court believes that it is necessary, prudent, and probably...
Stop me just a second. As an officer of the court, how many times have I told you that it was not too early for negotiations? I've told every single attorney in this room, they were present. Every time we've been in court, to my knowledge, I have tried to encourage the parties to negotiate towards some type of reasonable settlement so that this case may be put to rest. Will you agree as an officer of the court that I have done that?
Certainly, yes. But when the court phrased it that way, it put a chill onto the defense team because it came across as though the court had made up its mind. The court thinks Mr. Adams is guilty, and the court thinks he should be working out a plea deal. And the second issue that I did raise in the motion for recusal is that the court has continually brought up the fact that there's not going to be a continuance of the April. Nobody at this point had asked for a continuance. Recently, I think we filed a motion that was ruled on in November, but nobody had asked for a continuance, and that also comes across that the court has already decided that issue as to whether or not it would grant a continuance, and that there's not going to be any reason for an exception. And again, having prejudged an issue, Your Honor, and expressed an opinion on that issue, then I think that's a second reason that the court should recuse itself. So there's three reasons, and when you look at the law and what the law supports in a case like this, that because the court has had ex parte communication, and even though it may have been slight, it's still the state expressed their concern about the conflict of interest issue, and they did more than just simply say, we need a hearing. They said, we're concerned, and we are, as soon as they add an and we are especially concerned about trying to enter into plea negotiations. That gives their opinion. They have communicated something to the court besides simply saying that they want a date to hear something on the record, or they need a date for a hearing. And because of that, Your Honor, we say that under the law, and the law is clear, that under the law in this case, and there's a heightened due process responsibility when a person is facing the death penalty. And there's case law that says that too, that in a death penalty case they have a heightened due process responsibility to have a court that is unbiased and that appears unbiased. And so based on those three reasons, Your Honor, we're asking that the court recuse itself.
I'll be brief, Your Honor, to address Ms. Thompson's concerns. One, about any extrajudicial statements that were made. Your Honor, I've been on the case over 2 years. From the beginning, you not only encouraged us to call you if there was a scheduling issue, you actually explained that you're out of your office quite frequently, being a circuit judge, and that everyone has your cell number. You gave it to us in chambers, all of the attorneys. When I realized that I needed a telecom or something perhaps set on this date, I did pick up the telephone. I called you. I asked if I could schedule a teleconference. And I don't know in what world Ms. Thompson practices in, but I've never set a hearing with the judge without telling him or her what the hearing was to be about. And I said I have a concern about Mr. Evans' representation of Zach Adams. That's as far as it got. And you correctly...
Would you agree that the total time of that telephone conference was less than 5 minutes?
I disagree. I think it was less than 2 minutes.
Okay. And part of that was dead time because I told you I was in a restaurant.
Yes, you went out to the car.
And total sum and substance, less than 2 minutes.
Yes, sir. Not only have I never, ever discussed the substance of the case against Zach Adams with Your Honor, I've never made statements about the case against Dylan Adams, nor Jason Autry to Your Honor. Ms. Thompson made statements that you must have some information about what other defendants would say or wouldn't say. I can't speak to that because I haven't, and no one on the prosecution team has had those discussions with you. There were no extrajudicial statements made by me to you. There was zero discussion about the substance of anything other than we had received a notice of appearance representation from Luke Evans. I contacted the defense, all of them, including Luke Evans, explained my concerns. We've attached the email string to a filing this morning between myself and the defense, Luke Evans' response, and then Paul Hagerman's response there too. When that didn't work out, I called for a teleconference, which is what Your Honor has instructed all counsel to do, and based on the statements you've made from the bench this morning, others have apparently taken advantage of that much more so than the state. I needed to voice the very real concern that we had about a conflict. I won't get into that now because I know we're talking about recusal. I think the second issue that Ms. was negotiations. I've been on the case a little more than 2 years, from day one.
So that was a hearing where the defense tried to have the judge removed, and obviously he didn't remove himself. I'm joined by Nick Barris, who's a local reporter with News Channel 5. The problem here, Nick, is going to be evidence, is it not? There's some circumstantial evidence. It doesn't seem like a lot. There's one piece of critical missing evidence, if it even exists. There's talk of this tape that Zachary Adams may have taped the rape of Holly Bobo, potentially the killing of Holly Bobo. That tape has been reported by multiple people. Nobody ever found it. Investigators scoured more than 20 phones. That to me seems like the key to this case. If they could find that tape, if it exists, it's got the answers.
Well, sure. I mean, if that existed, then yeah, absolutely, that would be crucial. Now, we looked into that as well, and there is no evidence to our knowledge, and maybe they're keeping it quiet if they found something. I can't imagine that. It would have been in discovery. And I do not believe that tape exists. And when we did our investigation into whether that tape was there, we came across, some referrals to a sex-type tape that actually had nothing to do with Holly Bobo. It was involving another woman. So I do not think that tape exists. So in the absence of that tape, the question is, what kind of DNA is there? Zach Adams' attorney, Jennifer Thompson, has told me that prosecutors and in discovery, there's no evidence of a DNA link between her client and Holly Bobo. So what's the evidence? What's the evidence in this case? I know that they have given immunity ordeals to 5 people to testify against Zach Adams, and I assume 2 of them are his co-defendants, probably Jason Autry and his brother Dylan. But they've got credibility problems, right, Amy?
Yeah, absolutely. So Dylan initially confessed to the police, said that he saw Holly Bobo with his brother at his brother's home on that day, that Jason Autry was there, who's a friend of these brothers. And then later he rolled back and he said that that confession was coerced. So obviously there are credibility problems there. Jason Autry has an incentive to strike a plea deal as well after years of denying any involvement. A motion by Zach Adams' attorney then says that Jason Autry all of the sudden admitted to everything. Let's go over some more evidence though. There's a jailhouse, for lack of a better term, rat. And the reason why I call him a rat is because I don't like when these jailhouse cellmates cozy up to the person who comes in, because obviously they have a incentive to get a reduction in sentence. So maybe sometimes they're telling the truth, sometimes they're not. I mean, we don't really know. But this guy, fascinatingly enough, sent you a letter, an unsolicited letter. And what did he tell you in that letter?
Yeah, it's very interesting. His name is Benjamin Lee Hendricks, and he was incarcerated with Zach at the Williamson County Jail. He sent me a letter basically telling me that Zach went into detail about what it was and admitted to killing Holly Bobo. Okay, that's what he said. Now, we get things like this, and I agree with you. I mean, inmates, and he, by the way, I forget exactly the charge Hendricks was in there on, but it wasn't some super heavy charge that was going to put him away for a long time where he needed a deal. In this case, not long after Hendricks contacted me and we ran the story, I was going to do a follow with him and he disappeared. And next thing I know, I'm being contacted by the TBI about information with the letter and the like. So apparently they got on the radar with him and have talked to him. TBI has never told me anything, but I'm fairly sure Hendricks is going to testify about what Adams told him behind bars. And we have the letter, which is essentially that Adams more or less confessed to being involved with the murder of Holly Bobo. So we'll probably hear from him.
So we have a lot of circumstantial testimony from shady characters, basically.
Yes. Now, as far as physical evidence, they did find Holly Bobo's remains. How much of it? It wasn't like a full skeleton. We understand they do have her skull. We don't know the nature of her death. We don't know the nature of the rest of those remains. There have been some reports that they did find a footprint of a similar type of croc that Zach Adams wore at the time outside the home when Holly Bobo was abducted. We understand that there may have been a discovery of Holly Bobo's hair in Zach Adams' carpet in a closet in his home after she was abducted. So there's that type, but beyond that, it's not clear that they have any really strong physical evidence.
Yeah, I mean, there were some questions about IDing the brothers. How did they even come upon Dylan to get this confession? Nobody really knows how they zeroed in on these two.
That's great. Great question. We don't know that. I think based on at the beginning of this segment, you talked about the priors that Zach Adams had, and he has a long, long list. I think when Holly Bobo initially disappeared and for the few years while they were looking for suspects, I'm pretty sure Zach Adams' name was on the list as a potential based on his back history. Now, what finally brought them to them, I'm thinking it has to be someone who came forward and said they saw something or for whatever reason was feeling pressure and being questioned and then broke. And it may have been Dylan that did the first thing because all three of these individuals were doing time for other crimes and were being questioned a lot behind bars. And Dylan, by most observations, I don't know how to describe it, he's a little bit slow. And I think it may have started with him.
We have a type of Brendan Dassey potential confession on our hands because the defense could certainly go that route. But this Zach Adams, I mean, nobody doubts, even his own family, that he is bad news. But is he a rapist and is he a killer? That's really what this trial will come down to. Does the evidence support that? Now, you mentioned there's a gun all of a sudden. Right. But it's unclear whether they can connect that gun or have connected that gun to this murder. And tell me a little bit about that gun, and then we're going to go listen to the defense trying to buy themselves more time to get an examination of this gun.
Yeah, exactly. The defense wanted more time because they just sprang the gun's discovery on them 1 month ago. Just about a month ago, they found it. We don't know. The gun's kind of a mystery. It took everyone by surprise when it was mentioned that all of a sudden a gun's been discovered. As I told you, the reports are that Holly was kidnapped, raped, and then murdered with a gunshot to the head. That was some of what some of the witnesses have testified to, okay? And so the question is there a bullet hole in the skull they recovered? And is this gun with ballistics somehow able to match? We don't know. That's all conjecture and theory right now. Are they going to be able to link the gun to Zach Adams? You would assume somehow, some way they are. Is this a murder weapon? Do we even know that she died by being shot? A lot of questions in that regard. And because of that, that's one reason Jennifer Thompson, when this was sprung on her, asked for more time, but that was over a month ago. The judge, I think, deemed it that there was enough time. You'll hear this in the clip. So we'll be following all that. And I may leave you after this, but I'll be glad to talk to you more, Amy, down the road as we go on this. And again, you guys will be following this. We are going to be the pool camera in the courtroom when this starts Monday. And it's going to be newschannel5.com. And please, folks, follow me for some of this on Nick Barris at NC5 on Facebook. But just a lot to come on this, and I'll be glad to get with you again, Amy.
Thank you so much, Nick. You're fantastic, and please keep us updated. Thanks for joining me.
You bet.
And now we're going to toss to that clip where the defense tries to buy more time, delay this trial, even though it's been delayed for 6 years, because they want to examine the gun. So let's take a listen to that.
Your Honor, at this point, I foresee us, or I guess at this time, I'd like to make an oral motion for a continuance. I recognize the court's been very clear that it intends to try this case when it's already been set, but there is a gun that the state has now, I guess, after 6 years, they've dug up a gun somewhere that it's my understanding they're going to say the gun is going to be. And my understanding is that as soon as they got that, you were forwarded this information. Well, we were forwarded a picture of the gun and told what the caliber was. We don't have any reports on it. We haven't been able to inspect it. We are anticipating that we're going to want to try to get an expert after we get, if they're having the gun tested at a lab, we anticipate that we're going to want to try to get an expert. We've contacted, or we've gotten some names of some experts that we're planning to try to contact. But at this point, we don't have the gun, and we haven't had an opportunity to inspect it. And so I think because that's going to be such an important factor now in this case, it's my understanding they've only had it since about Memorial Day. So, but all we've received are 3 pictures of the gun and an email telling us what the caliber is. We don't know what the serial number is or what the make and model of the gun is, and I think all that's going to be very important.
They'll furnish that information. You can move to exclude if you feel it's appropriate. Motion to continue is overruled.
And
Yes.
they also say that they're welcome to come and look at it anytime they want. Nobody's made the request. The day we found the gun, the information was forwarded to.
Saw the picture. Somebody, I think she sent them to me, or you did, or someone.
I had actually notified the defense counsel before that.
Okay. So motion continues overruled. I've got a jury trial in Benton on Tuesday, which I will continue in deference to this case if there's something that we need to. I want to avoid any disputes. So I'm saying I can take up discovery matters, whatever we need to do. Not available next Wednesday. I can be available next Thursday or Friday. The following week, I can be available July 3rd, and then after that, we're a little close to trial. Potentially, I could be available the 5th. That's the day before we finish our jury selection. I will let the press know there will be no cameras on the 6th. That's pursuant to the rule. We'll be totally involved in jury selection at that time, addressing the issues that have not already been addressed during the individual voir dire of these people. They'll be coming back in on the 6th. I anticipate that when we get the jury selected on that day, that I will excuse them with admonitions to, once again, not view or listen to any news reports or anything else. I will swear the officers that will be guarding the jury that day so that they can report to Pickwick Landing State Park Inn on Monday so that we can start the trial. They'll be sequestered from that point. We'll start the trial promptly at 9 o'clock a.m. on July 10th till its conclusion. I anticipate running from 9 o'clock in the morning, and I could start a lot earlier, but the jury's sequestered. It's impossible to get it much before that. Be running till probably 5 or 5:30 in the evening. Once again, I don't mind going later, and if there's something that we need to take up outside the presence of the jury, perhaps we can do it, but I don't want to mistreat the citizens that are sequestered. I anticipate running 5.5 days a week, Monday through Saturday around lunch. And then I think to push it beyond that, it's going to be grueling like it is, not only for us, but for the jurors. So they'll be given Saturday afternoon and Sunday. Sheriff will do what he can to make it as pleasant as it can be under unpleasant circumstances. So we'll look at that. I also will tell you, I'll take care of it, okay?
And we are covering the Holly Bobo trial, which is set to begin July 10th. But this week, the prosecution is going to start choosing jurors with the defense team. They're going to fight it out. So we have a jury consultant named Dr. Lillian Glass. She's a PhD, and she's very, very popular. She's on all the media circuits, and we'd like to welcome her in via Skype. And we're
so good to be here.
Thank you. Thank you for being with us.
My pleasure.
Now, I wanted to ask you, what does a jury consultant like yourself do?
Well, what I do, it depends if I'm working for the prosecution or the defense. I help pick a jury that would be beneficial to either the defense or to the prosecution.
And you're a psychologist. How does psychology play a role in choosing the right jurors?
I'm a psychologist, but I'm also a body language expert, and a communication expert. And those two skill sets work so well in the area of jury selection because you look for nuances, you look for behaviors that most psychologists won't see.
So what's my body language telling you right now?
Right now, your body language is saying, I'm anxious. I want to get on with this interview.
That's true. I am a very eager person. What do you look for when it comes to jurors? What type of body language are you looking for when they're sitting in the hot seat?
I'm looking for different things. You know, when they're asked, you know, do you think you could put your own issues aside, and then you see a flinch or something, that tells you something. I look for attitudes. Sometimes people come in with a chip on their shoulder. You know, their arms are crossed, or they're scowling. They don't want to be there, and that tells you a lot in terms of jury selection. Then you look for personality types. You know, there are people that have kind of that energy, that leadership energy, and you know that type of person will most likely be a foreman in the jury process. And so you look for the followers. You look for people who are more in control.
How can you tell a follower from a leader?
Oh, it takes a lot of years of experience, but what you can just tell by their body language. A lot of times a follower, you know, is more lethargic. They're not as, their voice, their tone, you can tell so much about them, how they hold themselves, their posture.
When you talk about people not wanting to be there, I've seen my fair share of jurors who make it on to the jury pool, and they're sleeping sometimes during a murder trial, or they're doodling on their notepad. Who is that better for? Does the prosecution or the defense want someone who just wants to go home?
That's better for the defense, oftentimes, especially in this case.
Why is that?
Well, because they're not really paying attention. They don't want to be there. They're going to do kind of the opposite. They're going to, do something that most likely, not everyone, but they're going to, do something to be defiant.
And you were telling me in a sidebar conversation that you do some investigative work in terms of the social footprint of people that could be on the jury. What does that mean, and how does that play into it?
That tells you so much. It tells you about their political background. It tells you if they're, normal, so to speak, or if they're kind of off a little bit. You see people that are supporting one person versus another, or somebody who's very adamant or violent in their communication. That tells you a great deal because, for example, in this case, in the Holly Bobo case, you want to have a more conservative jury for the people who are in the prosecution. Those are the people that you want to have the person be very conservative. They they believe in the death penalty. They believe in justice, and that's very important. Whereas somebody who has a more liberal stance may not believe in the death sentence.
So what specifically are you looking for to be able to tell whether somebody is a good juror for a death penalty case?
Well, that's where questionnaires come in and questioning comes in. It's so important. For the prosecution in the Holly Bobo case, it's really important to get somebody who's educated. It would help if there were a lot of women on the jury that could relate. Somebody who's had a history or knows people that have had involvements with rape or physical violence, domestic violence. That would help. Somebody who's very educated, maybe a University of Tennessee graduate like this young lady, or somebody who's a nursing student or a nurse or doctor. This could be a very good juror for them. Now, for the defense, the type of juror that would be good for them would be somebody who may be blue collar, not that educated, somebody who doesn't really like the law, maybe felt that there was some injustice. So that is the type of things you look at if you're working for the prosecution or the defense.
So what you're talking about, what it seems that you're saying is that it's really all about relatability. So the defense wants somebody who can relate to the defendant, and the prosecution wants somebody who can relate to the family of the victim or the victim.
That's so well said, because that's exactly it. You want somebody that has that compassion, that can really see beyond the fact that these are just two strangers, but you want them to be invested. And if you have things that are more similar and you feel more familiar with the person, it works in your favor.
This is a case where it's unclear if there's any substantial evidence outside of some circumstantial testimony here. In a largely circumstantial case, what kind of jurors do you want? Because we know it's harder to get a conviction without forensic evidence.
Well, you want to get a jury that is really that is more female in this case. I think that would help a lot. Or if you have men on the jury, that they have young daughters or teenage daughters. That's very important. Once again, you mentioned relatability. That is so essential. And so you want to get that type of person on the jury, even if it's circumstantial evidence. You also look at likability factors. You know, when you look at the defendant, you know, how is he dressed? How is he coming across? What is his body language saying? Because believe it or not, the jury looks at everything. They really examine this in detail.
It's fascinating. I know you have to go. One last question. You brought up the relevance of crime shows. How do crime shows factor into jury selection?
Well, people that tend to watch crime shows, they tend to be really astute and really aware of the system, what's going on, and they tend to be, you know, really fighters of justice. So that's a good person to have on the jury.
Thank you so much. It's fascinating to speak with you.
My pleasure. Thank you so much for having me.
Thanks for being with us. And so, as I mentioned, jury selection is coming up this week. The trial will begin July 10th in the murder of Holly Bobo, a nursing student. And right now we're going to go back to the arraignment and show you some clips of that, then we'll come back and talk about it a little bit more.
Take a speed reading course so that I can move through it quicker, but in fairness to all parties, I wanted to give due. So that, having committed the offense of especially aggravated kidnapping in violation of 13-305, do you understand what you have been charged with?
Yes, sir.
Do you understand the nature of that charge?
Yes, sir.
Do you waive the formal reading of that? Ms. Thompson?
Yes, Your Honor.
All right. Ms. Thompson?
Yes, Your Honor.
All right. As to the third count, you're charged along with two co-defendants with having committed the offense of especially aggravated kidnapping in violation of 39-13-305. Do you understand what you have been charged and the nature of that charge?
Yes, sir.
Do you waive the formal reading of that indictment?
Yes, Your Honor.
Count 4, you are charged along with co-defendants with having committed the offense degree murder. It's a felony murder once again that you did unlawfully and with the intent to commit rape, kill Holly Lynn Bobo in the perpetration or the attempt to perpetrate rape, thereby committing the offense of first degree murder in violation of 39-13-202. Do you understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, count 5. You're charged with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand count?
Yes, sir.
Do you waive the formal reading?
Yes, Your Honor.
All right. Count 6. You're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you're charged with on that count?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
That with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
Count 8. You're charged with having committed the offense of murder in the first degree, premeditated killing of Holly Lynn Bobo in violation of Tennessee Code Annotated 39-13-202. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Waive formal reading.
Yes, Your Honor.
All right, that completes the arraignment process.
And he enters the plea of not guilty.
Yeah, let the record so reflect a plea of not guilty is entered. It's my intent to attempt to design at some point a scheduling order. In speaking with the attorneys, discovery will be an ongoing process. However, state's attorneys have indicated that they're ready to turn over all discovery within 30 days. And I've given them some extra latitude. They said they've actually got it ready and can be done within a week. I will consider that to be the attorney's work product when they receive it. I expect you to share it with your defendant in consultation, but I don't know that outside sources should necessarily benefit from your discovery. Okay?
Yes, Your Honor.
All right. What other matters do we want to touch on Mr. Zachary Adams.
I would like to say for the record, just in terms of the report that was on Channel 5 last week, while I have been provided with the photographs that they referred to in the report, I have not been provided with the affidavit to the best of my knowledge, and I've been through that discovery, and I've had multiple people go through that discovery. I've not been provided with the affidavit that they referred to, and I have not been provided with the TBI lab report that confirmed that the blood was Holly Bobo's. So I don't even have that information. I would like it, and hopefully I will get it soon, but I don't believe I have that information.
They will get you the discovery. She said it is indexed. It's indexed. She will furnish a copy, the same copy to each attorney. In that material are co-defendant statements, if there are any. There's also jinx material, which technically they're not required to provide until after that person testifies, but they might very well be aware of my history as possible so as to not delay a trial.
Yes.
And on top of that, Your Honor, I had an opportunity to speak with Ms. Watson this morning and have made ourselves available in that we've agreed. I've offered to, once the discovery is given, to meet with her, answer any questions she has about, what we were providing, point her in a particular direction if she has questions.
I think open discovery, I think it facilitates the case moving and is beneficial for all parties, both the state and the defendant.
When she gets her co-counsel in line, it's probably, that would be the time to do it, but the offer remains on the table.
Well, as I said, one of my primary objectives is to preserve the defendant's right to a fair trial as well as the state's right to a fair trial. And I think open discovery will actually aid all parties concerned.
And there was an objection that I had expressed at prior hearings, and the state assures me that open discovery doesn't mean just come and look and see what we have, but they will file a record with the court so we can be clear as to what I've been provided.
We're going to
file it directly with me.
Going to file a duplicate copy now, I know, directly with Your Honor.
That way, as we run into discovery disputes, we'll know where we're going, okay?
At this point, Your Honor, in light of the fact that the state has just filed this notice of aggravating circumstances on the new charges, we had several motions that were before the court, but I don't believe that now is the proper time to have hearing on those. We'd like to continue those matters until we have an opportunity to.
At some point, we'll be proceeding totally under the new indictment, and I would assume the old ones because everything's covered in the new one. But we want to preserve your right to present those motions if you wish or desire.
Can we say that those motions, any motion that I've filed in the other case, will automatically transfer to the new case? The discovery?
It is fine with us. That's the only reason that I've delayed this, was because I frankly didn't want the defense to...
Let's not gnaw across yet.
Yeah.
Okay. I don't need to file a new motion for discovery, and I had a motion regarding Brady material. I don't need to refile those duplicate motions in this.
Unless you find deficiencies in the discovery,
okay.
At which point you can file anything to bring the matters to the court's attention that you feel are appropriate. Then the circumstances with filing the notice have changed dramatically.
Yes.
And I had wanted to find out how long you folks felt Oceans. We've got a whole new situation. So I'm not going to be able to move at breakneck speed as I had hoped. I think in fairness to all parties, when you're talking about the ultimate punishment, then there's a heightened due process. And I want the attorneys to have an adequate time to file their motions. But I'm going to suggest in 180 days. So let's start looking at that framework, okay?
Yes.
And that will be as to each defendant.
Yes.
Okay? And we will try to have new counsel on board probably by the end of this week. Okay?
Yes.
Matter of fact, you might notify that person and make sure, because this is going to be very burdensome. You already know that.
He knows.
Okay.
He's been involved. He's aware of the nature of the case. He's
Okay.
actually met Mr. Adams, and he's prepared.
Okay. Is there anything you don't understand at this point, Mr. Adams?
No, sir.
All right. Let's dismiss Mr. Zachary Rye Adams.
Yes.
Bring in Jason Wayne Autry. Just at the podium there. You are Jason Wayne Autry?
Yes, sir.
Mr. Autry, we're here today to arraign you on a new indictment. This is essentially something that will take place of the old indictment. There might be additional charges on this that were not contained in the old indictment, but you have been indicted along with Zachary Rye Adams and John Dillon Adams in one single charging instrument. We're here today to arraign you on these charges and then take up any other matters that you folks feel are appropriate. You are charged in case 15 CR 30. In the first count, you're charged with what is known as felony murder. It charges you with unlawfully and with the intent to commit kidnapping that you killed Holly Lynn Bobo in the perpetration or the attempt to perpetrate kidnapping. Therefore, committing the offense of first-degree murder in violation of TCA 3913-202. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Do you waive formal reading of the indictment?
We do waive formal reading. I would qualify Mr. Autry's answer as to the nature and cause of the accusation. We have had a continuing problem in this case with that, and we don't want to waive any objections.
You're not waiving anything today, okay?
Very well.
All right. Count number 2, you're charged with having committed the offense of especially aggravated kidnapping of Holly Lynn Bobo in violation of TCA 39-13-305. Do you understand what you've been charged with?
Yes, sir.
Same situation, he understands the nature to the extent not waiving anything.
Right, we understand what statutes are involved.
All right, you waive the formal reading.
We waive the reading.
All right, count number 3. You have been charged with having committed the offense of especially aggravated kidnapping of Holly Lynn Bobo in violation of TCA 39-13-305. Do you understand what you've been charged with?
Yes, sir.
Same situation, waive the formal reading.
Yes, Your Honor.
Count number 4, you're charged with having committed the offense of felony first-degree murder in the perpetration or attempt to perpetrate rape in violation of Tennessee Code Annotated 39-13-202. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count 5, you've been charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count number 6, you're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you have been charged with?
Yes, sir.
Same situation.
Yes, Your Honor.
Count 7, you're charged with having committed the offense of aggravated rape in violation of TCA 39-13-502. Do you understand what you've been charged with?
Yes, sir.
Waive formal reading of the indictment.
Yes, Your Honor.
Pleas of not guilty will be entered on. Well, I've got the 8th count as well. You've been charged with having committed the offense of premeditated murder in the first degree in violation of TCA 39-13-202. Do you understand what you've been charged with?
Yes, sir.
Waive formal reading, Mr. Ferguson.
Yes, Your Honor.
As to the indictment, counts of or pleas of not guilty will be entered as to all 8 counts of the indictment. Other matters that you wish to take up today, or are you in the same situation that Ms. Thompson was?
Your Honor, we would ask that Mr. Altree be determined to be indigent for purposes of support services, expert assistance. I realize he'll need to fill out an affidavit.
Can you get that affidavit and get to the court, and I will, I think there's very little question. You don't have any financial resources?
Absolutely not.
I'm going to make a preliminary determination of indigency for purposes of getting support services, mitigation specialists, whatever are deemed necessary in his proper defense.
Very well.
If you'll get me an affidavit to support that.
Certainly will. In regard to Mr. Zachary Adams, there was discussion of open file discovery. Do we have an on-the-record representation that open file discovery will be provided as?
I don't know that we said open file. What we did say, you'll be furnished the same discovery of each defendant. State will be under a continuing duty to provide any additional discovery.
Very well.
Is that correct?
Yes, sir.
I think she's giving you everything she's got.
Very well.
And you've already essentially, under 2 DAs ago, had essentially an electronic dump that I understand it's just unbelievable the amount of material in that. That stretches the human imagination, but she will have this in form indexed, and I will have a copy so that when we have any discovery disputes, we'll know where we can go.
Yes, we were furnished 2 external hard drives that the defense had provided to the state. There was some difficulty in the organization of it, but I'm pleased to hear that this will be indexed.
Well, we're indexing it. We're not organizing it perhaps the way that defense counsel wishes that we would. They'll have an index. They're still going to have to work. There's no way to make this small. Your Honor made reference to the voluminous amount. It's over 4 terabytes. I've been told that's a quarter of the size of the Library of Congress. Can't make it small, but they're going to have an index.
I understand.
The haystack's still there. They're going to give you some needles. Okay?
I understand.
You want to hold your other matters in reserve?
Yes, and Your Honor, as to indictment number, the previous indictment, number 2014 CR 20, we had motions pending that request dismissal with prejudice, and we will accordingly object to any nollie proceeding with there.
We're keeping those files open until everything's done, and then there'll be no process.
Yes, and I understand. I received one motion from the state, one filing from the state. It's the state's response to defend this motion for bill of particulars. I understand there's an additional 83-page or so pleading or filing that I've not yet
There's
received.
some cases attached and some other matters.
So if we can hold those off until later, I would advise.
I want you to get your discovery before we address the bill of particular issue. The state is saying we will give you complete discovery such that we feel that it will obviate the need for a bill of particulars. The court will cross that at a later time.
I understand, and Your Honor, I do.
And then I guess we ought to say, Mr. Flanagan, who's also co-counsel, he received the court's permission to be away today.
Yes.
He's apparently got a vacation scheduled.
That's what I understand.
And I think it's good that attorneys periodically take vacations.
Very well.
Ms. McGinley had me on vacation last week with grandkids. So.
Very well.
All right. Anything else on this?
I would apprise the court that I do anticipate fairly promptly filing some dispositive motion regarding the new indictment, and if we can Since that would moot out the case, if we could take those up pretty promptly. Since that would moot out the case, if we could take those up pretty promptly.
How soon?
I can file them by the end of next week, and they can be for hearing anytime afterwards.
Of course, the state will need to respond. So, and I don't know what motions he's talking about.
Well, I can apprise that.
How about July 29? That's about a month and a half.
Very well.
I try to keep Wednesdays available for this case because a lot of the courthouse offices are closed, and with the enhanced security and the things, I try to do that. Let's see if we can.
Your Honor, was that a date for a hearing on that motion? Is that what you just announced?
It would not be, well, might be an evidentiary hearing, but I don't know yet whether it will require evidentiary hearing. Morning or afternoon, Your Honor?
I guess I'm asking if we can, since we don't know what motion you're referring to, can we at least get a copy of it and see whether or not it requires?
Let's tentatively set it for July 29, and then is that a problem?
Okay.
I'm turning on my calendar.
Morning or afternoon, Your Honor?
Morning.
Morning. And I will
that
say,
way, I've got all day if it takes it.
Very well. And I can state that the grounds for dismissal I anticipate will be Rule 8A of the Rules of Criminal Procedure plus the Due Process Doctrine of Prosecutorial Vindictiveness.
And you're hearing the arraignment in the Holly Bobo trial. I'm joined by Law News Network correspondent Aaron Keller, who just made me laugh at an inappropriate moment, and Law News host and correspondent, they're both hosts, Misty Maris. And I love these panel discussions because I love getting all of the opinions and we can really debate. The judge recusal motion, this had me up in arms because first of all, the judge gives out his cell phone and answers a call from the prosecution at dinner and has an ex parte communication. Then he says something to the effect of, to Zach Adams, you should be banging on the prosecution's door to try to get a plea deal. And then he's asked to rule on his own recusal, whether he should go off the case or not. Misty, what do you think about all of this?
Well, it's really interesting because this is an issue that comes up for defense attorneys often. First of all, they were absolutely right to ask for the judge's recusal. They had to in this case. The fact that he had that ex parte communication is completely improper. And then also he's showing complete bias to the prosecution, saying you should really be doing everything you can to take this plea deal. The thing with that motion is that it's a real strategy call from the defense perspective because very often, even here in New York, that motion goes to the judge to make their own decision about whether they're biased or what they've done is improper. And how often do you think they say, you know what, actually, that wasn't right that I did that?
Probably
very
never.
rarely,
Probably
yes.
somewhere close to never.
Yeah, never. I recently actually argued this motion, and the problem is that if you're not successful, and for whatever reason, you're going before that judge for the remainder of the case. So now you could put yourself at a potential disadvantage.
And I could tell that Jennifer Thompson was very nervous. I mean, mid-sentence, she's guzzling her Perrier and shaking while she's talking to this guy about recusing himself. And he was fighting. He was fighting against it. And obviously the prosecution was on his side, kissing up to the judge. What do you think about giving out the cell phone and this plea to take a plea deal, which he says was just encouraging negotiation and settlement?
Well, look, I mean, the cell phone thing is bad on its face, okay? You want to have conversations on the record, obviously, if you're a judge. The rest of it just went off the tracks, in my opinion. The judge getting in and trying to counsel the defendant, I mean, that's not the judge's job. That's the defense attorney's job. Does the judge know all the evidence in the case? Presumably not. Right? Okay, so why is the judge jumping to that conclusion right away? I don't know. It left a bad taste in my mouth as well. The judge should be listening to the motions presented by the attorneys, but let the defense come up with a strategy. And I think the strategy thus far, from what little we know of the case, because so much of it has been reported in dribs and drabs, is that the defense strategy is really going to be to pit the statements of the other witnesses, conspirators, what have you, against one another and say, well, wait a minute, this one said one thing, this one said the opposite thing, the state changed its theory midway through the game, and therefore the prosecution is inconsistent, you can't believe what either of them say. Now, that's an actual strategy. If the defense thinks it's strong enough, the defense ought to be able to present it. Why is the judge getting in the middle of it and saying everybody should just be pleading guilty?
Yeah, and the fact that what you're saying is these people that could be pitted against each other, they all have credibility issues. But what you're talking about with the judge and what his defense was, listen, I'm just trying to negotiate a settlement. I've seen judges actively try to negotiate settlements in business disputes. But is this normal, Misty, in a criminal defense case, a murder trial, to try to get a settlement of basically telling the defendant to plead guilty?
I would say that judges do try and strike deals. They do. They try and say, they stay away from giving legal advice, which is really what happened here. This is a recommendation by a judge to who would be a co-defendant or co-conspirator defendant in this case, for that person to take a deal. Completely improper. A judge saying something to the effect of, well, did you consider the prosecution's offer of a plea? Or would you consider the prosecution's offer of a plea? Or advising, well, listen, here's what you're charged with and here's the potential sentence range. The prosecution's offered you this. What say you? Something like that, those backdoor conversations with attorneys, with the defendant in the room, happens all the time. But giving a legal opinion, which is really what that is, at the end of the day, that's the judge saying, my advice to you is to go strike up a deal with the prosecution. Particularly problematic, given what we know or what the inkling is about the defense strategy.
So the problem here is semantics. Obviously saying bang on the door of the prosecution and beg for a deal is improper.
Right, but those words, that makes all the difference. In the law, we know those legal terms, what you're doing, that makes the difference between towing a line of what's proper conduct and what's completely improper conduct.
So Aaron, is this an issue on appeal?
I think that I would think so, certainly. What if this were a bench trial? What if the defendant were to choose a bench trial? You can't in front of this judge. Definitely. Seriously? But I think that it's more than just semantics. I think that the judge really was stepping into the prosecution's shoes, or in the defense attorney's shoes, or both. Again, it's one thing, as Misty pointed out, to say in a subtle way, look, Mr. Defendant, you realize the charges are serious. These are 3 possible options. That's like a waiter saying, here's the menu, not, if I were you, I'd order the turkey because the beef is got botulism or something. There's a difference between making sure that a defendant understands the options and then just saying, this is really the option you should take.
So it seems like he served up dessert to the defense before they've even eaten dinner,
Something
because now
like that.
we have an issue for an appeal before the trial even gets started.
Right, and it seems like the judge, maybe that was the wishful thinking of the judge. How often are you sitting on one side or the other thinking, boy, I wish they'd say that, or I wish they'd say this, or they should have done that, or backseat driver should have done this. He just went ahead and did it. But that really was an improper move, and that, in my opinion, and in the opinion of a lot of legal analysts out there, that's a clear bias.
And then the fact that he has to, Aaron, rule on it himself, and he has to say, I don't think I did anything wrong. We know that on appeal, sometimes it will still go back to the same judge. Why is that? Do you think that's proper in the system?
It's just the way the system works. Is it morally, ethically proper in a pure world where we pluck, purity out of the sky and then just live with it? Well, no, of course not. But, who else is going to hear the motion? That's the judge that's sitting in the trial. It starts with him. If it were to happen in front of a conscientious judge, the judge might realize, hey, look, I better dial myself back a little bit here because I might get slapped on the wrist by an appellate court. And if there's one thing judges hate worse than everything, it's being overturned on appeal. Okay? Now, judges hate that worse than they hate being wrong in an individual circumstance, or, having to save face in a community from a public relations standpoint. They don't mind that. They hate being overturned, because then that's a signal that they screwed the law up. Okay, so I don't know how else the system would work. I know that it looks fishy from a pure moralistic standpoint, but it starts with him. If the attorneys don't like the decision he makes, it jumps up above his level. And I don't know, maybe they have filed an interlocutory appeal in order to hop it up another point yet, or maybe an appeals court would say in that particular state, you have to wait for the trial to be over to see whether an actual bias was suffered by the defendant. It's just standards for flipping errors over like that are pretty high. I mean, there's got to be a pretty clear danger, and at this point, in theory, the defendant probably hasn't suffered one yet.
And there were other issues, and we heard from the defense attorney that the judge couldn't get the two Jennifers right. There's a Jennifer on the prosecution team, a Jennifer on the defense team. He's calling them by the opposite names, which is probably messing up the record. So that's an issue in and of itself. Last question, and then I'm going to turn it over to Misty, who is going to take over the hosting responsibilities and continue Casey Anthony trial coverage. What do you think, Misty, is the biggest issue in this case?
The biggest issue here is going to be the fact that, again, much like we're going to talk about Casey Anthony later this afternoon, you've got a case based off circumstantial evidence. We have potential witness testimony, but we have witnesses who have problems. And when you have a circumstantial case, witness testimony can be what makes or breaks that case. So it'll be interesting to see how that plays out throughout this trial.
Aaron.
I think that I agree with Misty. I will add that one of the other issues is going to be that this is in a small rural county.
Which you know something about because you covered Making a Murderer trial, the Stephen Avery trial.
I've lived in smaller communities as well.
How does that impact
I grew up upstate. So I think the population of this county is just over 11,000 people. That's a pretty small jury pool for a crime that's already received our attention and national attention. And I was digging around in some of the local news organizations' websites, and the comments are just, this guy deserves the death penalty. Okay, well, that's what this particular defendant, the first defendant who's up, is actually facing. But look at the public backlash within the walls of that county. I think one of the big issues with it is going to be that the victim, from what I gather, was well known in a church community. Everybody who's commenting is saying, well, I didn't know her, but I know her cousin. I know her family. I went to school with one of her siblings. And when you've got that kind of a small community, the instinct of the community is justice for the victim, not weighing the constitutional rights of the defendant. And I think that that's an issue that was exploited in the Making a Murderer case as well. So you've got a high publicity trial with a relatively small jury pool. Everybody there probably already has an opinion about it. Jury selection is starting either today or tomorrow. It's going to be a tough jury selection.
Even outside of that county, it's going to narrow the jury pool, a jury consultant was telling us.
Yes.
Because you can't find someone who doesn't know about it.
How many big murder trials get national attention out of Tennessee? I mean, this state knows that it's in the spotlight right now. And part of me wonders if the reason that the judge said what he said about the defendant, maybe you should take a plea, is because the judge feels somehow, whether it's legally right or wrong, maybe he feels somehow that he's trying to quiet the community in some way. Maybe that instinct led him to go in that direction, which again, legally makes the hair stand up on all three of our heads. But you know, judges oftentimes in communities like that feel that pressure coming back.
I would object to that speculation, Aaron, without evidence to support it, unfortunately. But thank you guys so much for joining me. So I'd like to thank you guys for welcoming me as the host. Today was my first day. I really enjoyed covering Casey Anthony, Holly Bobo, and continuing the coverage. The trial starts next week, and I'm going to now toss to video of the arraignment of Zachary Adams, Dylan Thomas, and Jason Autry, the three defendants in the case, charged with the murder, kidnapping, and rape of Holly Bobo, and then Misty will take over from here. Thanks so much.
That's what I anticipated this time.
I can take up. If we've just got you, that's fine. If there's something touching on the other people, then I'll make that date available as well.
Okay, I'm not available that day. That's why I was just asking if this is for everyone or just this defendant.
Well,
I can do it the 22nd, a week earlier, or I would have to go into the last week of August.
22nd will work for me, Your Honor.
I can do it the last week of August, Your Honor. I'm not available the 22nd.
26th of August, tentatively.
I'm available. Mr. McCollum's checking. Okay, it's good for the state.
If they haven't changed, and I think they have changed, used to the court system in Shelby County closed down during August. Maybe it's civil. I think it harkens back to the days before air conditioners. And they just haven't changed that rule.
We both have trials in August. It's definitely not.
Okay. So we'll hold that date. And then if problems arise, I can take up things by telephone conference.
Do it.
Okay? I mean, just scheduling things. I don't want to hear anything that is material. Just scheduling problems.
Okay.
All right? All right, anything else on him today?
I would like an opportunity to confer with Mr. Autry before he's taken back. I'd like to observe Mr. Dylan Adams' arraignment, but if I can make sure I have some time for client.
All right, can we hold him? Where's my TDOC?
Oh, here it is.
Yes.
Thank you, Your Honor.
Your Honor, there are people in the courtroom that were subpoenaed by Mr. Ferguson that if he's not going to go forward, I'd ask that they be allowed to leave.
Oh, certainly.
All right, anyone that's subpoenaed on behalf of State of Tennessee versus Jason Wayne Autry, you're hereby released.
So long as they're subject to being present for any future motion hearing with regard to. Thank you.
All right, Mr. Ott, you got any questions?
No, sir.
All right, thank you, sir. All right, we got a place where he can meet after our hearing?
Yes, sir. Yes, we do.
Okay, so he can exit there and then you'll make him available?
Yes, sir.
All right, thank you, Sheriff.
Thank you.
All right, let's bring in John Dylan Adams.
Your Honor, I do have an affidavit prepared, but he's not yet signed that I will be submitting that to the court.
I've already found him to be indigent.
That's
so
correct, Your Honor.
I don't know that it's necessary, but you're appointed on this. I'm going to execute it today's date, but it'll be not pro tunc.
Thank you, Your Honor.
All right, you are John Dylan Adams.
Yes, sir.
Mr. Adams, in case 15 CR 30, a new indictment has been returned by the Decatur County Grand Jury. It contains earlier charges as well as additional charges and you have been indicted along with 2 co-defendants, Zachary Rye Adams and Jason Wayne Autry. The first count of that indictment, you are charged with having committed the offense of felony murder, alleging that you did unlawfully and with the intent to commit kidnapping, kill Holly Lynn Bobo in the perpetration or attempt to perpetrate kidnapping, thereby committing the offense of first-degree murder in violation of TCA 39-13-202. It's generically known as felony murder. Do you understand what you have been charged with?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Count 2, you're charged with having committed the offense of especially aggravated kidnapping of Holly Lynn Bobo in violation of Tennessee Code Annotated 39-13-305. Do you understand what you're charged with on that count?
Yes, sir.
You understand the nature of that charge?
Yes, sir.
Count 3 of the indictment, you're charged with having committed the offense of especially aggravated kidnapping of Holly Lynn Bobo in violation of Tennessee Code Annotated 39-13-305. Do you?
Yes, sir.
Count 4, you're charged with having committed the offense of that you did unlawfully and with intent to commit rape, kill Holly Lynn Bobo in the perpetration of or the attempt to perpetrate rape, thereby committing the offense of first-degree murder in violation of Tennessee Code Annotated 39-13-202. Do you understand what you've been charged with in that count? Count 5, you're charged with having committed the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502. Do you understand what you've been charged with in that count? Count 6, you're charged with having committed the offense of aggravated rape of Holly Lynn Bobo in violation of Tennessee Code Annotated 39-13-502. Do you understand what you've been charged with? Count 7, you're charged with having committed the offense of aggravated rape in violation of 39-13-502. Do you understand what you've been charged with?
Yes, sir.
Count 8, you're charged with having committed the offense of premeditated first-degree murder of Holly Lynn Bobo in violation of Tennessee Code Annotated, Section 39-13-202. You understand what you're charged with?
Yes, sir.
Mr. Maddox, do you waive formal reading of the indictment?
Your Honor, we have received a copy of the indictment as well as I've given a copy to the defendant, and we will waive formal reading of the indictment at this time.
Let the record so reflect. Pleas of not guilty as to all 8 counts will be formally entered on his behalf.
Yes, Your Honor.
Do we have the same situation concerning any motions in the old case?
Your Honor, I did have motions that I filed underneath the old case. What I was asking for in those motions is that discovery be provided. I've been assured by the state that that is forthcoming.
I think you're going to get more than you
I think that's probably true, Your Honor, but I do need that. And as long as it's forthcoming at this time, I do not need to proceed on with those motions under the same circumstances that...
those files will not be closed until I've either been advised that the parties no longer wish to present them or they've been disposed of.
Yes, Your Honor.
Okay?
Your Honor, there are a few other matters that I do need to address the court on under the new indictment, I guess you would say. It's my understanding, or at least some of the other attorneys may have indicated that they do not wish to file the motions again. However, in light of the notice given by the state of Tennessee today, I will be filing all of my motions again due to the heightened scrutiny that notice brings with it. So I will be refiling those, but I would like to...
Mr. Maddox, I've been dealing with you for how many years?
More than either one of us care to talk about,
Since
John.
the memory of man runneth not. I'm very familiar with what your computer generates in virtually every case that I have.
Yes, John.
I anticipate I will be seeing that yet again.
Yes, John.
Okay.
However, if the state will agree to the same orders that we have already agreed to under the first case, then that will belay any argument of those motions.
All right.
That's for record-keeping purposes.
Okay, all right.
For any appellate.
So anything else, and then, as I said, we'll be looking at August 26th. That's not a deadline for motions or anything. It's just an early hearing date if there's anything that's dispositive or that the parties feel particularly need the court's attention.
Your Honor.
And I will say, in thinking of this case, I've tried very hard since the very beginning to get this thing on track. There are times that I felt like the children's game, the whack-a-mole. I'll whack it down and I'll have two more pop up over here. But I hope that we're past the primary obstacles and surprises in this case and we can take this to a reasonably expeditious conclusion.
Well, the number of years that I've dealt with you, Your Honor, I've never been whacked by you, and I hope I don't get whacked now. Your Honor,
I don't have friends or enemies, all right?
Thank you, Your Honor. Your Honor, the other issue that I would like to address is the state has said that they will be providing an index to this discovery. If I could impose upon the state to also make available someone who is aware of the current organization of the material on the hard drive and make that person available to me so I can understand the organization that as it is,
as I
and also the
they
different
said
file types.
They're willing for a face-to-face exchange.
And I had the same discussion with Mr. Maddox that I had with the others. We've already had a face-to-face or two, and that offer remains on the table as well. I'm not, at this point, because we've already copied the discovery, not going to reorganize it. The index, along with the face-to-face, will point him where he wants to go.
Okay.
Certainly.
All right, anything else?
Finally, Your Honor, the previous cases were all individualized as to the defendants. Now with the new indictment, all three defendants have been brought underneath the same case number. I would ask that all parties in this case, if they would include all of the defendants and all of the attorneys on any certificate of services so we could all receive copies of motions and other responses.
I have no problems. Ms. Thompson, you all right with that? I agree. Mr. Herbison? Okay. Same over here. And Mr. Herbison, you've had some change of address. If you'll get various counsels, the address as well as the clerk's office, and also Ms. Carroll. Okay? All right, anything else on him?
No, Your Honor.
Anything else we need to deal with today as to any of these defendants? Anything further from the state?
No, sir.
Anything further from Defendant Zach? No. Autry? Jason?
No, Your Honor.
All right. Then we will, Dylan, I beg your pardon. Then we will hereby adjourn. All right.
Hello, everyone. I'm Misty Maris. Welcome to Law News. I've switched sides of the table and taking over hosting duties for the next couple of hours. I hope everybody had a great 4th of July. And now we're back here at Law News watching these trials. We've got our eye on Holly Bobo. Now, this is a case that's coming up for jury selection starting next week. 6 years in the making. This trial has been delayed time and time again. We were just watching the arraignment of the 3 suspects in the case. That's Zachary Adams, John Dylan Adams, and Jason Autry. Very interesting issues in this case playing out as the time for trial draws near. I'm joined here by criminal defense attorney Nicole DeBoard. Hello, Nicole. How are you today?
Hello. How are you?
Good. I hope you're refreshed from 4th of July and ready to break down this Holly Bobo case. I mean, there are just such a plethora of issues that are coming out pre-trial. And I mean, we're talking about 6 years of coverage of this case in a small Tennessee town. And finally, we're at the brink of jury selection. So let's start there. We actually had a guest on earlier today talking about the difficulties of selecting a jury in this small knit community. How do you see that playing out this week? I mean, how long is jury selection going to take, and what strategies is the defense putting in place?
So the defense is going to be wanting to make sure that the people who end up on the jury don't have their minds made up about what they think happened. So it's going to take some time, because this has been such a public case, to find out what impressions the jurors have, what they think they know, and whether or not And this is such a cliche thing to say, but they can put whatever opinions they've already formed aside. I mean, ideally, you would have jurors that didn't have any opinions formed about the case, but that's going to be a very difficult thing to achieve in this circumstance. It's a small town, it's a big case, and a lot of people have a lot of information about it already.
Oh, definitely. And we know that the victim in this case, terrible, tragic story, but she was high profile in the community, and a lot of people know her family, know other friends, and she was active in church. That makes it even more difficult to find unbiased jurors. So how do you do that from a defense perspective? What kinds of questions are you asking? Because you never truly know what a juror is thinking.
No, you can't know, and it's a scary thing. You worry that maybe someone's not going to feel comfortable disclosing all of what they feel or know or think they know about the case. And so you're relying on them to be completely open, and you have to make the jurors feel comfortable being open, letting them know that there is no wrong answer, that you're really just trying to find out what they think about the various facts that they think they've heard. I think the judge and both sides are going to be asking a lot of questions about what information these potential jurors have already received, if they have any information about it. And what does that information make them think about the various parties and any responsibility on the part of those parties. And so those are the first questions I think that both sides will be asking.
Oh, 100%. And you know, in a case like this where you want to get even more specific than those general questions, as you said, you really want to make sure the jurors haven't formulated their own opinions. So that brings me to an issue which I think has been more prevalent, and I'm sure it's come up a lot in your practice. I know it has in mine. It's really, how far do you go to research the jurors? Everybody has an electronic footprint now, right? So you're going to make sure from a defense attorney perspective and from a prosecutorial perspective, because everyone wants a fair and unbiased jury, that you're going online to ensure that you don't have somebody posting a lot about the case, making comments, stuff like that.
Exactly. And there's a ton of information available right now. And there are lots of cases out there and presentations about the ethics of researching jurors online. And the fact of the matter is that it is totally lawful for an attorney, and it's even expected, quite frankly, for an attorney to do at least some cursory research to find out what can be found out from people's various social media platforms about what kinds of information they're posting. And this is important for the jurors, it's important for the lawyers to understand what the jurors are thinking. And it may also reveal circumstances where maybe the jurors haven't told the lawyers in the court everything. What lawyers can't do in that context is sneak onto a juror's website or even potentially communicate with the jurors about what it is they're posting. So lawyers can look, but they can't talk with the jurors through social media while they're in the jury selection or trial process. And they can look, and they can't sneak on to a juror's social media page. So if it's open and available to the public, the lawyer can look. If it's not open and available, then the lawyer really can't even reach out to the juror to gain access to that social media page.
Yeah, very, very, very important distinction that if that line is crossed, could put the entire integrity of the trial at issue. And you would have a situation where they'd say this trial was unbiased or was biased right from the get-go, could get a conviction overturned. You have these really big issues on that front. So keeping in line with these issues of jury selection, we just saw this play out in the Bill Cosby trial. Obviously, Bill Cosby, different level of celebrity status, national news attention, the use of jury consultants. So what's your opinion on jury consultants? I know this has become even more of a trend in local cases. I mean, we used to see this popping up with your Bill Cosbys, with your O.J. Simpsons, with your really high-profile celebrity cases. But now it's a much more prevalent industry, even in small communities. So do you think that that's helpful in a case like this?
I think anytime you can have someone share the workload, and that means going out and finding out about information from the community that might be hearing the case, you're at an advantage. So there's almost no reason, if it's not available to you, or if it is available to you, that you wouldn't use it. And the problem is that jury consultants can be very expensive, and jury consultants are not available to most criminal defendants facing trial. The reality is if we could run every single trial that we had through a focus group, and we could have someone taking on some of the workload of going through every single jury juror questionnaire, and finding out personal information about those jurors. It's almost like having an investigator. That would be the ideal circumstance. Practically speaking, that's not available for every defendant in every trial. To the extent that it's available to you, you'd be foolish not to use the information.
Yeah, I mean, definitely the more information, the better. But at the end of the day, juries are very unpredictable, as we're going to talk about a little bit later in the day. Right now, we're going to stick with Holly Bobo because this case is going to jury selection next week. But later, we're going to revisit a case that grabbed national attention that no one could look away from, and that's the Casey Anthony trial. So from what we know about Holly Bobo now, and again, this is an interesting case because we're talking about 6 years in the making. 6 years this case has been waiting to get into the courtroom. What about what we know right now, which is the case is largely based on circumstantial evidence and the witness testimony of the primary defendant's brother, a confession that will undoubtedly be called into question in the courtroom. But what about these circumstantial cases? In our world of CSI, does a jury have a difficult time saying, well, why is there no forensic link? Can prosecutors get convictions on these cases?
They can, and it's a scary thing. It's a dangerous thing. I mean, I think there are two sides to that same issue. Really, you have jurors that walk in and want to be sadly entertained as if it was a TV show and as if, you could solve the whole case in an hour. And that's probably not the healthiest perspective to have. On the other hand, the positive side of this coin is that jurors, with all of the information that's been made available to them through media, through the news, they're so much more educated about what is science and what is not science. And what these jurors will need to be doing is looking to figure out what is speculation and what is actual evidence in the case. So the prosecutor can get a conviction, but really, we shouldn't be asking prosecutors to get convictions on sensationalized gossip, basically. And there's a difference between that and circumstantial evidence. That's true. But we really do need the jurors to be thinking critically about what is actual evidence and what is conjecture.
Yeah, and that's definitely the case. And as defense attorneys, you spend a lot of time reining in the jury to say no emotion, just evidence. What do you see? What does the evidence tell you? Another interesting question that I'd love to pick your brain about is the purported confession. So there is a confession. This is John Dylan Adams. The prosecution's case is largely based on a confession. We anticipate, from what we know, and again, it's a little spotty coverage on that local level because the case has been such a long time coming. The media kind of dipped in and out of it as time went on. But the confession the defense is likely going to argue that in some capacity that confession was coerced. So what is the standard there? What does the defense need to show to get that conviction thrown out? Excuse me, confession thrown out.
Sure. Confessions, those are slippery things. People say all kinds of things for all kinds of reasons. And, anytime a defense is arguing about the way a confession was obtained, they're arguing about whether or not the things that were said were A, actually reliable, and B, whether the statements were voluntarily made. And so if there was trickery involved in obtaining this statement, or there was some reason or motivation for him to be asked to say these things, and those are certainly pieces of information the judge is going to need to consider in determining whether or not this particular statement by this accused was reliable enough to actually find its way into the courtroom and in front of a jury.
Well, we've got a lot of issues that we're going to be talking about as this case proceeds. Nicole DeBord, excellent commentary. We're going to come back to you, but right now we're going to watch some more coverage of some of the pretrial hearings that took place in the Holly Bobo case, just to acclimate ourselves for jury selection, which will take place next week. So we're going to cut to a clip now, but then Nicole will be back to talk about it.
Your second motion?
Yes.
All right. It's a motion to set aside order disqualifying Luke Evans as attorney of record for Zach Adams. And I want to make a preliminary statement concerning that at this time. I have never, to my knowledge, set eyes on Luke Evans. I'm assuming this might be him in the courtroom, but I don't know. And I think he will confirm that. I will say that anything that I know about Luke Evans' involvement in this case was gleaned from a public record. I was preparing to hear a motion for injunction to enforce an immunity agreement that was filed in the Chancery Court of Decatur County. Frequently, I interchanged with the Chancellor, and she was fairly new at the time, and I was prepared to hear it. And then the untimely death of Mr. Shane Austin rendered the case moot. But is that not correct? We've never met, to my knowledge, have we?
That's correct, Your Honor. I think we had a teleconference in that case.
We did in that one? I didn't even remember that.
Yeah, we had with Scott Sutherland, with the Attorney General's office, myself, and yourself. It was a scheduling conference regarding setting a hearing out prior to Mr. Austin.
And then upon his demise, it was moot?
That's correct.
Okay, thank you. All right, proceed with your motion, please.
Yes, Your Honor. I would like to call Luke Evans to testify.
Okay, come around, sir. I want you to raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Would you state your name for the record, please?
Luke A. Evans.
Okay, and how are you employed?
I'm an attorney.
Okay, and who do you practice with?
I'm a law partner at the law firm of Bullet Fly, Hornsby and Evans in Murfreesboro, Tennessee.
Okay, and can you explain to the court how it is that you came to be involved in the representation of Zachary Adams?
Yes, I was contacted by you and asked if I would be both willing and able to engage on behalf of Mr. Adams. In response to that inquiry, my first statement was that I needed to check with the BPR because I had previously represented Shane Austin.
Okay, and did you in fact check with the Board of Professional Responsibility?
I did. I contacted them immediately after speaking with you on November 23rd, 2016. I spoke with Stephen Christopher that afternoon in detail about the issues related to any potential conflict that might exist or ultimately might.
We use the acronym BPR, Board of Professional Responsibility, and we've got a lot of people that are non-lawyers.
Sorry about that. So I called the Tennessee Board of Professional Responsibility and ran it by Mr. Christopher in detail.
Just what details did you tell him? I mean, what facts did you make clear to him when he made the decision that, or when he advised you that there would not be a conflict?
On that date, I alerted Mr. Christopher that I had previously represented Mr. Austin, who had not been indicted in the case, but was considered at the time a person of interest in the investigation. I let Mr. Christopher know that I had filed a civil suit and litigated the issue of enforcement of an immunity agreement in the Chancery Court of Decatur County, and that there was a proffer attended for those who don't know what a proffer is, where myself and Mr. Austin met with several agents from the TBI one evening and had a discussion with them, as well as I had some interactions with Ms. Beth Boswell, who was the attorney at the time handling the case.
Assistant District Attorney.
Yes, sir. Had some discussions with her in negotiating an immunity agreement. I then let Mr. Christopher know that after all that had transpired and we were litigating in Chancery Court, that Mr. Austin had unfortunately taken his own life. He was now deceased, and that I had been contacted by the defense team for Zach Adams with an inquiry as to whether or not I could possibly be one of his attorneys.
And what did you advise the board as to Zach Adams and what your role would be and how his case related to Shane Austin?
Well, what I advised the board and what I had been, information I had received from the defense team was that essentially there would be a consistent defense theory at play in trial.
And what does that mean, consistent defense theory?
Essentially, from what I understood from speaking with you initially, that your argument on behalf of Zach, and therefore Zach's argument, was that not only was he innocent of this, they were all innocent of this.
Okay.
Including Shane Austin.
Okay. And so then, did you relate to them any additional information?
Not that I recall.
Whether Zach had been charged?
Sustained.
Did you relate to them any information about the status this case was in?
I did let them know it was a death penalty case that was currently pending with Zach Adams. I'll know who the other co-defendants were in the case, I believe, when I was discussing.
Okay. And then, based on that, what did you do next?
Well, I received an informal opinion from the BPR, which was provided to the court. That day I just received it verbally from Stephen Christopher, and the opinion was that there was a conflict of interest. My understanding of his opinion was that essentially Mr. Austin was...
Let me say the parties furnished, or they sent some emails, both sides, discussion of this issue and the opinion, which were forwarded to me by the staff attorney. I don't actually get emails directly from any of you. They either come to Sherry or they come to Susan Jones. But I was made aware of the email correspondence. So I didn't engage in the ex parte. I viewed emails that had been exchanged between the parties.
Yes. And I'd like to pass up to you a paper. And do you recognize what that is?
I do. This is a copy of the email inquiry that I ended up asking Ms. Laura Chastain to send me when I contacted them on January 18th. But it was generated, my understanding, by Mr. Christopher on November 23rd in response to my call.
Okay, so will you tell me then what happened? He gave you an opinion.
Yes.
And after he gave you an opinion, what did you do next?
I immediately contacted you back and let you know that I was cleared from the board's perspective. There was no conflict of interest, no issue related to my being able to engage in the representation of Mr. Adams. And so from that perspective, that I was able to proceed and also willing to proceed should the court see fit.
Now, do you understand that there's a difference between having represented someone in a criminal action versus having represented them in a civil action?
Yes, and that's one of the things that the Mr. Christopher made clear when I spoke with him, was that essentially it would almost be...
I don't object to what Mr. Christopher may have said in the telephone call between this witness, and we weren't present for it.
He says hearsay, all right?
Right, but
we've got the written email, which the court will consider. But what the prior conversation, he can say, which he already has. Right. We had it. I disclosed things. He said there was no conflict. We've already filed that.
Okay. But what do you understand after doing research and looking at the information is the difference between having represented someone in a criminal matter versus a civil matter?
Well, essentially my understanding upon review of the rules and what I considered before engaging in this case was, could I ever be in a position to take it in representing Mr. Adams that would be materially adverse to Shane Austin, my former client. Upon my review of the rules and under the current understanding of everything I've reviewed, the state is essentially in a spot where they cannot take any further adverse action against Shane Austin in a criminal matter because he is deceased. You can't, unfortunately, he's deceased, and you can't charge someone who's deceased with a crime. So my understanding of it from that perspective was that wouldn't be in play. There was no current concern about a conflict that's related to Mr. Austin. I also understood it based on the opinion that was rendered that I could not disclose any confidential information I gleaned through my representation for Shane Austin. And based on everything I reviewed and understood, my current representation of Zach Adams would not require me to do that.
Okay. And was it your understanding, what if at some point the defense team decided to go with a different theory that perhaps implicated Shane Austin? Would that have affected your ability to represent Zach Adams in this case?
I don't believe so, based on everything I looked at again, because the test is not, the test is based upon review of the rule, whether or not it would adversely affect the former client. And again, even if you, theoretically, even if Mr. Adams took that position, it still would not have been the rules of professional conduct because it wouldn't have an adverse effect on Mr. Austin.
Okay. And did you also talk with Zach Adams in this case?
I did, absolutely.
And did you discuss with him your representation and the fact you had represented Shane Austin?
Absolutely, and I discussed that with Mr. Adams, and I discussed that with you as well. And the sole purpose of that was almost, from my perspective, was a belts and suspenders type of ideal to ensure that there was a conflict waiver signed by Mr. Adams. I wanted to, on top of, even though I don't think it was required, based on my understanding of the rules of ethics, I wanted to make sure that I had it. I wanted to make sure that he understood it and that there was no issue with that. So yes, that discussion.
And what I have put before you, do you recognize that?
I do.
What is that?
That is the conflict waiver that you provided me that was signed by Mr. Adams.
Okay. I'd like to make those two things exhibits.
They're attached to your pleadings. That is Exhibit B to your pleadings.
I guess my fear is, Your Honor, I'm aware of another case that went up on appeal, and the court said because it wasn't made an exhibit to the testimony, that something that's in the pleading doesn't meet the standard.
But that's in the pleadings up. We'll just send the pleadings up.
The pleadings will be sent.
I'm just trying to cover all the bases. Okay, so after you had received the opinion from the Board of Professional Responsibility, what did you do next?
Your opinion is Exhibit A. It's attached. Okay?
Yes, Your Honor.
After I received the opinion from the Board of Professional Responsibility and informed you of that fact, I waited to hear back because it was my understanding that you and Mr. Simmons were going to approach the court regarding the appointment in this case.
Okay. And at some point, then, when did you begin work on the case?
December 29th, if I recall correctly, approximately December 29th, December 30th.
And when did you file your notice of appearance in this matter?
I'd have to see the date on the notice of appearance, but I would say maybe January 7th rings a bell, but I couldn't be sure. Whatever date stamp filed on it, or whenever the email was sent.
Okay. And what happened after that?
Well, immediately upon being notified by you, Mr. Simmons, that I've been appointed subject to AOC approval by the judge, I began working because I knew that there was a trial date looming in April. Sent the notice of appearance out. We attended a discovery conference with Mr. Christensen and Mr. Hagerman and several members of the TBI, I think on the 11th and 12th of January. Worked through that. Sometime after that, I received an email from Ms. Nichols, Ms. Jennifer Nichols, saying that she had a concern about potential conflict.
And when you received the email from her, what did you do next?
I responded to Ms. Nichols' email, probably within a few minutes or a few hours, something to that effect, but on the same date, let her know that I had taken steps to ensure that there was no conflict of interest, that there was no issue, and that my representation to Mr. Adams didn't in any way have been the rule of professional conduct.
Then, as far as you know, what happened next is regarding you representing Mr. Adams?
I believe I received another email from Ms. Nichols. At that point in time, it said that, again, I think she stressed her overall concern, saying that she believed there was a conflict. That's not her exact words. And at that point in time, I contacted the BPR again. I believe that was January 18th. I contacted the Board of Professional Responsibility. On that day, I spoke initially with Ms. Laura Chastain, who forwarded me the inquiry on December 3rd, and then spoke again with Mr. Stephen Christopher. During that conversation, I let Mr. Christopher know that the concerns that had been raised by the state, I think I even read it into our conversation, emailed.
And I'm going to object.
What you're saying.
Oh, it's what you did, right? You're telling
Right.
He's also saying what the other party responded.
He can say what he did, but
Well, just tell us what you did.
I don't see Lewis, he could, we can't know what the response is.
What did you do?
I read in the email that Ms. Nichols had sent me.
So you made her concerns known to the Board of Professional Responsibility.
I did.
What happened after that?
The email that was forwarded to me by the BPR showing that no conflict existed.
Okay. And what was your next interaction with the prosecutors in this case?
The next interaction I had is when we left this discovery conference, we had been discussing several issues of deficient discovery or missing discovery, or that we couldn't put our hand, at least discovery that the defense is not going to get made aware of in some cases, or been provided. A list was then done by your paralegal who was present in the meeting and sent to the state, and I was again concerned about the upcoming trial date. Emailed out to Paul Hagerman to say two things. One was, hey, we just want to check status on the discovery. Where are we on that? The second part of it was to inquire about any proffer statements that they had received from Jason
I'm going to object at this point. I don't see what getting off. The purpose of this hearing is whether or not there's a conflict.
Right.
And we are well beyond that. I sat silent for a minute to see where we were going, but I think any conversations that we now have crossed over.
Concerning discovery, anything else is irrelevant.
Well, but I guess but I'm just trying to outline the facts as I have them in my motion as to what led up to us having the telephone conference and him being disqualified. So what I was wanting him to, get to is just what Paul Hagerman had said to him, and then what he did from there, how we came to have the telephone conference.
And, Your Honor, the discovery issues has nothing to do with how we came to have the telephone conference. And actually, those emails are also attached to the state's filing this morning so that Your Honor would have benefit of those. But I still say it's hearsay and it's not relevant to whether...
I don't see relevance.
Okay. So then let's just go to the telephone conference. You were a party to the telephone conference?
I was.
And in that conference, was there anything, any new issues raised or new facts raised in the conference that would justify you being conflicted out?
I'm going to object, Your Honor, since it's not his opinion about whether he's... the purpose of the phone call was to voice
Let me
opinion.
say, I didn't let either side argue anything that day. I said that upon further reflection, I reached a conclusion that he could no longer ethically be part of the representation. That just based upon facts that I knew essentially from his prior representation concerning the fact that for all intents and purposes, he was representing a fourth co-defendant.
Okay, so
But I think both parties will agree, I didn't ask the state for anything further, nor you further.
yes, that's, I guess, the point that I was trying to put in. And so then no further questions, Your Honor.
All right. Cross-examination.
Mr. Evans, I was trying to write down the items that you said that you provided to BPR when you called, and I wrote down, she advised them that you had previously represented Shane Austin, correct? You said yes.
Yes.
That you had advised them that you had engaged in a proper and immunity discussions.
Yes.
And that would have been with both the assistant district attorney handling the case as well as special agents with Tennessee Bureau of Investigation. Now, that any discussions with Beth Boswell, president, the actual proper.
She was not present.
President, the actual proper, a number of special agents.
Oh.
Correct?
Yes. Yes.
Did you advise them that you had filed a chancery action?
Correct.
And that was upon Beth Boswell, Hanson McAdams' determination that your client at the time, Shane Austin, had not been completely forthright and honest.
Can you repeat that? I'm sorry.
You filed a chancery action to enforce the immunity agreement when Hanson McAdams and Beth Boswell withdrew their offer of immunity.
Correct.
And they withdrew that because, in their estimation, as is evidenced by correspondence from them to you, that they did not believe that he was completely honest and upfront.
That's correct.
Okay. And you told the board that you had discussed this case with Beth Boswell.
That's correct.
And you told the board apparently that it was a death penalty case.
That's correct.
You did not, however, because Ms. Thompson asked you, was there anything else? You told them anything else? You said no. So you didn't tell them that Shane Austin said that Zach Adams told him that he, Zach Adams, killed Holly Bobo. That wasn't in the list of things, correct?
Back up again. You're going to have to repeat the question.
All right. I will back up. 2 questions. Ms. Thompson specifically asked you whether the list of items that I just read were the sum total of what you discussed, what you provided to BPR. You said it was.
I don't recall giving that answer as a conclusive answer.
Well, yes or no, you said yes, so you're saying now that's not conclusive?
I'm saying that.
Robert, I didn't ask that question. I didn't say, is that all you told them?
Well, she did.
Is that all you told them?
No.
Okay, so.
Yeah, I mean, it depends on which day. I talked with them in Arizona on the 23rd. Then I spoke with them again on January 18th. So
In any conversation with BPR, did you advise them that your client, Shane Austin, told 3 special agents with the Tennessee Bureau of Investigation that Zach Adams killed Holly Bobo?
Not those words, I think.
Okay, thank you. Did you tell? No, that's not.
He's allowed to explain. Answer yes or no, and then if you wish to make explanation.
What I told them was that during my representation of Shane Austin, that he did in fact commit a fraud, where he made statements that implicated Zach Adams. Absolutely.
Okay, well, that's what a proffered immunity, that wasn't my question. So my question was, did you actually tell the Board of Professional Responsibility that your client, Shane Austin, said Zach Adams killed Holly Bobo?
I wouldn't have said that.
Okay.
I don't recall him saying that.
You wouldn't recall that?
I wouldn't. I said I would not have said that because I don't recall my client Shane Austin saying that during the proffer round.
And you didn't, I assume, tell them that your client, Shane Austin, told you that Zach Adams said he put her in the river next to a rock that had an orange T painted on it.
I wouldn't have specifically said that, no. I didn't, no.
Your Honor, I object. Ms. Nichols is mischaracterizing what was said in the proffer.
I'm sorry.
Shane Austin did not say...
She's allowed to ask the questions if you want to re-examine.
She's mischaracterizing what was said in the proffer for the court. That's not what was said in the proffer.
Go ahead.
Your Honor, I'm reading from a report, and have spoken to the agents and have spoken to Ms. Boswell. I assure Your Honor, now, as in every other time I've appeared before you, I don't misrepresent what I believe to be the truth based on the evidence in front of me.
All right.
This is important, and I want to know what the board had in front of them when they issued or confirmed the defenses were similar. Because it seems highly unlikely that Mr. Evans may actually advise him of this.
He didn't say similar, he said consistent.
Consistent.
All right.
So that's no, you said you didn't tell him that.
None of those exact words, because.
Okay, in any other words?
Your Honor, if I may have the opportunity to complete my answer.
Go ahead.
I wouldn't have told them specifics, number one, because I didn't have the benefit of that report or the specific recollection that you're able to recall reading a report that I didn't have the benefit of when I called the video.
So if you didn't have the benefit of the report, you have the benefit. You are the person who, in the course of this proffer, assisted the special agents in getting a handwritten note from Shane Austin that implicated Zach Adams. Surely you have recollection of that.
I do.
And did you list for the board the 5 statements that Shane Austin wrote on his handwritten note?
No, because I didn't have it before me, but if you would have emailed it to me, I would have been glad to discuss it with the board at any given moment.
And you'd agree with Mr. Evans that the state would have no way of knowing that you were trying to have yourself put on this case?
No, I mean, when you emailed me on the 18th or the 16th, if there's anything you wanted me to let them know, I would have been glad to do that.
So Shane Austin told you that Zach said, I will make you disappear like I did that girl. That's what he wrote, right? In your presence.
You can tell me.
That's what he wrote in your presence during the course of the proffer.
Can I take a look at that?
No. I mean, I'll pass up in a minute. I want to see what you remember.
I don't know.
Okay. Do you recall that he said that he wrote, I had her chained up in the back and called Shane to, please excuse me, Your Honor, fuck her. Remember that one?
What I recall.
Wait a second. I don't want any disturbance out there.
No, I don't recall that being said.
Do you recall Shane Austin writing in your presence and you providing it to TBI? You have to gut them so they won't float.
What I recall in that interaction, ma'am.
And I'm going to ask you to answer yes or no and then explain as the
recall
judge.
that specifically, because, no. Because that's not what I said.
Do you recall Shane Austin writing in his own handwriting that Zach said, I put her by the teeth in the river. They'll never find her there.
I do recall that, yes, ma'am.
Do you recall Shane saying, Zach said, no body, no crime?
I do recall that.
So those items, the ones that you recall today and the ones that you don't, were not provided to the BPR when you spoke to them, correct?
Not specifically in those words. What was provided to the BPR was me running through factual scenarios like, if my former client absolutely said that the current client had admitted to doing it in certain times, in certain places, would that in any way affect my ability to engage in representation of the current client if my former client was now deceased? I think that pretty well covers all those statements, but it would have to be an accurate reading of those statements still.
And you would agree that the email that you received from BPR says the caller confirmed. You're the caller, right?
Yes, ma'am.
So Luke Evans confirmed for the Board of Professional Responsibility that the legal and factual positions of the former client and prospective client with regard to the criminal allegations are consistent.
Correct.
So despite the fact that you were present for this proffer, and despite the fact that you were present when your client at that time wrote those 5 things about the person you now want to represent, you confirmed for BPR that that was consistent?
Absolutely. Their positions, from what I've been informed from the defense team, are absolutely consistent.
And you were present during the telephone, of course, when the judge disqualified you from continuing to represent Zach Adams, correct?
Yes.
You heard him make statements, of course, about the appearance of impropriety or conflict of interest with respect to the public and the public's, in the family, and the public's confidence in the judicial system.
Yes.
Okay. And would it surprise you to know that this family and these friends of Holly Bobo would have a significant problem with you representing Shane Austin and then now representing Zach Adams? Would that surprise you? Because that's the public.
Well, it wouldn't surprise me. I can't begin to imagine what those ladies and gentlemen have endured. That wouldn't surprise me. But that's not the legal standard. Appearance of impropriety is not the legal standard here.
And I appreciate you trying to educate us, but that wasn't my question.
Under what?
You understand my question?
I answered it, ma'am. You need me to explain it?
No.
Okay.
You answered affirmatively. Do you agree with me, or you wouldn't be surprised?
But I said, look, I can't imagine. I can't begin to imagine it. No.
Have you ever had a death penalty case? Ever tried one? One. Sorry, what'd you say? Have you ever tried
I haven't
one?
said anything yet. I previously handled a death penalty case that...
I'm sorry, that wasn't my question. Have you ever tried a death penalty case?
No, ma'am.
Despite never having tried a death penalty case, you're aware of the scrutiny placed on those cases in the event of conviction down the road. Correct?
Sure.
You've read about that, I assume, since you haven't tried one.
And I've tried multiple homicides, and I'm aware of the heightened standard, and I've handled other death penalty cases.
But haven't tried one.
Luckily, they took death off the table before I went to trial.
You saw this waiver
I did.
that Ms. Thompson attached to her pleading. You recognize that as being her handwriting.
I did.
And you read it.
I have.
And it's your position, you're going to sit here under oath as an attorney and tell the court that you should stay on this case despite the fact that you guys got the defendant, Zachary Adams, to sign a waiver saying that there might be conflicts in the future. We don't know about them yet, but that's okay.
I don't understand your question.
What? You told us that in part you based the fact that you didn't think there was a conflict on the waiver and on the BPR opinion. Is that a yes?
Yes.
And so this waiver says, there may also be actual conflicts at some point in the future. I have discussed this matter with Jennifer Thompson and am willing to waive any conflicts.
Okay.
So in other words, what's his educational background? Zach Adams.
I don't know about that.
Right. And that might be an important thing to know when you obtain this kind of a waiver from somebody, right?
Well, I didn't obtain the waivers.
Now, I'm just asking because you said you handle so many cases.
Sure.
And so if a person doesn't understand what they are being asked to sign and what they are waiving away, that would be a concern, wouldn't it?
No, absolutely. If it was in fact the case that the person didn't understand, sure. That would be a concern.
How many capital post-convictions have you done? Do you understand that this waiver, Mr. Adams agreeing that he's waiving things in the future that he doesn't even know about, would not stand over the course of time when looked at in the post-conviction arena, separate and apart from your BPR clearance to proceed? This is a different issue.
Are you giving me a legal opinion, or are you asking me a question?
That's a question.
You're going to have to restate it. I didn't never hear a question.
Do you understand, given your vast experience, that this kind of waiver would not stand the time when it's looked at later on if he's convicted?
I don't understand that, because I don't know that you can understand that either. Because we're not the courts, and we're not in the future.
So you don't know the answer to that question?
No, ma'am.
What about the drug?
I need to ask you, I've left some documents back there. Is that proper that you've been referring to? I either need that in exhibit or I need it attached to pleadings.
I'll get you a clean copy of this.
Okay.
It's attached to a pleading. I have something circled on mine. I'll get a clean copy of it. And you should have it, but I wouldn't want you to have to sift through the hard drive because it's IR.
Let's just file it as an exhibit.
Okay.
One.
Phone number, Joe. What the question? In the board opinion that you shared with us, it actually says that that opinion is not binding on any court, correct?
Absolutely.
Or anyone else, for that matter.
That's correct.
It doesn't afford you protection either.
Nope, it does not.
Your Honor, I've got the hour, but I just want to get a clean copy that's not circled. But I'll go ahead and file it, and maybe I'll substitute. We show it to the defense counsel's got a couple things circled.
I think we got a clean copy. We found it.
And it has an attachment.
Right here. Hand that to her. See if that's.
That's the attachment to the proffer.
Okay.
The actual proffer that Ms. Thompson was indicating.
Well, the attachment was what you were reading from.
Actually, I was reading from both, Your Honor.
All right.
Let me pass forward.
I've got it. Let's.
I don't think that's what she has. That's not what. No, sir. That immunity agreement we discussed, but I'm passing forward. That's what I was reading from the part.
It's got some markings. It makes no difference to the court. The handwritten was attached to the to this. All right. Then that'll be Exhibit 1.
Nothing for you, sir.
Yes, I'd like to see Exhibit 1 if I could, please. Now, would you agree with me that saying somebody killed Holly Bobo and saying somebody said they killed Holly Bobo are two different things?
They are.
Okay.
Your Honor, I'm going to object to relevance to whether.
No, let her go. Let her go.
And so when Shane Austin went in to give his proffer,
he specifically told the TBI that he never believed that Zach Adams had actually done those things.
If I recall.
He was telling the TBI what he had heard Zach Adams say before.
Yes, that's correct.
And the statement, if you look at this IR report, the statement that he made about having Holly chained up, Shane Austin said that Zach Adams said that in a bar. Isn't that right? And Double D's or Johnny's?
I'd have to look at the report and see what it says.
I'll just pass it to you and refresh your memory.
That's correct.
I just want to refresh your memory on the whole thing, and then I can ask you more questions about it.
Your Honor, can we have a sidebar conference, please? Judge.
Yes.
Would you like here?
Let's go back there. I'll have the court reporter join us. All rise.
We're watching the pre-trial hearing of Zach Adams. He has been indicted with the rape, kidnapping, and murder of Holly Bobo. Jury selection begins in this case on Monday. 2 other co-defendants have been indicted. That's John Adams, Zach Adams' brother, and Jason Autry, a friend of the 2. There's a lot of twists and turns in this case. It's taken 6 years for the Zach Adams case to be in the courtroom, with jury selection commencing on Monday. This was a very high-profile case in a very small town. Jury selection will certainly prove to be challenging. I'm joined here by Nicole DeBord. She's a criminal defense attorney. Nicole, there are so many issues in this case that we've seen prior to the trial. So one thing is we don't really know what's coming. So let's review some of the information that we have, because the media has kind of dipped in and out of this for the past 6 years. So right now we know this is Zach Adams' trial. We know that his brother at one point, there is a confession. That confession is being retracted. We anticipate the defense is going to argue that there was coercion there. We also know that the word is Jason Autry, who was also indicted with the same charges, may be taking a plea deal. How much does this matter? How much do these witness accounts matter when you're talking about a circumstantial case?
Well, they matter a lot, because the reality is that it's all about witness statements in this situation. There is no evidence of any scientific nature typically in a circumstantial case. And so what they're going to be doing is relying on these witnesses to come to court and say, this is what we know happened, or this is what we heard someone say happened. And the jurors are going to have to decide whether or not these witnesses are credible. So having access to a defendant, for example, who's been accused of this crime, who's now pleaded guilty, will be extremely helpful to the government, to the prosecutors, because they're going to be looking to him to provide a statement. Now, on the other side of that, the defense is going to have the argument, which is a legitimate one, that whatever this guy says is tainted by the notion that he is going to be getting credit for it and getting a lighter sentence depending on how great he testifies for the prosecution.
Right, and that's definitely the issue, and the defense will go crazy on that. And we've seen that in some of the other cases we've covered here on Law News. The fact that somebody might be getting what some would view as a sweetheart deal in exchange for that testimony, and you see it very frequently in cases where you've got people accused, co-conspirators, co-defendants, that everybody points the finger at each other. And that will be an issue for the jury to decide whether or not that overcomes, that fact that they are getting a deal overcomes their credibility as to the facts. Another interesting piece of this puzzle, apparently there is a jailhouse confession a cellmate of Adams, Benjamin Lee Hendricks. It's anticipated that he will testify that, or the prosecution would like for him to testify, that Adams at some point had detailed some of the crime to him while they shared a cell in the Williamson County Jail. How far do you think that will go? I mean, you've got a credibility hurdle right there, of course. I mean, this is somebody who's already in jail. Could they be bartering some sort of deal or special treatment in order to come forward with this story?
Absolutely. In fact, inmates know that one of the best pieces of currency that you can get is information. And inmates will oftentimes trade on what they can learn about a cellmate's case. So it's very dangerous, for example, for cellmates to have their paperwork from their trial, their indictment, copies of reports, any information that oftentimes an accused will think they want is an extremely dangerous thing to have in custody, because the guy sitting next to you is certainly interested on little pieces of information that he can use to string together a plausible story that he can sell to the prosecution to get a better deal in his case. So I am extremely suspicious of cellmate confession stories, because they're almost never reliable.
Right, and we know that, listen, this guy's in jail, but that doesn't mean he's cut off from all media. And there certainly was a lot of media attention on this case, and perhaps some of those facts were learned a different way. Certainly the defense will point that out. And very often when you do have these jailhouse confessions or these cellmates who come forward, many times the credibility can be can come down to whether or not that's consistent with other forensic findings. All right, so this cellmate says XYZ happens. Well, that's not really in line with what we found here in this particular case, so it discredits or credits their testimony. But here, the forensics are very sketchy. We're talking about a body that was found 3 years later, so that may also be a factor.
Exactly, and it's scary, because the reality is that the prosecution gets excited oftentimes when they have these kinds of statements provided by these witnesses, and what they have to keep in mind is that they are selling very inherently unreliable information, and there is real risk that they are buying into something and that a jury could buy into something that is completely self-serving on the part of the witness who claims to have heard the information.
So from a strategy point of view, taking all of that into consideration, so we anticipate that we're going to see information about this alleged jailhouse confession this witness is going to testify. But given the fact that you have a confession, again, granted, this is from Zach Adams, his brother. Granted, we know that that's going to be contested. They're going to try and get that thrown out, no question. But now you also have potentially a confession and damaging testimony of Jason Autry. Do you even need this other guy? Do you need the jailhouse confession if you have the two other people charged with the crime who are pointing the finger at one guy?
That's a great question, really, because I think that's something also the prosecution always needs to be careful about. When they start piling on and the sources of the information that they're bringing to the jury come up consistently biased and motivated by some angle of their own, they start to look dirty. So the prosecution has to be really careful about offering snitch testimony repeatedly. And the confession that they are hinging their case on is really a statement by a snitch. It's this brother that can't stand the accused, that was in custody at the time and serving out his own sentence, hoping for leniency in his own cases, when he claimed that his brother confessed to him. So this case already relies entirely upon snitch testimony. Piling onto that with more self-serving snitch testimony may not serve the prosecutor well.
And that's such a great point, and that really can be the case, because as a defense attorney, you can turn that around and spin it and say, look, the prosecution is going to every Tom, Dick, and Harry trying to pin it on this guy. We understand that, of course, you want to see justice for a victim, but you want to see justice by the person who actually committed this crime, not just find a scapegoat. And that's a very easy flip when you're talking about every single witness having a real stake in this game.
Exactly. You know, and the deals that these witnesses oftentimes think they're going to receive or may actually receive are entirely contingent upon them testifying the way they originally reported whatever they reported to the prosecution. So a lot of times the prosecution can say to a jury and will say to a jury, well, you know, we haven't offered him anything yet, but don't you know that that snitch knows that if I do what I told the prosecution I was going to do, I'm getting something in return. They always believe that. And that is a dangerous situation because it's very difficult for the defense to say and cross-examine them about, you know, have you received anything in return? Well, not yet, but they're expecting it. And they know that to get it, they need to testify consistently with whatever they claim to begin with.
Right, and that's not going to be lost on a jury. Those are going to be the points that the defense is absolutely going to bring up. I mean, those are critical points for a defense attorney. So turning back to another pretrial issue that we have in this case, obviously we don't exactly know what we're going to see during the course of this trial. We don't know who's going to be sitting in that jury box. We know it's going to be tough to pick an unbiased jury here. But what about an unbiased judge? So the defense had requested that the judge recuse himself from this case. This is based on a couple different factors, one being an ex parte conversation the judge had with the prosecution. The other, and I want to read the exact words of the statement the judge made to the parties, and this was after Autry had Autry's anticipated testimony, so let's put it that way. So the judge said, after Autry's finding out about Autry's anticipated testimony, if I were representing Zach Adams, and based on new developments in the case and what the court has been led to believe, if I were Mr. Adams' attorney, I'd be beating down the prosecution's door to negotiate a deal. Now, the defense obviously said this looks to me to be a pretty clear-cut case of the judge already having a preconceived notion of the defendant's guilt, and asked the judge to be recused. Of course, that recusal is reviewed by the very same judge. Ultimately, the judge said he was going to stay on the case. But what do you make about all of this? Because that's a pretty damaging statement.
Sure, and it tells us a lot about where this judge is starting out. He already has these preconceived notions, which he's said, this is how I feel about the case. And the reality is that in criminal court, even when we're dealing with a very, very sad case like we are in this circumstance, a very well-loved victim, somebody killed her, and everybody wants justice for her. There's no question about it. But a criminal courtroom is entirely about the defendant. It is not about the decedent. It is about the accused. And it is about making sure that the accused gets due process. And you're supposed to start out in a criminal courtroom with the defendant, for that reason, actually having the advantage or the presumption of innocence. And when you have a judge who's supposed to be presiding over that as a gatekeeper, determining what evidence comes in and what evidence stays out, and that judge is already saying, I'm not starting the defendant out ahead. I think he's at a disadvantage and that he ought to be working out a deal. That is terrifying to the defense for good reason.
Absolutely. I'm really, the wording, when I read the exact quote, because we were talking about this earlier today, and behind the scenes here at Law News, we're talking about this issue all the time because we think it's really interesting. This judge is really acting as almost an attorney. He's giving legal advice to this defendant, saying, well, you should probably get a plea deal because based on, and I think this wording is so interesting, based on what the court's been led to believe occurred. I mean, isn't that premature? Don't we have a trial for that purpose with a jury of your peers to make a determination of fact about what occurred?
Exactly, and it speaks to how credible this particular judge believes this alleged confession may be. And, you know, it is normal for a judge to start to learn things about a trial before the trial happens because both sides may file motions asking for information or asking that information be kept away from the jury. And so the judge does have to make decisions about whether or not certain information is reliable enough to get in front of that jury. That said, making a determination about how that evidence may ultimately make the case end up is not appropriate. And we want to make sure in every single criminal trial that the defendant is the one with the presumption of innocence and that that remains until a jury decides otherwise.
Right. I mean, innocent until proven guilty, right? It might be said time and time again, but that really is where this trial should start. As far as this is concerned, we don't know necessarily here sitting in this chair whether or not there's been an appeal of that determination. I know in New York it's the same process. You would go to the judge first. The judge would say yay or nay. Sometimes if there is some clear bias, family member, something like that, they may step down. Oftentimes it's difficult to ask a judge to make a determination on what is alleged their own wrongdoing. And that's what we really have here. What happens next if there's an appeal? What's the recourse here from the defense attorney perspective?
So typically what would need to happen is that a judge for an administrative region or for a region that controls a group of judges, there's usually one judge that sort of oversees a sector of judges. This judge should ultimately review the information put before the court that tends to show some sort of bias on the part of the judge, and make a determination as to whether or not there's been enough bias shown that this particular judge should not be sitting in this particular case. Doesn't mean that the administrative judge would be making a determination that this is not a good judge or in a broad sense not a fair judge. It just may be that this judge is not the right judge for this case. So an independent review should happen. Now, if it doesn't happen, what needs to take place is those defense attorneys need to put in the record, whether it's under seal or for public consumption, likely under seal, all of the specific reasons why this judge should not hear the case and why they believe that he is biased and that deprives their client of due process. And then later, if this judge still is not recused, a court of appeals can make the determination about whether or not there was an issue here.
Yeah, and so let's do a hypothetical. Let's go back to law school for a minute, because say that's absolutely what you need to do: preserve from a defense perspective. Now, let's say hypothetically we get to the end of trial. This judge stays on the case. The defendant there's a conviction. And obviously the defense is going to try and appeal that conviction. What's the standard here? Because it's a pretty stringent standard. I mean, they would really have to go back and show that there was some bias that ultimately was a significant factor in the outcome of the case. So that would really be contingent on what happens throughout the trial, correct?
Yes and no. If there's such a bias that is shown by whatever information the defense has been able to gather, and certainly statements like the ones you've described may be enough. If the defense is able to collect those statements and show before this judge ever heard anything in a trial, he had decisions made and his mind made up about whose side was more credible, that may be enough to send a case back to starting over. And so really it's not so much always a question of whether or not his bias actually led to bad decision making. The real question is, was there a bias such that he should have never been making those decisions in the first place?
Right, and that will really be the issue. And I would think, as you said, just because a judge recuses themselves from a case, that has nothing to do with the fact whether they're a good judge or they've made other great determinations in the past, or they're fair or they're honest. Not at all. It just means in this particular set of circumstances, this is not the person who should preside over the case. And perhaps that's for many reasons. It might be a legal reason. It might even be to just preserve that, hey, we're going into a trial unbiased. We want to preserve the sanctity of this trial.
Right.
And so it's going to be interesting to see. I mean, the judge right now, as far as we know, we're moving forward. This is going to be the judge on the bench.
Right. I think you make an excellent point. Sometimes it's not so much whether there's a circumstance where there's actual bias, but the public really depends on our justice system being unbiased. And certainly the public needs to know that whatever happens in a court of law is happening for legal reasons and for justice reasons, and not for any other personal reasons that come from a place of bias. And so really what should be happening, as you have already pointed out, is that if this judge believes that there could be a public perception that anything else is occurring other than justice and just plain fairness, someone else needs to hear the case. And whether that's an earned perception or not is really not the question. The question is, how's this going to look? At the end of the day, is whatever happens in this courtroom going to look like justice? And that's a real valid concern.
Absolutely, especially when you're talking about a small legal community. That matters everywhere. But in a small community, in a small town that doesn't see a case like this, I mean, this is something that you're not going to see too often in this jurisdiction. So it's really critical that everybody comes from a place of, hey, this is a fair and unbiased trial. So just to circle back, we're going to transition into Casey Anthony, but before you leave me, Nicole, I want to ask you a couple questions because there are a couple similarities here in what we know right now. Again, of course, I'm the biggest proponent of it's the onset of trial. We don't really know what we're going to see. The tides could turn. We've seen attorneys make an opening statement and then take a totally different path as the trial proceeds. You never know what's going to come out. But what we do know is that there is an uphill battle in some circumstances when you have a circumstantial case. Casey Anthony is a prime example of that. No matter what you think about the outcome that the jury came to, the acquittal back in 2011, that was a difficult case because no one could ever point to what caused Caylee Anthony's death. And many of the jurors in interviews afterwards, obviously this story took America, captivated everyone in the nation. Many of the jurors said that that was a huge piece of the puzzle, why they could not convict her.
That's exactly right. I mean, the defense's job, really, their first job, is going to be separating emotion from fact, as you've pointed out earlier as well, because everybody wants justice for this poor woman who was killed. But this is a criminal courtroom, and again, these are about the rights of the accused. And anybody who is going to be a juror in this case has to set aside the heartbreak and the emotion and needing to get something for this poor woman who was killed. That has to go somewhere else. This is a courtroom about what can the government prove actually happened. And there are big similarities. The defense has a big job to start out with, finding out who can actually put those kinds of emotions aside and make fact-based decisions.
Absolutely. Nicole DeBorde, excellent commentary today. Thank you for breaking this case down with us. Hopefully we'll see you again as the case unfolds after we have jury selection next week. We'd love to have you back.
That sounds great. Look forward to it.
Fabulous. So right now we're going to turn the tables. We've been talking about Holly Bobo, the Holly Bobo trial set to commence next week for most of the morning. But now let's revisit a case that no one can ever forget. This is Casey Anthony. We're going to turn to the opening statements in the Casey Anthony trial now.
According to a neighbor by the name of Brian Burr. Brian Burner didn't see Caylee Anthony. Again, Casey Anthony told her mother, Cindy, that they would be spending the night again with Xana. She spent the night with Tony Lazzaro. Tony Lazzaro will testify. Caylee wasn't there. So on Tuesday, June 17th of 2008, where is Caylee Marie Anthony? Day 3, Wednesday, June 18th. Again, cell phone records established that Casey Anthony was in the area of Tony Lazzaro's apartment until about 12:30 in the afternoon. From 12:30 until 1:15 or so, Casey Anthony is attempting to call the house or her parents. Brian Burner, the neighbor, sees Casey Anthony again. Backs her car into the garage. And at about 1:30, 2:30 in the afternoon, asks Brian Burner if she can borrow a shovel. He will testify that she had the shovel for maybe an hour or so and returned it He didn't notice anything unusual about its condition. George Anthony worked that day from 3 to 11 p.m. Cindy Anthony, again, inquiring about the whereabouts of her granddaughter, who had spent no more than a day away from her grandparents' home in her life. Casey Anthony told Cindy, her mother, that she was going to be at a conference in Tampa for work, and that Kaylee would be with Zanny and two other people, Juliet and Annabelle. Casey Anthony's story grows. There is no Zanny, there is no Juliet, there is no Annabelle. Casey Anthony spent Wednesday, June 18th with Tony Lazzaro that night. Tony will say Kaylee wasn't there. So on Wednesday, June 18th of 2008, where is Kaylee Marie Anthony? Day 4, Thursday, June 19th, 2008. George Anthony typically didn't work on Thursdays at that time. So there is no indication in Casey Anthony's cell phone records that she came back to the house at all. The cell phone records established that she was in the area of Tony Lazzaro's apartment for a lengthy period of time, traveling away from the apartment, and ultimately you will hear the testimony of an individual by the name of Matthew Chris, who will indicate that on that day, Casey Anthony was looking for apartments for her boyfriend, Tony Lazzaro. Matthew Crisp and Tony Lazzaro didn't see Kaylee Anthony that day. Casey Anthony was back at Tony Lazzaro's apartment by 9 o'clock that night. Kaylee Anthony wasn't. So on June 19th of 2008, where is Kaylee Anthony? Day 5, Friday, June 20th, 2008. Again, because of his shifts, George Anthony is not working on that date. Cindy Anthony wants to know, question that at this point everyone wants to know, where is Kaylee Anthony? Casey Anthony tells her mother Cindy that she is still at a conference at Busch Gardens in Tampa, and that it's going to go over into Saturday. On Friday, June 20th, Casey Anthony went to a club called Fusion with her boyfriend, Tony Lazzaro, and entered or participated in a hot body contest and was photographed at the hot body contest dates. Kaylee Anthony wasn't there. Kaylee Anthony wasn't at Tony Lazzaro's. Kaylee Anthony wasn't with her grandmother, Cindy. So where's Kaylee? Day 5 and day 6, the weekend, June 21 and June 22 of 2008, Casey Anthony did not return to the area of her parents' home, according to her cell phone records. But Cindy, her mother, kept pressing, where is Kaylee? We're still in Tampa. boyfriend's roommate, a girl by the name of Maria Kish, who's at Tony's, says to Casey Anthony, "Where's Kaylee?" Casey Anthony tells Maria Kish that Kaylee is at the beach. On Sunday, Cindy continues to press Cindy Anthony. "Where is my granddaughter? I want to see my granddaughter. Where is she?" Casey Anthony continues to tell her mother a lie about being in Tampa, about being in Busch Gardens, that the conference that she was at went late, that they decided to stay over at the hotel and then go to the park, Busch Gardens, on Sunday. Adding facts, adding details, trying to get her mother to believe that this is where she is and that Kaylee is with her. Day 8, Monday, June 23rd. Casey Anthony's cell phone records, you will hear, show that she is at Tony Lazzaro's apartment until about 1:30 in the afternoon. That the cell tower records show that she did head in the direction of her parents' house at about 2:30 that afternoon. Phone records show that Casey Anthony calls her boyfriend Tony Lazzaro about 2:45, saying that her car had run out of gas. Tony finds Casey, and Casey Anthony takes him to her parents' house, where they break into the shed and take her dad's gas can. Again, as you might imagine, Cindy Anthony is still inquiring about her granddaughter. Where is Kaylee? Casey Anthony spoke with her mother about 5:30 that afternoon and now adds another detail. Zanny was in a hospital in Tampa because she was in an accident on I-4. And that Kaylee is with Juliet and Annabelle at a hotel while Casey Anthony tends to Zanny at this hospital in Tampa. You will hear, and we know from Casey Anthony's cell phone records, she wasn't in Tampa. She was at her parents' house taking her dad's gas cans with her boyfriend. Day 9, Tuesday, June 24th. George Anthony decides he's going to mow the lawn. And he goes to his shed where he keeps his gas can and his lawnmower, and he sees that the lock is broken. So George Anthony contacts the Orange County Sheriff's Office that somebody broke into his shed. And he fills out a statement for a deputy that came, goes and tells the neighbor, Brian Berner, or Brian Berner's son, that there's a vandal, that there's somebody stealing things in the neighborhood. Basically, keep a lookout. While George Anthony may have normally been at work that day, he ended up having an interview for another security job at 6:30 that evening, so he was at home. And at about 2:30, Casey Anthony shows up. No Kaylee. No Tony. Just Casey in her white Pontiac Sunfire. Her dad is happy to see her, wants to know where Kaylee is. Tells Casey, I miss Kaylee, where is she? I'd like to see that little girl. We miss her. And Casey Anthony dismissively says, I have 10 minutes, I have to get back to work. George Anthony has an idea that the missing gas can may be in his daughter's possession. So he tells her he needs something from her car. And that he's going to go get it out of the trunk. At which point she brushes past him, goes to the trunk of the car, takes out the gas cans, throws them or pushes them in his direction, and says, here's your fucking cans. Gets in her car and leaves. Immediately starts calling her mother about it. On that day as well, you will hear from the testimony of another of Casey Anthony's friends by the name of Troy Brown, who received a Facebook message from Casey Anthony that she hasn't been at her parents' house for the last 9 days because of trauma. Day 10, June 25th of 2008. Casey Anthony begins to tell her friend Amy Huizenga that there is a smell in her car, and it seems to be coming from the engine. Cindy Anthony, as you might imagine, continued to ask for her granddaughter and was told we're still at the hospital. Day 11, Thursday, June 26, 2008. You will hear that the cell phone records of Casey Anthony show that she was at Tony's all day. No Kayla. Where's Kaylee? Again, Cindy Anthony presses, and Casey Anthony tells her that Zanny, this babysitter, was released late from the hospital. We're going to spend another night at the hotel. You've heard that before. Day 12, Friday, June 27th of 2008. You will hear that Casey Anthony's cell phone records show that around 11 a.m. that she is in the area of her parents' house on Hope Spring. And that she spent about half an hour in that area. And that shortly after 11:30 that morning, she begins to text Amy Huizenga, her friend, about a dead animal being plastered to the frame of her car. Within minutes of that text, Casey Anthony's white Pontiac Sunfire runs out of gas again. This time at an Amscot on University Boulevard in Orlando, next to a dumpster. And so you will hear that Casey Anthony calls Tony Lazzaro, her boyfriend, to come get her. He does, and when he does, she has with her what appears to be grocery bags full of either clothes or items from a refrigerator, someone's refrigerator. No Caylee Anthony. You will see that video was taken of Casey Anthony and Tony Lazzaro at a JCPenney's on June 27th of 2008 at 2:51 p.m. Tony will tell you that he thinks she bought some shoes. Because that night, they went back to Fusion. Cindy Anthony, pressing her daughter, wants to know where Caylee Anthony is. At this point, Casey tells her, well, we're back in town. I have a late meeting. I'm going to meet up with Jeff Hopkins. He's in Orlando, and we're going to stay with him at the Hard Rock Hotel. Now, there is a Jeff Hopkins that is an acquaintance of Casey Anthony, except that he wasn't in Orlando on June 27th, and he wasn't at the Hard Rock Hotel. And he didn't have contact with Casey Anthony. Jesse Grun, you will hear, is a former fiance of Casey Anthony who had contact with her that day. He inquires after Caylee, and she tells Jesse Grun she's with the nanny. Amy Huizenga inquires about Caylee, and she tells Amy Huizenga that Caylee is at the beach. So on Friday, June 27th of 2008, where is Caylee Anthony? Days 13 and 14, Sunday, June 28th and June 29th, the weekend. Again, Casey Anthony is telling her mother she's at the Hard Rock Hotel. Her cell phone records tell a different story. She's at Tony's. They're going to the movies. They rent a video at Blockbuster. Day 15, Monday, June 30th of 2008, Tony Lazzaro had a pre-planned trip to New York, where he's from. So Casey Anthony takes him to the airport, and he allows her full use of his car. Hers is still at the Amscot, where it's been since Friday, next to the dumpster. But not for long. The manager at Amscot, you will learn, call the tow company, because this car is sitting in their lot next to the dumpster and no one's come to claim it or get it or say anything about it. So Johnson's Wrecker, a local tow company, comes and tows Casey Anthony's white Pontiac Sunfire to their lot on Narcoossee Road in South Orlando, where it stays until July 15th of 2008. On June 30th, while Casey Anthony's and Tony's car and her car is being towed to Johnson Wrecker, she goes to Target with Amy Huizenga and is captured on video from Kaylee Anthony. She goes to the JCPenney's at Fashion Square Mall. No Kaylee Anthony on that video. She's back at Target before 9 o'clock that night. No Kaylee Anthony. Cindy Anthony, once again, pressing, pushing, wants to know, where is my granddaughter? And Casey Anthony tells her, again, that she's working late, and now Kaylee is with somebody named Jennifer Rosa, who is supposed to be a relative or a roommate of Zenaida, Zanny. And you will hear that Casey Anthony tells her mother, we're going to be staying with these people until July 3rd. And she tells her mother that Jennifer Rosa and Kaylee are going to go to Universal Studios. You will hear from the testimony in this case that the week of June 30th of 2008, all the way through the 4th of July weekend, Cindy Anthony was on vacation. And being on vacation, she wanted to spend time with her granddaughter, Kaylee, who at this point she has now not seen for over 2 weeks. So on Tuesday, July 1st, day 16, Cindy Anthony begins to insistently call Casey. On July 1st, with her boyfriend, Tony, now in New York, Casey Anthony doesn't have a place to stay. She's been staying with Tony for the last 2 weeks. So at 9 o'clock in the morning or so, she shows up at the apartment of her former fiance, Jesse Grunn, to take a shower. By 4 or 5 that afternoon, she's back at a JCPenney with her friend Amy. That evening, there are multiple calls from the Anthony household to Casey Anthony's cell phone trying to get a hold of her. You will learn that on that day, Casey Anthony went to the Ale House, which is a restaurant bar here in Orlando, with some guy friends she has. Cindy Anthony begins texting about where's Kaylee. And Casey Anthony tells her that Kaylee's at the park with this Jennifer Rosa. This pattern continues into Wednesday, July 2nd, day 17, where there were multiple attempts to call Casey Anthony from the Anthony home on Hope Spring. When Amy Huizenga asks Casey Anthony, "Where's Kaylee?" she tells her she's with a nanny. And while all of that is going on around Casey Anthony, she makes an appointment to get a tattoo. She goes to Ross to buy some clothes or shoes. She goes to a nightclub called Voyage, another one called Mako, and then ultimately spends the night at Amy and Amy's roommate Ricardo's apartment. You will hear from the testimony and the evidence in this case that on day 18, Thursday, July 3rd, Cindy Anthony has had about enough of this. Again, she's on vacation. She's making multiple calls to Casey Anthony. Since Casey had said Kaylee's going to be at Universal Studios at a character breakfast, Cindy gets in her own car and drives to Universal Studios. She wants to see Kaylee. And when she gets there, calls her daughter, "I'm here at Universal Studios. I want to pick up Kaylee," words to that effect. Casey Anthony says, "We're in Jacksonville." Jeffrey Hopkins, the guy that we were at the Hard Rock with, well, he's from Jacksonville, so we're going to hang out in Jacksonville for a while. You will hear from the testimony. Cindy Anthony is beside herself. That night, Cindy Anthony creates a MySpace page that she titles "My Kaylee is Missing," and writes a paragraph or more about her thoughts and feelings. Her Kaylee was missing. And again, while this is going on around her, Casey Anthony gets a tattoo, tells the guy at the tattoo shop that Kaylee is with the nanny. Sends a text to her ex-fiance, Jesse Grund, that if my family tries to contact you, tell them nothing. They're basically crazy. She goes shopping at the Florida Mall, which is in South Orlando, with a girl she just met by the name of Melissa England. While somebody at the Anthony home is trying to call her, trying to find her. Eventually, at about 8 o'clock that night, somebody at the Anthony home, Cindy, you will hear from the testimony, contacts her son, Casey Anthony's older brother, Lee. Lee Anthony tries to find his sister based on some research he did on people's Facebook pages, where he hears or reads or learns that his sister is going to be at a nightclub in downtown Orlando that night. So Lee Anthony gathers up his girlfriend or fiance, Mallory, and they go downtown, and Lee searches for Casey and can't find her. During this process, Lee Anthony had sent a message or called Annie Downing, one of Casey Anthony's friends, who alerted Casey Anthony that her brother was looking for her. Casey Anthony, you will hear, got herself out of downtown Orlando. Day 19, Friday, July 4th. Casey Anthony is perpetuating this lie to her mother that they're in Jacksonville. However, she tells her former fiance, Jesse Grund, that Kaylee's at SeaWorld with the nanny. You will hear from an individual by the name of Will Waters, a guy Casey met July 4th, 2008. That she was at his house planning a party for the 4th of July. And they went to Lake Eola, which is in downtown Orlando, where they have an annual 4th of July fireworks. Before he arrives, Casey Anthony is captured on video with Will Waters at an IKEA here in Orlando. No Kaylee Anthony. Is talking excitedly about the fact that her boyfriend, Tony, is coming back from New York. And goes to a place called Buffalo Wild Wings that night with Tony. In the meantime, she didn't forget to tell her mother that her car is now broken down in Jacksonville. And Jeffrey Hopkins is helping her get it fixed, and now we're not going to be back till July 12th. Another week. Buying time, the evidence will show. She tells Cindy that Kaylee Anthony is now staying with Jeffrey Hopkins' mother and Jeffrey Hopkins' son, Zachary. You will hear from Jeffrey Hopkins that none of that is true. So we go through day 21, 22, 23, 24, 25. No one knows where Kaylee is. And Casey Anthony is just gallivanting around Orlando, captured on video at Target, captured on video at a Bank of America eventually. And there's no Kaylee Anthony on any of these videos. So where is she? On Friday, July 11th, day 26, Casey Anthony's back at Fusion, a nightclub. On July 12th, day 27, Cindy is getting text messages from Casey that she's still in Jacksonville. She's really at a Winn-Dixie at 9:30 that night, captured on video. Sunday, July 13th, which is now day 28. Casey Anthony tells her mother that they had to stay longer past July 12th in Jacksonville because of a wedding. Jeff Hopkins' mother's wedding. And finally, we get to day 30. Tuesday, July 15th of 2008. You will hear that over the weekend, George and Cindy Anthony were doing some yard work and had noticed that a letter had been placed in their front door. They had to go to the post office to retrieve whatever this item was. George Anthony was unable to accomplish or take care of that errand on July 14th. So on July 15th, he goes to the post office, retrieves this letter, and it's from Johnson's record. Although Casey Anthony had exclusive possession of the white Pontiac Sunfire, the car was titled in George and Cindy Anthony's name. And so when it was towed to Johnson's Wrecker, the wrecker company eventually sent a letter to the registered owners. George and Cindy Anthony, here's where your car is. Come get it and bring cash. So George and Cindy Anthony drive to Johnson's Wrecker, and while Mrs. Anthony deals with the people at the front desk, George Anthony goes with an individual by the name of Simon Birch to retrieve the car. Along the way, George Anthony is telling Mr. Birch of these problems that the family is having, that he hasn't seen his granddaughter or his daughter for days. And as they approach the vehicle, an overwhelming smell is emanating from it. And it's coming from the trunk. George Anthony will tell you that he said a silent prayer, that it was neither his daughter or his granddaughter that he would find in the trunk of that car. Simon Birch, who you will learn has spent many years in the tow business and has seen and heard and smelled just about everything associated with a car, including when someone committed suicide inside a car and it sat for days. So Simon Birch will give you his opinion based on this experience about what that smell was. And as that's going through his mind, and he hears George Anthony making these statements about his missing daughter and granddaughter, Simon Birch as well is hoping that they're not going to find a body in the trunk. And when the trunk is open, there's a bag of garbage inside. And you will hear that Simon Birch took that bag of garbage and threw it over a fence at Johnson's Wrecker and eventually placed it into a dumpster there. George Anthony got into that car, drove it home. When Cynthia Anthony had her first contact with the car, her words to George Anthony were, "Jesus, what died?" At which point, her husband proceeded to tell her that there had been garbage in the car. So George and Cindy Anthony go back to their house on Hope Spring Drive. Now, obviously frustrated about the fact that this car is not in Jacksonville, where Casey said she was with Caleb. And that it had been, they learned, at this tow yard since June 30th. So they knew she was lying. George Anthony had to be at work at 3 o'clock that afternoon. They put the car in the garage at their house to air out. Cindy Anthony goes back to work as well and is communicating about the smell to her coworkers. And they eventually convince her she needs to call the police. Cindy Anthony texts Casey Anthony about 4:30 that afternoon that there's a major problem, that she needs to contact her. In the meantime, while all this is going on with George and Cindy Anthony, Casey Anthony is happily in her friend Amy Huizenga's car, because days earlier, Amy had taken a trip to Puerto Rico. And now Casey has her car. And on July 15th in the afternoon, Casey Anthony makes an appointment for another tattoo, tells the guy at the tattoo place that she's gonna bring Kaylee in with her when she gets this tattoo, is captured on a Bank of America surveillance video, cashing a check about 1:30. As she's driving to the airport, she speaks with a woman, a girl, a young lady by the name of Erica Gonzalez. Gives Erica the impression that Kaylee's in the car with her. When she picks up Amy, she tells Amy that she got a call from Kaylee Anthony that day on her cell phone. And eventually, Amy Huizenga drops off Casey Anthony at her boyfriend, Tony Lazzaro's apartment. Amy Huizenga, you will hear from the testimony, goes with friends of hers in her car to the Florida Mall. And Cindy Anthony is at home, trying to figure out a way to get in touch with Casey Anthony. And so she goes through items that were left in the car. Kaylee's car seat was in the car. Casey Anthony's shoes are in the car. Some clothes are in the car. There were dryer sheets in the car. There are items in the trunk, in a bin in the car. There is a bag that Cindy Anthony thought Casey used for work And in that bag is contact information for Amy Huizenga, who Cindy Anthony never met. So Cindy Anthony calls Amy Huizenga and asks if she's seen Casey or Kaylee. Well, Amy just saw Casey. She knows exactly where she is. And even though the two had never met, Cindy Anthony on that day, on July 15th of 2008, is not going to be denied access to her granddaughter to the point where she is tracking down her daughter Casey's friends. Despite some hesitation, and because of the sound in Cindy Anthony's voice, Amy Huizenga agrees to allow Cindy Anthony to come pick her up at the Florida Mall. And Cindy Anthony drives down there, gets Amy in the car, is telling her all about what's been going on. And Amy directs Cindy Anthony to Tony Lazzaro's apartment. Amy goes up to the door with Cindy behind her, knocks on it, and gets Casey Anthony out of there. Kaylee Anthony's not there. Where's Kaylee Anthony? You will hear that Cindy Anthony basically pulls Casey out of there without her phone, without her belongings, and she gets in the car. They drop Amy off, and at this point, Cindy Anthony is not going to be denied access to her granddaughter, who has now been gone for a month. Casey Anthony tries the same old Zanny story with Cindy, but Cindy Anthony will not be denied access to her granddaughter. And since Casey Anthony is stonewalling, telling her mother she doesn't want to upset Kaylee, she doesn't want to disrupt this routine that she's now in, Kaylee's going to be upset, Cindy has had enough and decides that the only way I am going to get access to my granddaughter is to get the police involved. So she drives Casey Anthony in her car to a substation of the Orlando Police Department, which at that time of the night is closed, and makes her first 911 call from her car, from the parking lot of that Orlando Police Department substation. During the course of this trial, you will hear that first call that Cindy Anthony made to the Orlando Police Department. She wants her daughter arrested. The dispatcher from the Orlando Police Department is trying to determine if there is a crime that's been committed and where that crime has occurred. So in making this inquiry, it is determined that the address on Hope Spring Drive, where the Anthonys live, is actually within the jurisdiction of the Orange County Sheriff, not the Orlando Police Department. And they give Cindy Anthony a choice about whether or not she wants to wait on the side of the road for a deputy to show up or go back to her house and make another call, and she chooses the latter. During this exchange, and while there is some dead air between the dispatcher and Cindy Anthony, you can hear Cindy Anthony threatening to take Kaylee away from Casey. And Casey Anthony asked her for one way. You will learn that during this exchange, George Anthony, who's been apprised of some of this, not all of it, some of it, calls Lee Anthony, Casey's older brother, and says, "You need to get to the house." So Lee Anthony, who lives in the area, arrives at the house on Hope Spring Drive just before Cindy and Casey Anthony. And as they pull up, they get out, they rush in, he gets no information. There's the car in the garage. He notices himself that there is an overpowering smell, indescribable smell associated with that car. And as they all rush in the house, Cindy Anthony basically tells Lee to get information from your sister. She's not telling me anything. I want her to take me to Kaylee now. Shortly thereafter, Cindy Anthony makes her second 911 call, which you will hear. This time, it goes to the Orange County Sheriff's Office. And she again talks about having her daughter arrested and mentions at that time a possible missing 3-year-old. The dispatcher, in trying to get some information, elicits from Cindy Anthony that her daughter, Casey, will not tell her where Kaylee is. So when patrol units of the Orange County Sheriff's Office are initially dispatched to this call, they're unsure whether or not this is a stolen vehicle call, is this some other theft call, is this a domestic incident? Because while Cindy Anthony is waiting, and it does take a while for the Sheriff's Office to arrive, based on the priority levels that they give calls, Lee Anthony is talking to Casey Anthony, who is now in her role. And Lee Anthony is trying to convince Casey Anthony to just take Mom, Cindy, to Kaylee. What's the problem? This is going to happen anyway. Why are you doing this? To the point where Lee Anthony eventually engages in what can only be termed as a role-playing episode with his sister, where Lee Anthony pretends to be the police officer and says, "Miss Anthony, good evening. I see that you're having a problem here with your mother. Why don't we just resolve this? You take us to the child and everything will be fine. We'll all go home. We'll all be happy."
stop for a moment. It's been going for about an hour and a half. Let jurors take a break. Want to take a recess? Okay, ladies and gentlemen of the jury, we're going to take a 15-minute recess at this time. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Please remember all of my previous admonitions. We'll be in recess for 15 minutes.
Nobody is ever going to forget this trial. We're watching the opening statements from Casey Anthony. For those of you who don't remember, which I'm pretty sure there are not too many, Casey Anthony was acquitted of first-degree premeditated murder charges back in 2011 for the death of her 2-year-old daughter. Even now, even after a full trial was conducted and 6 years later, there's still a lot of question marks about this case. One of the things that was never solved, how did Caylee Anthony actually die? Big point of contention between the defense and prosecution, maybe the point of contention, maybe the question mark that actually led to the acquittal. Who knows? Well, here to break it down, though, we have Deborah Blum, criminal defense attorney. Deborah, thanks for being with us. Oh, yeah, so we have a little blast from the past today. Casey Anthony. A lot of us spent a lot of hours and time breaking this case down minute to minute, making predictions about what was going to happen, which way it was going to go. A lot of people shocked by the outcome. Obviously, media frenzy surrounding this case, dubbed the most hated mom in America by the media. I mean, this was just such a crazy case to follow. A lot of this case hinging on the prosecution and the evidence that they have and the evidence that they didn't have. Big piece of that, the fact that they couldn't really pinpoint how Caylee Anthony died. What do you think dictated the outcome of this trial?
Well, I think that there was a lot of what ifs, and I think that her parents, it seemed like they were questionable as well. I think the biggest thing for the defense was that the father allegedly had an affair with a woman who claimed that the father, Casey Anthony's father, said that it was an accident that went terribly wrong. So I think that the jury believed that perhaps he was involved and that this was not premeditated murder, that this was an accident that they then covered up.
Yeah, and we heard a lot. We heard from some of the jurors after the fact. Reasonable doubt. They just saw that reasonable doubt. They weren't sure, especially when you're talking about a premeditated murder charge. If she was charged with something lesser, do you think the outcome would have been different, or was the evidence still just not there?
You know, when I was reviewing this before coming in today, I'm surprised actually that they got not guilty on so many different counts. She was found not guilty of first-degree murder, not guilty of aggravated child abuse, and aggravated manslaughter of a child. So I think that was a lot of not guilties. I mean, this was a woman that for a few months afterwards continued to go about her daily life, was going out, lied on many different instances to the police, made up that a nanny was the one that was last with her child when that wasn't true. We never even found this nanny. And perhaps she referred to the nanny as Zanny, which might have been a reference to Xanax, which she may or may not have given to the child. So I think there were a lot of really ridiculous things, crazy things, that if I was a juror, I maybe would have found her guilty of more counts.
Yeah, I mean, a lot of those facts that came out during the trial were really out of control. One thing, and you and I talked about it a little bit before we dove back in while we were listening to the opening statements, one of the issues was that Casey Anthony was an admitted liar. And that time period, 31 days in between the disappearance of this 2-year-old baby and the time that her mother reported Caylee missing, I mean, it's lie after lie after lie about her whereabouts, what happened, this and that.
She lied about having a job. She said that she was still working at Universal Studios, and the police took her there, and then she had a breakdown. I think in part it's her personality that she's like this victim, and you feel bad for her. And I guess the jurors just didn't find beyond a reasonable doubt that they had enough information to say, yes, this was a premeditated murder. What I find very interesting about this is that it's taking us back to 2008 when the murder occurred, and you'll notice there's no real surveillance footage. Nowadays, everything is caught on surveillance camera. So if you're going to commit a crime, you really have to be careful. Not that I'm advising anyone to commit a crime, but surveillance footage is everywhere. So I think they would have had a more accurate picture, the prosecution, of what went on if it occurred nowadays.
Oh, that's definitely true. And that media footprint, surveillance, all of that stuff is so prevalent now. It's such a different situation to piece together the puzzle. Cell phones are different. I mean, you think about now everybody has a cell phone that also has their email, their text messaging, different social media platforms, and they're using that all the time to determine their whereabouts. So that definitely changes the game.
Right.
I know that back in the day when we were covering this case, minute to minute, that I really thought, and wrongly, with a lot of other legal analysts, that the fact that there were all these lies and inconsistencies would really be what dug her into the ground. But the defense attorneys really flipped that around. Baez did a really great job of kind of just turning into the skid. He's like, yeah, okay, she lied. Nope, she didn't act like the way you think a mother who just lost her child, whether she was abducted or some terrible accident went horribly wrong and then there's a cover-up, would act. But it doesn't make her a murderer, and the jury really bought that.
This is absolutely a triumph for the defense in this matter. There was a fume in her trunk that could link somebody to the death of a child. So it was likely, they had a forensic expert testify, that the smell in the trunk was the smell that's associated with death. So it's clear that she had this little girl in her trunk, or at least to me it was clear that she had a dead baby in her trunk, which is a heinous thing, but I agree. The defense said she's not an angel, but that does not make her a murderer. This is somebody, again, it's this whole theory of it was an accident gone terribly wrong. So whether she was involved in the killing or wasn't, it wasn't intentional, it was an accident. Maybe she drowned in the pool, maybe she administered chlorophyll or chloroform, whichever one it is. And she didn't do it with the intent to kill her child, but then either with the assistance of her father or without the assistance of her father and potentially her mother, they covered it up, and for a month or so afterwards, she just lied and lied and lied and lied.
Right.
But that doesn't make her an intentional killer.
Right, and that's a high bar. I mean, you're talking about saying that she planned and plotted the murder of her child. That's a tough for a jury to swallow if there's not some clear-cut evidence there. One thing that you pointed out that's really interesting about the case is the divergent theories between the prosecution and the defense. So the defense, as you said, they said, well, this was a terrible accident. The 2-year-old got into the pool, drowned, family panicked. Casey Anthony and her father covered up her death, saying that they didn't want to be accused of child neglect, so they covered up the death, in contradiction to the prosecution's theory of the case, which is that she was suffocated. This tape was placed over her mouth. Now, while that might have been consistent with how they found the body, with the duct tape and all that, there was never a medical report that could truly say, that could never really identify the cause of death. And that was a big factor. Do you think that had an impact on the jury?
Well, in Bella Bond, the boyfriend was found guilty of second-degree murder, which is a trial we just covered recently. And it's kind of similar to the fact pattern here, is we don't know the cause of death. And then unfortunately, when the little girl in that case, in the Bond matter, was discovered, her body was so badly deteriorated that they also couldn't determine the exact cause of death. So I do think that people sometimes need an exact answer, and when the prosecution is unable to provide one through forensic evidence, that's doubt, and that's what a defense attorney argues, because that's their job.
The defense attorney makes sure to capitalize on that, and that's what they did. They said, Baez stood there, and I remember it distinctly. He said, this is not emotion, this is evidence. So what is the evidence? And the answer to that question was a lot of gaping holes. As you said, I know one of the alternate jurors who was interviewed, they couldn't get over the fact, despite that there was the smell in that trunk, they couldn't get over the fact that there had been police there before who didn't see it, who didn't identify that smell. There was a lot of issues that the defense really capitalized in this case.
Right.
Which in a circumstantial case, that's a great strategy.
Right, and that made their strategy, is that this was mainly a circumstantial evidence matter, and if you're able to persuade the jury of all of the holes, then legally they have to not convict, even if they think that she was guilty of murder. The question is beyond a reasonable doubt. Do you think that the prosecution proved their case beyond a reasonable doubt? And a lot of times they do not.
Yeah, and there was definitely an effort to explain away some of those lies, as we know, that the defense came back and they talked about this potentially abusive relationship that Casey Anthony had with her father, that her father had abused her as a child, that it led her to act differently than the way you would expect a mother whose child is missing or a mother whose child has died to act. As we know, during that time period, some pretty damaging stuff. I mean, she's in a hot body contest. She's, out partying, living this life, playing very much into what the prosecution's theory of the case is that this is a person who had a child before they were ready and that did not fit in with their lifestyle. The defense took another angle. Now, at some point, the judge really kiboshed that line because it wasn't corroborated that there had ever been any abuse by Casey Anthony's dad against her. But do you think that also played a factor, just this family life that was a little bit
Absolutely,
odd?
absolutely. I think that was a tremendous factor in this case, was the peculiar family life where it's alleged that the father abused her. Sometimes all it takes is for the jury to hear it once. Even if you say something and you know that the judge is going to sustain the prosecutor's objection, it's enough to say it and have the jury hear it. I'm not saying that you do that on purpose, but sometimes it just occurs. And then the jury has heard something that is that they're going to take into consideration, even if the judge instructs them not to. I know that jurors try very hard to follow the judge's instructions, but sometimes you can't erase what you just heard. So I do think that this disturbing family life where the father might have been having affairs, which would play into the fact that he was abusive, and somebody that is abusive doesn't have the same relationship with the truth as somebody that's not raised in an abusive home. But again, this all goes back to, this is your child. I don't know how you don't report your child not missing unless you, again, buy the defense's theory that it was an accident that just went terribly wrong, and they made a horrible mess out of an accident where they should have just reported it, but it doesn't mean that she committed murder.
Right, and they have that one corroborating statement, as you pointed out, which is the affair. The father was having an affair, and there's this statement by that woman saying that it was something that went off the rails, essentially. The prosecution argued that statement's taken completely out of context, but maybe it's just that one corroborating factor that tips the balance.
Right. We never really know. And the actual jurors who rendered this verdict didn't comment to the press, as we just talked about. There was a juror that did speak with the press, but that was an alternate. So he wasn't present during a good part of the deliberations, most likely. So he doesn't know what swayed the jury. And, I think that when they rendered the verdict and the father was sitting there, he didn't have a facial expression. So most parents whose children have been exonerated would be exhilarated, and he was not. So to me, that does possibly speak to her guilt. But some people have delayed reactions, so there's so many different ways to read it. But when you find out that your daughter has been cleared of murder charges, if you believe she's not guilty of those charges, you usually would be extremely happy.
Right, and we saw her family. That was the first time they hadn't expressed emotion, really, because during the course of that trial, there was a lot of focus on her parents, and there was almost no question as to the connection and love they had felt for Kaylee.
Right.
And that really they were so distraught over the loss of their granddaughter. And since then, so we see Casey Anthony pop up now and again in the tabloids, and we see Casey Anthony pop up now and again in interviews. And the word is that she does not have a relationship with her father anymore. She still keeps in contact with her mother, noting her mother during the trial there was some favorable testimony that the prosecution tried to discredit about who did that Google search for chloroform.
Right.
And the mother kind of took the fall for that, whether that's true or not, no one knows. But that now, since that time, there's still a big question mark in the minds of everyone. What really happened?
And this case was like on the cusp of when we're using technology in the cases. The law especially the state of New York, still hasn't caught up to all of the social media, the Google searches. Here we did see a Google search come into play that the mother, Casey Anthony's mother, claimed responsibility for. But nowadays, I think there would have been a lot more to pinpoint the specifics that were missing. And I think that the jurors just had a really hard time. She's a peculiar character. She's now living with an investigator that was involved in this matter, which is strange, you know, although we also have to take a look at the fact that she is like has a pockmark. It's like she's Casey Anthony.
Right, forever.
Right.
She's been exonerated. I mean, listen, she had a fair trial. And even critics of the outcome will come out and say that, hey, look, this was presented, the evidence was presented fairly to a jury of her peers, and they simply did not see enough evidence to convict her on these charges. I mean, whether or not you agree or disagree, that was the justice system at work.
Right. Well, she was convicted of the misdemeanor counts of lying to the police, but that time all merged into 1 year. So she was found guilty of 4 misdemeanor counts, which she got a year for each one, but those were served together. So she only had to serve 1 year. She did concurrent, not consecutive time. So she did spend a year in jail, or the portion of the time that she had to spend in jail. It's just that her life has also to some degree been ruined. She declared bankruptcy. She has a job with the investigator, but it doesn't seem like, you know, I saw a picture of where she's living. It's certainly not a lavish lifestyle, although I'm sure there were some perks to this in some way, shape, or form. It's just a very tragic situation and an interesting person that was accused of a crime but was exonerated.
Right. I mean, obviously the death of a child is always going to be completely tragic, and whether or not we ever, and from a public perspective, get the answer, we probably won't. Even Casey Anthony in her interviews, not that she's going to come out and say one thing different than the other, but she did not say anything in these post-trial interviews consistent with her defense theory. She hasn't come out and said, well, what I presented at trial was the truth. She said, I don't really understand or know what happened to Kaylee. So that makes the whole case even more mysterious after the fact. I mean, the reason why we're here 6 years later, and when we're talking about what trial should we revisit, that would be interesting to talk about all the ins and outs, it's the Casey Anthony trial. She's notorious.
Well, people are still to this day trying to figure out what went on. They're trying to catch her in all of the lies. And, you know, as with the benefit of time, people are able to say, well, there was this lie, she lied about the nanny, she lied about her job, she lied and said that she had spoken with her child when she hadn't. So there are a lot of lies, and there's the benefit of really being able to examine everything point by point. And I think in doing that, the jury maybe would have had an easier time convicting her of at least some of the charges pertaining to the child, not necessarily the death, but endangering her welfare.
Well, we could go on, Deborah, all day about the Casey Anthony trial. I mean, this was really, in the past decade, this was such an interesting trial, lots of twists and turns. We're going to continue to watch this into the afternoon. Deborah's going to stick around, but I'm going to leave and turn the seat over to Aaron Keller, who will continue to go through the Casey Anthony trial. We're going to still play these opening statements. Make sure to listen, because if you recall, which there's so many details to this case, it's hard to put it all in perspective after the fact that there's so much to talk about. But there was a time when Baez kind of presented a different theory of the case and retracted that a little bit, kind of changed paths as the trial proceeded. So make sure to take note of that in the opening statements. We're going to throw to that clip now, and I'll see you next week.
At the break, we were speaking of Lee Anthony's efforts to convince his sister Casey of her need to just tell Cindy, their mother, where Caylee Anthony was. That resisting, fighting, just not giving the information was counterproductive and would ultimately result in the same ending regardless. That whether or not Casey did it, or Lee did it, or the police did it, that they were all going to see Kaylee that night. However, in a pattern that is repeated throughout this case, when Casey Anthony's lie can no longer stand, when she can't get out of the corner that she has painted herself into, when her back is up against the wall, and when the stakes increase, what does Casey Anthony do? What does she do? Casey Anthony comes up with a new, a bigger, and a better lie. It is at this point, with her back against the wall, with her brother telling her that the result of this disagreement that you are having with our mother will end in our mother's favor, that Casey Anthony first says these words: Kaylee was kidnapped by the babysitter. The babysitter that nobody has ever seen, that nobody ever saw, that her parents didn't know, that her brother had never heard of. Kaylee has been kidnapped by Zenaida Fernandez Gonzalez. And upon hearing this information, all Kaylee's Uncle Lee could think of was nothing. He goes into vapor lock. He can't believe his ears. He has to focus now on solving this problem. And even though Cindy Anthony, the evidence will show, had to realize that her daughter had lied and lied and lied and lied for 31 days about where she was, about where Kaylee was, about what they were doing, at that moment, Cindy Anthony had to believe her daughter. Although her first response, according to the testimony that you'll hear from Lee Anthony, is, "What did you do?" Her first response directed at Casey Anthony, "What did you do?" And at that point, this story, the evidence will show, had its desired effect to take the focus off of Casey Anthony. Her mother was in her face. Her brother is in her face. How do you get out of that? You tell another lie. Cindy Anthony goes into an all-out panic. At this point, 911 again, the third time on the phone, and you will hear Cindy Anthony's panic 911 call to the Orange County Sheriff, the third call she made that day. And this time she is hysterical. Cindy Anthony wants Casey Anthony to speak to the dispatcher on the phone. You can hear the exchange, and then you can hear Casey Anthony get on the phone like nothing. With the attitude, well, why do you people want to talk to me? I don't want to talk to them. During this call, Cindy Anthony tells the dispatcher from the Orange County Sheriff's Office that her granddaughter was kidnapped. I cannot find my granddaughter. Something is wrong. It smells like there's been a dead body in the damn car. As you will learn, as this trial unfolds, the Orange County Sheriff's Office, as do all police agencies, keep a almost second by second accounting of their response to a call. You will learn that the first officer that arrived at the Anthony residence was Corporal Rendon Fletcher. Now, Corporal Fletcher's dispatch was to the second call. So he's not completely apprised until he gets there of the seriousness of this call. Eventually, after learning from Lee Anthony and Cindy Anthony and Casey Anthony in the home that Kaylee is missing and this Zenaida Fernandez Gonzalez has Kaylee, the Orange County Sheriff's Office begins to gather information about locating this person. And one of the things that is told to them by Casey Anthony is that Zanny, or Zenaida, lives at the Sawgrass Apartments, which is off of Conway Road in Orlando. So deputies with the Orange County Sheriff's Office asked Casey to show them the last place she saw her daughter 31 days ago. And she gets into the car with Adriana Acevedo, a deputy with the Orange County Sheriff. Brendan Fletcher, the corporal that first responded to the call, follows in case he needs to do follow-up with the people at the Sawgrass Apartments. And they drive in to the location at the direction of Casey Anthony. She points out the apartment where she last saw her daughter, Kaylee, and says, "That's where I dropped Kaylee off on June 9th, 2008. Rendon Fletcher finds somebody with this apartment complex, somebody in management or maintenance, and it's determined that while this is July, now 16th probably, 2008, nobody's lived in that apartment since February 2008. The prior occupants were evicted. So when these deputies from the Orange County Sheriff's Office returned to the Anthony home with Casey and no Kaylee, what does Cindy Anthony do? She continues to insist that something be done. That Casey is lying, that somebody needs to arrest her. She needs to tell me where Kaylee is. During this process, deputies send somebody to Tony Lazzaro's apartment where Casey's cell phone was. And her belongings were later retrieved by her brother, who went to the apartment. Kaylee Anthony was not there either. One of the things that Casey Anthony told them had to do with having contact information for this Zanny person in her phone. So the deputies retrieve that phone and attempt to get any information that night off of it that they can in an effort to find this person who allegedly has Casey Anthony's daughter, Kaylee. They ask Casey Anthony to put pen to paper. Tell us everything that you can tell us about what happened and about this person that you say kidnapped your daughter. They were there to help find Kaylee Anthony. So what does the evidence show Casey Anthony did at the first opportunity given to her to put pen to paper? She writes, on Monday, June 9th, 2008, between 9 a.m. and 1 p.m., I, Casey Anthony, took my daughter, Kaylee Marie Anthony, to her nanny's apartment. June 9th. On Monday, June 9th, 2008. The first words written to the Orange County Sheriff about the disappearance of Kaylee Anthony are a lie. This statement is single-spaced, 4 pages, and during the course of this trial, you have the opportunity to review it, and you will see that it's 4 pages of lies. The patrol supervisors at the scene of the Anthony's that morning, July 16th, now 2008, decided that they needed to call a detective out to the house to follow up in this investigation, to tell the detective what their findings were, at least preliminarily. While they're waiting for the arrival of the detective, the sergeant on the scene, Reginald Hosey, took Casey Anthony on a short walk. There's a cul-de-sac that is 2 or 3 houses down from her residence, and asked her, is this a domestic situation? Is it just a matter of you don't want your mom to have access to your child? And Detective Hosey is left with the impression from Casey Anthony that night that this is no big deal. And that her child is fine. At 4 o'clock in the morning on Wednesday, July 16th, Detective Yuri Melich, the Orange County Sheriff's Office, first arrives at the Anthony house. He gets a copy, or he reviews that handwritten statement of Casey Anthony, and he asks to speak with her. She talks with him in a room in the house. He ultimately tape records their conversation, and he says, is this true? Do you want to change anything on this statement? And Casey Anthony says, no, sir, no way. This is what happened. I'm telling you the truth. One of the things that she had relayed to the Orange County Sheriff's Office was that she had a phone, another phone, that was lost at Universal Studios where she worked, that there were people who were employees of Universal Studios who she had told about this situation. Detective Melich again asked if Casey Anthony could take him to the location where she says she last saw her daughter at the Sawgrass Apartments, and she takes him right back to that same place where she took the patrol officers. He asked if there are other people related to this Zenaida Fernandez Gonzalez that he could contact in an effort to locate Kaylee Anthony. She takes him in the area of another residence, supposedly of Zenaida Gonzalez's mother. No one is contacted, nobody is found. They return to the Hope Spring house with no Kaylee. Casey Anthony goes back in her house, and Yuri Melich begins his investigation. And that investigation begins at Universal Studios. Yuri Melich contacts an employee of Universal Studios by the name of Leonard Tutura in an effort to determine where Casey Anthony works, where these other people that she said can be contacted work, how they can be contacted. And Detective Melich learns Casey Anthony doesn't work at Universal Studios. Casey Anthony hasn't worked at Universal Studios for years. These people that she told you were here, they don't work here. So Detective Melich, with the assistance of his supervisor, Sergeant John Allen, and another detective by the name of Appy Wells, made contact with Casey. The first contact is made by Detective Melich over the phone, where he calls Casey Anthony and says, "You work at Universal Studios, and this is the information," verifying what she had told him before. She's like, "Yes, absolutely, of course. Yes, you're right, that's it." He knows it's a lie. Maybe they all have it wrong. Maybe if Casey comes out to Universal Studios, we can clear this all up. Maybe we're not getting the names right. Maybe I wrote it down wrong. And she is contacted and agrees to come out to Universal Studios. So Detective Melich is there with Leonard Tutura, and John Allen and Appy Wells go to the Anthony house, pick up Casey Anthony, and she accompanies them to Universal Studios. She directs them where to park, just has idle chit-chat with them on the way, and they get to the security gate at Universal Studios, and she's denied access. They're suggesting she doesn't work here. They ask her for her identification. She tells them, "I forgot it, I don't have it." Leonard Tutura, who's there with Yuri Melich, allows them to come in anyway. And there, Casey Anthony is supposed to show them the office where she works and where she lost her phone, or where there might be some information about Zenaida Gonzalez. And you will hear testimony that Casey Anthony walks with purpose through that security gate and heads towards an administration building, walks in true to what we've seen, or you will see during this case, is at the end of the hall. And she puts her hands in her back pocket and smiles. All right, that'll work here. Detectives Allen, Wells, and Melich then speak with Casey Anthony on tape in a conference room at Universal Studios, where she admits to them that she's been lying to them about working at Universal. Because that's the lie the evidence will show they caught her in. But she will not waver at that point from her story about the nail. So in an effort to find this person she insists exists, the detectives take her from Universal and show her pictures in the driver's license database of individuals with the name Zenaida Gonzalez. She doesn't know any of them. None of these Zenaida Gonzalez's on your driver's license pictures are my Zenaida Gonzalez. At this point, since Casey Anthony admitted to them that she lied during the process of this investigation, she was arrested. And at this point, the investigation, by necessity, takes two different paths. There is the investigation that continued into attempting to locate this person that Casey Anthony insisted had her daughter, this Zenaida Gonzalez. There were tips and phone calls and sightings of Kaylee Anthony all across the country, on airplanes, in gas stations, all over the place. Tips that were followed up by members of the Orange County Sheriff's Office, the Florida Department of Law Enforcement, the Federal Bureau of Investigation, local police agencies in different states know Kaylee Anthony and know Zenaida Gonzalez. That night, July 16th of 2008, with the permission of George and Cindy Anthony, the Orange County Sheriff's Office seized Casey Anthony's white Pontiac Sunfire. And you will hear testimony from crime scene technicians and ultimately the individuals who evaluated and analyzed evidence taken from that truck during the course of this trial. You will also hear that the trash bag that Simon Birch had thrown out of the car the day before, when George Anthony picked up the Sunfire at the Johnson Wrecker, was located in the dumpster when George Anthony went with a missing persons civilian investigator to find it. Was there something in that garbage that would help the Orange County Sheriff's Office find his granddaughter? George Anthony wanted to know. On Thursday, July 17th, the Orange County Sheriff's Office had one of their cadaver dogs, which you will hear during the course of this trial is a dog that is specially trained in detecting the scent of human remains. Do a sweep around the car. Deputy Jason Forgy, who has many years of experience in handling police canines and who has worked with his dog Garrus prior to Garrus's recent retirement for a long period of time, took the dog around the car, at which point Garrus alerted, give a trained final alert, which will be explained to you, on the trunk of the car as having the odor of human remains. Later that day, Garrus was taken to the Anthony residence, where, again, George and Cindy Anthony had given permission to the members of the Orange County Sheriff's Office to look in their yard to see if there was any evidence that would help them learn what happened to Kaylee. Where was Kaylee? And then again, in the backyard, near Kaylee's playhouse, Garrus alerted to the odor of human decomposition. Deputy Forgy had asked that another canine handler, this one from the Osceola County Sheriff's Office, Kristen Brewer, Sergeant Brewer, brought her cadaver dog to the Anthony home. And her cadaver dog also alerted to the odor of human decomposition near the playhouse in the Anthony's backyard. Now you hear that crime scene technicians dug up in the areas where the dogs alerted, did not find Kaylee. Evidence from the car was also preserved: hair, air samples, samples from the carpet lining the trunk, samples from the spare tire cover were cut and collected in tin cans by members of the Orange County Sheriff's Office. Samples of Casey Anthony's DNA, Lee Anthony's DNA, Cindy and George Anthony's DNA, and a hairbrush that was used by Kaylee to get a sample of her DNA was obtained. The hair and other debris collected from Casey Anthony's Pontiac Sunfire was sent to the Federal Bureau of Investigation's laboratory in Quantico, Virginia. And you will hear that the evidence and testimony in this case establishes that forensic science has discovered that there is a distinctive band of discoloration that occurs at the root end of a hair under very specific and unique circumstances. According to these scientific studies, you will hear this artifact occurs only and has only been seen in hairs taken from decomposing human bodies. Of the many hairs that were found in the trunk of the Sunfire, one hair exhibited the classic characteristics that I just described. This supports the prior investigative findings, not only as it relates to the alerts by the trained cadaver dogs, also the ability of those people who have smelled a dead body before to know what it is. These findings led to the inescapable conclusion that, in fact, a dead body had been in the trunk of Casey Anthony's car. And you will learn that the FBI compared the hair that I just described to hair collected from Caylee Anthony's hairbrush through the use of mitochondrial DNA, which will be explained during the course of the trial, as well as microscopic analysis, and determined through the unique characteristics of the hair that they were indistinguishable from those of Caylee Anthony. The testimony in this case regarding the analysis of this hair will convince you that it was the hair of Caylee Marie Anthony that was found in that trunk. Nevertheless, in order to further establish the nature of the odor emanating from Casey Anthony's trunk at that point, the Orange County Sheriff's Office contacted an individual who is the leading expert in the field of the biochemistry of the odor of human decomposition. That individual, Arpad Voss, Dr. Arpad Voss, will be testifying for you during this trial. And in 20 years of studying the chemistry of the odor of decomposition, he has spent the last 10 concentrating on identifying the chemical composition of the very distinctive odor of decomposition, of human decomposition. Dr. Voss will tell you that when he opened this can that was collected by the Orange County Sheriff's Office that contained samples of the spare tire cover in the trunk of Casey Anthony's car, he immediately recognized the unmistakable odor of human decomposition. Now you will learn that his research and others' research into this area is ongoing. And he will tell you about the instrumental analysis that he performed on the odor from the substance, from this piece of spare tire cover taken from the trunk of Casey Anthony's car. What you will learn is that these compounds are consistent with a decompositional event occurring in the trunk of the car, possibly of human origin. But Dr. Voss will also tell you that during his analysis of those pieces of spare tire cover, that he found something unexpected. His instrumental analysis found the highest concentration of chloroform that he's ever seen. And while he will tell you that small amounts of chloroform have been found in human decomposition under specific circumstances, his analysis of the evidence in this case showed a concentration of chloroform thousands of times greater than he had seen produced by human decomposition alone. The amount that he detected simply cannot be accounted for by human decomposition alone. You also hear that different sections of this same spare tire cover the samples from it were sent to the Federal Bureau of Investigation, Crime Laboratory, and they independently confirmed through separate analysis the presence of chloroform. Upon receipt of this information, the Orange County Sheriff's Office detectives contacted the forensic computer analysts with their agency. You will learn that of the items collected from the Anthony household, one was a desktop computer. The hard drive from that desktop computer had been in the possession of the Orange County Sheriff's Office since July 16th or 17th of 2008. And when this information was passed along to these examiners, based on Dr. Voss's findings, which occurred at the end of August or beginning of September of 2008, the computer analysts were asked to perform a keyword search of the hard drive of that desktop computer for the word chloroform. And you will hear, in this case, testimony from Sandra Osborne, who is a forensic computer examiner, that her analysis of the computer revealed searches on March 17th and March 21st of 2008. What you will hear is that internet searches were conducted by a user in the Anthony home using Google. You will hear that on Monday, March 17th of 2008, between 1:43 and 1:55 in the afternoon, Google searches were done on that computer for the words chloroform, alcohol, acetone, and peroxide. You will hear that on Friday, March 21st, 2008, between the hours of 2:16 and 2:28 p.m., Google searches were conducted for, quote, how to make chloroform, quote, how to make chloroform with a different spelling, quote, self-defense, quote, household weapons, quote, neck breaking, quote, shovel. In addition to those Google searches, there were Wikipedia searches conducted on March 17th, 2008, between the hours of 1:53 and 1:58 p.m. for the words inhalation, chloroform, alcohol, acetone, peroxide, hydrogen peroxide, and death. On Friday, March 21st, 2008, between 2:16 and 2:28 p.m., a Wikipedia search was done for the word shovel. Also on that date, there were searches using websites blogspot.com, scispot.com, druglibrary.org, instructables.com for these words, quote, making weapons out of household products, quote, chloroform habit, quote, chloroform, quote, how to make chloroform, and quote, chloro2. You will learn that Cindy Anthony was working on those days and at those times. You will learn on March 21st, George Anthony was working on those days and at those times. And you will learn from the forensic computer examiners that the context, searches surrounding, before and after these searches were done on that on that desktop computer at the Anthony home, reveal that there could have been no other user making those searches than Casey Anthony. You will hear that despite the mounting evidence that made it more and more obvious as we got into September of 2008 that Caylee Anthony was dead, that the Orange County Sheriff's Office and many thousands of private citizens continue to search for her. These search efforts, you will hear, in many areas were hampered by the passage of time and standing water that was created by Tropical Storm Faye in late August of 2008. Many additional attempts were made to locate this Zenaida Fernandez Gonzalez. She's never been seen. George and Cindy Anthony held out hope that their precious granddaughter would be found alive. However, on a rainy Thursday morning, December 11th, 2008, the Orange County Sheriff's Office received a call from a dispatcher at Orange County Utilities. The Sheriff's Office at that time was informed that a tiny human skull had been found in the woods off of Suburban Drive. This was in walking distance of Kaylee's home and within sight of the elementary school where she would be at this very moment if she were alive. Examination of that scene revealed that the body of Kaylee Marie Anthony had been wrapped in a Winnie the Pooh blanket, stuffed into multiple garbage bags, shoved into a laundry bag, and thrown into a littered swamp like she was just another piece of trash. A forensic anthropologist will describe to you that all that remained of Kaylee Anthony were her scattered bones, remnants of the clothes that she was wearing, and pieces of the plastic bags that had entombed her. For 10 days, crime scene personnel from the Orange County Sheriff's Office, the Florida Department of Law Enforcement, and the Federal Bureau of Investigation painstakingly worked on their hands and knees, sifting, digging, resifting, collecting evidence, and collecting the remains of Kaylee Anthony to make certain that she would no longer suffer the indignity of lying in a wooded swamp. The evidence, by its very appearance, and you will see hundreds of the thousands of photographs taken in this case, and by its very appearance, you will be able to conclude that Kaylee spent many months in that swamp. Roots encircled the blanket, grew through the blanket. They encircled her hair. They wrapped themselves into the bags that she was in. As you have seen in the photograph taken at the scene on December 11th of 2008, duct tape covered the nose and mouth area of that tiny human skull. The cotton and polyester backing of that duct tape was disintegrating in the harsh environment in which she lay. You will learn that 3 pieces of overlapping duct tape covered the nose and mouth of Kaylee Anthony. You will learn that the duct tape was placed on her prior to decomposition as it held the mandible or the jaw to the head. You will learn that the duct tape was stuck in the hair, indicating that Kaylee's killer never intended that it be removed. You will learn that the brand and style of the duct tape are distinctive and not widely available. You will learn that the Orange County Sheriff's Office executed a search warrant on the Anthony residence late in the evening of December 11th of 2008 and discovered that the gas cans that Casey Anthony took from her dad on June 23rd of 2008 had a piece of duct tape identical in appearance to the tape covering Kaylee's nose and mouth. You will learn that a chemist from the Federal Bureau of Investigation determined that the tape was manufactured at the same time using the same methods. You will learn that the duct tape, identical in appearance to that on Kaylee Anthony's face, was used at the end of July on a missing child poster of Kaylee Anthony. You will hear that the pieces of shirt that remained and the plastic logo that once appeared on that shirt, "Big Trouble Comes in Small Packages," were captured in photos of Kaylee and Casey Anthony taken in January and March of 2008. You will learn that Kaylee's Winnie the Pooh blanket was missing from her house. You will learn that a Whitney design laundry bag was located in the garage of the Anthony home, and the matching bag was missing from the house. You will learn that upon autopsy, there was no evidence of any trauma to Kaylee's bones. And you will learn that the only evidence indicating the cause of death of Kaylee Marie Anthony are the 3 pieces of duct tape covering her nose and mouth. The evidence in this case will establish that there is no other reason for the placement of multiple pieces of duct tape on this child's face, mouth, and nose other than the specific intent to end that child's life. As difficult as it may be for anyone to accept that a mother would intentionally kill her own child, from the evidence that you will hear in this case, there is no other conclusion that can be drawn. Kaylee Marie Anthony was not kidnapped by a nanny or any other person. No one but Casey Anthony had access to all the pieces of evidence in this case: the duct tape, the laundry bag, the blanket, the shorts, the shirt, the car. No one else lied to their friends, to their family, to investigators. No one else benefited from the death of Kaylee Marie Anthony. Kaylee's death allowed Casey Anthony to live the good life, at least for those 31 days. At the end of this case, you will have no trouble concluding that Kaylee Anthony was murdered by her mother, Casey Anthony. And at the conclusion of all of the evidence and argument in this case, we will be asking you to return a verdict that reflects the truth of what happened to Kaylee Anthony. And that is that Casey Anthony is guilty of the crime of murder in the first degree. Thank you all for your attention.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you through the afternoon as we take a look back in the archives to the 2011 trial of Casey Anthony. We know how it ended. It ended with an acquittal on the most serious charges and convictions on some misdemeanor accusations of lying to police for the mother who was accused of killing her little girl, Kaylee. Deborah Blum is still here with us on the Law News Network, and you know, it's a case that happened when I was in law school. So I wasn't glued to it because I had to study, but so many people were just transfixed by this case. And is it because of the death of the girl? Is it because it ultimately ended in an acquittal? Is it because it was all circumstantial evidence, or all of the above?
All of the above and more. You know, I think that you have a very unique individual who is accused of the crime. She's a beautiful woman, a beautiful little girl who was tragically killed. We still don't know how, and we're still finding out more information now. Mom, Casey Anthony, is giving reports to the media still. Her parents are still reacting. This is something that we're going to continue to learn more information about, I think, into the very near future.
Well, you know, we're taking a look at the pictures now, and it's just a case that brings back bad memories for so many people, because a lot of people in this case turned the page the next morning and said, we're just going to love to hate Jose Baez, who then went on and you know, did many other high-profile prosecutions. But this acquittal was largely his brainchild, and it opened him up to both praise and criticism, depending on which side of the spectrum people sat on as far as guilt or innocence.
You know, I recently represented somebody in a manslaughter matter where he did kill another individual, but I genuinely believe that he did not intend to take a life, and I genuinely believe that he did not intend to commit serious physical injury. But it was very emotional to see the victim's mother, so the deceased boy. His mother would come to court every single court appearance, and she would cry and is clearly in a lot of pain because her son is missing. And then you also would interact with my client's family, who their son, if he went to trial, faced up to 25 years in jail, which is a significant amount of time and what he probably would have gotten if we lost trial. And he faces a large amount of time if he enters a plea of guilty, and it's just very hard for the family on both sides, because you have a young man who took another life. I don't believe intended to do it, but there's no explanation why it occurred outside of, yeah, there is some basic explanation, but it's just incredibly tragic from every angle you look at it at. And that is why you can be a defense attorney and represent people who are accused of these heinous things, because everybody is entitled to a defense. Your job at trial is to craft the best possible defense, and that means zealously defending your client and sometimes presenting an alternate theory, which is what Baez and the defense team did in this case. They ran with, it was an accident. The death of Kaylee Anthony was an accident that then went terribly wrong and should have been reported, but it wasn't. But that doesn't make her a vicious killer.
Did that defense even make sense to you? I mean, I'm sure that now, looking back, you think it was the best defense ever. And I know that Deborah Blum believes that no one ever is responsible for criminal conduct, or at least that's what I accuse you of saying. So, you know, looking back, does that kind of defense make sense? Because if I were sitting on the jury, I would be inclined to say, you know what, okay, accident, if you'd reported it, then I'd believe you.
You know, I think that what the defense was able to really run with, and I spoke about this with Misty earlier, was that the father allegedly had an affair. And that woman took the stand and said, yes, I was having an affair with Casey Anthony's father, and yes, he said to me that Kaylee's death was an accident that went terribly wrong. So the jury was able to hook onto that statement and probably believed that Casey Anthony's father and maybe even her mother were in on this death. So maybe they were not able to take a leap and say, no, Casey Anthony was fully responsible for this and it was premeditated murder. And of course, I would like to state that some people are very guilty of crimes. It's just in having the experience of committing the crimes, but in my experience, sometimes socioeconomic factors play into the commission of a crime, and there are other things going on. Mental health, I think that we just have to really, in this country, improve upon many things, which is access to guns. Why are so many people able to access a gun? Like the shooting that just occurred at the Bronx Lebanon Hospital. Why was that man able to get a gun? Why are certain groups kept in the way that they, in their current economic state, and not helped by encouraging their growth? So I think that there are a lot of reasons that people commit crime or get sucked into a life of crime. Some are really terrible people that should be behind bars. Others are people that would really tremendously benefit from rehabilitation. In this Casey Anthony matter, I think if the jury had the benefit of knowing what we know now and actually looking at it in the way that you read it on the many networks that have covered this matter since the not guilty verdicts, they might have convicted. Because maybe not of first-degree murder, but probably of aggravated child abuse and aggravated manslaughter of a child. Because
yeah, I mean, it just seems, okay, so if there's not quite, look, if there's not enough evidence for first-degree murder, I don't think that charge should stick. And we see so many of those trials here on the Law News Network where the charge seems to be wrung about as if it were nothing by many prosecutors, okay, because many want to have that first-degree murder conviction on the resume, okay, or at least on the information that's circulated to voters in the district. You know, so there's that element that plays into some of the less scrupulous prosecutors' offices out there in the country. I recognize that that happens. But, okay, well, if the girl is saying, oh, well, it's an accident gone wrong, well, then there could be a litany of charges related to that. Improperly disposing of a corpse, you know, failure to report a death. You know, if that's where we're going, then, okay, well, there's an admission to a litany of other crimes other than the lying to police misdemeanors that are there. At least there are in New York. I'm assuming Florida has similar laws. So it just seems to me that as a defense tactic, it was a really interesting tactic. Perhaps if I were sitting in her defense team's shoes, I wouldn't have been so quick to basically cop an admission to a litany of other crimes to try to deflect attention from the big crime.
Well, she wasn't charged with disposing of a body. She was just charged with lying to the police, and there was no way for them to get around it. And then they were able to explain, look, she has a messed up family life and had years of abuse at the hands of her brother and her father.
But does that really detract from the? So I mean, how is that a catch-all that just absolves guilt in a first-degree murder case?
I think that the jury here didn't believe that she was guilty alone, or even if she was guilty of the child's death, that she intended, so that this was an intentional, premeditated act. That's clearly what the jury had a hard time believing for the first-degree murder charge.
Well, we will continue to listen to the case. We're going to dip now into some of the defense opening statements in this case. It's really interesting now that we know the outcome to go back and listen to exactly what was said, when it was said, and how it was said to see which arguments were more persuasive than others. So we'll listen to some of the defense's opening statements, and we'll be back with more analysis when they're done.
Good afternoon, ladies and gentlemen. On behalf of the defense, I want to thank you for the sacrifice that you've made in your jury service and coming here and helping us see justice. We know it's no easy task, and we intend, I'm sure both sides, on getting you home as quickly as possible once you have all of the information that you need, and not a moment before. We are here, and you had to leave your homes because of an onslaught of publicity that lasted for 3 years. In the middle of sound bites and sensational media coverage, Casey Anthony stands trial for her life. Now, what I'd like to cover with you, I've organized my opening statement into several different ways. I'd like to cover with you what I'm going to go over first. First off, I'd like to tell you what happened. We sat through almost 2 hours. There was day 1, day 2, day 3, day 4, and so on and so on. But no one ever told you what happened. But today, you will be the first people to know exactly what happened to Kaylee Marie Anthony. I will also discuss with you Mr. Roy Kronk. That name was silent throughout the first 2 hours of this morning. And I think you're going to find after I conclude that it's going to be shocking why that name wasn't mentioned to you previously. And what, if any, role Mr. Kronk will have in your evaluation of the evidence. I think that's very important, and we're going to cover that. After that, I'd like to talk to you about the investigation. This investigation was extremely thorough when it comes to focusing in on Casey. Probably the most comprehensive investigation that you will ever come across and in the history of the state of Florida. It was directed at one person and one person only. Now, the problem with this investigation that you'll find is that it reached the level of desperation. And that's going to be covered throughout my opening statement and my opening remarks. At what point do we stop speculating? At what point do we stop guessing? At what point do we stop being so desperate? Now, after the investigation, I want to talk to you about Suburban Drive. Suburban Drive is the location which is right around the corner from the Anthony home, and it is where Kaylee's remains were recovered. And there are numerous suspicious circumstances surrounding that location, and I want to make sure it's brought to light to you. I want to make sure you all understand what was there, who was there, and for how long. And then after that, I'd like to discuss Miss Anthony's car. Now, as you've noticed from this morning, there was a significant amount of time that had to deal with this car. And the evidence, or the lack of evidence, or the confusion of the evidence that surrounds this car will probably double, if not triple, the length of this trial. And at the end of it, you may find yourselves asking yourselves, after so much time, is that really relevant? Does it answer the question? Does it tell us how Kaylee died? And that's why you're all here today. We're not here to talk about day 1, day 2, day 3, day 4. We're not here to talk about how inappropriate Casey acted, her foolish actions. We're here to talk about, and we're here to find out exactly how Kaylee died. And that's the key issue throughout this entire case. You may get distracted by emotion, and you may get distracted by what some might say reaches the level of bizarre. But you cannot lose focus, and you cannot forget that you're here on a first-degree murder case, a death penalty case, where they want to take someone's life. And that's what we're here for. And you're going to find that this is not a murder case. This is not a manslaughter case. This is not a case of aggravated child abuse. This is none of those things. But you can't be distracted. We all chose you because we thought you were the best jurors to sit on this case. You wouldn't be distracted by emotion that would let the law guide you in making a just decision. The death of a child is a horrible, horrible tragedy. And no one here is going to ever say otherwise. But we have to remain focused. We're not the media. We don't have the opportunity to speculate and to draw in viewers and to sensationalize life. And that's what we're going to talk about throughout this trial, is life. Some of the happy things, but many of the ugly things that come along with life. And that's what this case is going to be about. Afterwards, I want to talk about the forensics. Exactly what reliable forensics you can rely on, and what isn't necessarily science, but more like science fiction. And you'll see that throughout the course of this trial as the state reaches that level of desperation. And then I want to conclude with my parting remarks and tell you where I think at the very end of this trial we will end up at. Now, everyone wants to know what happened. How in the world can a mother wait 30 days before ever reporting her child missing? It's insane. It's bizarre. Something's just not right about that. Well, the answer is actually relatively simple. She never was missing. Caylee Anthony died on June 16, 2008, when she drowned in her family's swimming pool. You're going to hear that Caylee loved to swim, and Caylee could get out of the house very easily, and did so on that day. We hear about it every day, or once a week, or once every other week. We hear of a story on the news, or we'll see a little blurb on the newspaper about some poor child who accidentally drowned in the family swimming pool. Well, the reason we're all here is because not of the commonality of this tragedy. Now, that's unfortunately, it's far too common. In fact, in the state of Florida, it is the #1 way that children die, is drowning in swimming pools. But what makes this case different, what makes it unique, what makes the reason we're all standing here today, is because not of the commonality, but of the uniqueness of the family that it happened to. You will hear stories about a family that is incredibly dysfunctional. You will hear about ugly things, secret things, things that people don't speak about, things that Casey never spoke about. Come with me to 4937 Hope Spring Drive, or as you can see, it looks like the All-American home. In fact, you can drive by any home in the United States and never know what goes on behind closed doors. You never know what secrets lie within. You never know what's going on. On June 16, 2008, after Caylee died, Casey did what she's been doing all her life, or for most of it, hiding her pain, going into that dark corner and pretending that she does not live in the situation that she's living in. She went back to that deep, ugly place called denial to pretend as if nothing was wrong. And you'll see as the evidence comes in that that is the most likely conclusion of the evidence, that something's not right here. Something's not right with this girl. You've heard some of it today. Some of it may have been shocking already for you to listen to. But what you don't hear, what you didn't hear, is that Casey was an excellent mother. She took care of Caylee. That child never went without food, without clothing, without shelter. You won't hear a single person come up here and testify how she was neglected or abused. There's no broken bones. There's no trips to the hospital. There's no moment that would help you determine that this child was abused or anything but loved by all members of the family, especially her mother. The photographs that Mr. Aimburdick talked about early on, they were all taken by Casey. Casey adored her child. And you'll see photographs of her room, of her life, and you'll know that this child was loved, but not for a horrible tragedy, a common tragedy. Are we all here today? You see, this family must keep its secrets quiet. And it all began when Casey was 8 years old and her father came into her room and began to touch her inappropriately. And it escalated. And it escalated. What does a sex abuse survivor look like? They wear a scarlet letter. They have a tattoo on their forehead. We could all be sitting next to a person who's a sex abuse survivor and never even know it. These things are kept quiet. And these ugly secrets slowly will come out through this trial. A little bit of a sign here, a sign there, a sign here. And you'll be able to know and see what makes Casey Anthony behave the way she does. Why did she act as if nothing was wrong? She didn't run. She didn't move to California, New York, and say to her parents, sorry, you're never going to see your granddaughter again. That's the easiest thing to do. Instead, she acted as if it never happened. It never even happened. You hear stories of this Zanny the nanny. It's true. For 2 years, she pretended she had a job and pretended she had a nanny. Is that normal? Is that what normal people do? They get dressed up. They pretend that they're going to work. They have fake emails from work. Well, there was a reason behind this. Something's not right here. And anything Casey could do to protect her child, she did, including living a lie, making up a nanny, making up a job. That's what Casey had to do to live. She wanted to live. She forced herself to live in a world that she wanted to, not the one she was thrust into. And you're going to see throughout this case how some of this evidence came to be. For example, when Casey came home and told her family that she was pregnant, just to be kept quiet. No one was to know. Why? I hate to say, you'll have to speculate why. Unfortunately, because of the way this case was investigated, we'll never know all the answers. But it wasn't until she was 7.5 months pregnant did the outside world know that Casey was with child. When Casey was about 7 months pregnant, the family went to a wedding. Her mother's brother's wedding. This is her uncle. They're there. That's their wedding photo in June. Kaylee was born in August. This is Casey, 7 months pregnant. Everyone wanted to know who the pregnant girl was at the party. When Cindy Anthony, Casey's mother, and George Anthony were confronted with this, they both looked at Cindy's brother like he was crazy. They denied. Cindy, who is a registered nurse, said, "Oh no, she's just retaining water." You'll hear other stories, well, oh, she just had a tumor. She was pregnant. There's no denying this. This is a pregnant girl. But yet the entire family wanted to keep it quiet. Why? they hid this child, this beautiful child, in life, you can best believe that they would hide her death. Now, another thing you'll hear is when Casey didn't want to hide this anymore, she went to Cindy's job. And in the middle of the summertime in July, wearing an overcoat, hot summer day, wearing a huge coat to hide her pregnancy. But co-workers saw her. They began to talk. Office gossip came around. And unfortunately, a week later, Cindy Anthony had to come in and announce that she was going to be a grandmother. Something's not right here. This is strange. This is bizarre. This is the life of Casey Anthony. Now, as this case was being investigated, this all came to light. Everyone was aware that they hid this beautiful child like a flower in the attic. They treated this pregnancy as if it never happened. Police got to be a little suspicious, and you'll hear evidence that Casey has a brother, and he too wanted to follow in his father's footsteps. And on certain occasions when he was a teenager, he attempted to also touch his sister, although it didn't go as far. It got so bad that the FBI did a paternity test to see if he was Kaylee's father. And when he was confronted with this information, he didn't deny it. He said, "We'll talk about it when the time is right." Well, the time is now. The time is now to try and save his sister's life, but yet these secrets, these family secrets, still remain locked. You're going to hear all kinds of bizarre family behavior that just doesn't make sense. How parents should stand by their child, but instead are throwing them under the bus, making bizarre statements and accusations. And that's what this case is going to be about. You're going to hear all kinds of interesting behavior from all parties, not just Casey. And once you see some of this behavior, you'll realize that the apple doesn't fall very far from the tree. We are what we are because of who brought us into this world and how we were raised. Casey was raised to lie. This child, who at 8 years old, learned to lie immediately. She could be 13 years old, have her father's penis in her mouth, and then go to school and play with the other kids as if nothing ever happened. Nothing's wrong. That will help you understand why no one knew that her child was dead. That's the most important thing you must keep in the back of your mind, is that sex abuse does things to us. It changes you. Some people are fortunate to live with it. Others are not. And in this sad tragedy, it had to happen to Casey. On June 16th, 2008, Casey was home with Kaylee, and so was her father. Early morning hours, the exact time is not known. It could have been early afternoon, early morning. Actually, it was the early morning hours. George Anthony approached Casey and started yelling at her, "Where's Kaylee? Where's Kaylee?" They began to search the house. They couldn't find her. They searched in the bedroom. They searched under the beds, in the closets, in the garage. Then they went outside. This is a mock-up of the Anthony home, where you'll see they both came outside. Casey came around to the left of the house. George went that way towards the pool. They have an above-ground pool with a ladder. And we'll talk about the pool and the ladder in just a moment. But what happened next is, as soon as Casey came around this corner and went back, she saw George Anthony holding Kaylee in his arms. She immediately grabbed Kaylee and began to cry and cry and cry. And shortly thereafter, George began to yell at her. "Look what you've done! Your mother will never forgive you, and you will go to jail for child neglect for the rest of your freaking life." She cried and asked for her father's help. And it was shortly thereafter that George did help. It's at this moment that Casey should have been stronger. Casey should have called 911. Casey should have done the right thing. And that's what she's guilty of. She's not guilty of murder. This is not a murder case. This is not a manslaughter case. This is a sad, tragic accident that snowballed out of control. Her death was covered up. Why did George do this? Why didn't he call 911? Again, if the investigation had gone in a different direction, maybe we'd have the answers to those questions. But unfortunately, we don't. We've done our best, and we'll do our best to bring all the information to you, but that, unfortunately, will go unanswered. Here's some things you must know about the swimming pool. Cindy Anthony will testify that on June 15th, as Ms. Drain-Burdick mentioned, Cindy Anthony and Kaylee went swimming. That was Father's Day. They went swimming until the early evening hours, late afternoon hours. They have a ladder that is on the pool, which they will both tell you they were religious about making sure the ladder was down so Kaylee wouldn't get up. They were religious about it. But unfortunately, did Cindy leave the ladder up? Did Cindy forget? Because right about the time they were getting out of the pool, Casey came home. We don't know. We don't know. Is she holding guilt inside of her for leaving that ladder up? We don't know. Again, if the investigation had gone in another direction, we might know. George Anthony will tell you that Kaylee used to wake him up all the time in the morning and say, "Jojo, swim, Jojo, swim," and that she can get out of the house in a hurry through the sliding glass doors and get out immediately. And that's why they were so religious about the pool. Now, something extremely odd happens the day after Kaylee drowned in the pool. And that is on the 17th, the day after, Cindy Anthony goes to work.
Welcome back, everybody. We're going to break into this opening statement from the Casey Anthony trial just to give a little bit of context, a little bit of analysis with Deborah Blum. We know she has to take off in about 45 minutes, so we wanted to go a couple steps down the track here and see what you think about it. We're hearing most of what ultimately became the core defense theory, and we're hearing a soft tone out of Jose Baez. He truly is a master of performance. You take that away right away.
Absolutely. I think he's improved since Casey Anthony, but this was his first major, to the best of my knowledge, his first major case where he was in the spotlight, and he certainly shined. So what I'm taking away from his opening is that he had his own theory, and he fully walked the jurors through it. How long is the opening? An hour? You know, that is a really long time, even in a case of this nature, to be speaking to the jury, because you're then saying, I'm really confident that this is what the evidence is going to show you, or you're just trying to blow smoke into their head and give your own theory, for lack of a better word, give your own theory so they think of an alternate theory, even if it's not what the evidence is going to show. And I don't know that the evidence in this trial fully supports what he's saying on opening. I don't know that we have this whole explanation as to what happened that evening with the pool and the removal of the ladder. I don't know that that's what the witnesses actually testified to.
Yeah, I mean, so certainly parts of it changed, but I think that his tone is soft, it's apologetic. He's trying to get the jury to believe his side of it right out of the gate. And we see a lot of defense attorneys don't really come up with a clear theory of their own about something, but Jose Baez does it frequently. So
well, I don't know that that's the most ethical always, because sometimes you're supposed to do, we've used this word before, and I'm not saying that he's an unethical attorney. I certainly don't know enough about him or really don't make those judgments about other attorneys. But sometimes if you know that you're not really able to prove what you're saying, you just don't say it. So perhaps at the time he thought that that's what the evidence was going to support, but if you know that you're not going to be able to come up with that evidence, you don't say it in opening and you go with the non-opening opening, which just really explains that the prosecution has a burden beyond a reasonable doubt, which is the highest burden of proof that we have in this state, in this country, and that the state, the prosecution, has to prove each and every element of each and every crime charge beyond a reasonable doubt.
Okay, so we don't want to do the unethical stuff. We don't want to see anybody do the unethical stuff. But it seems to me that defense attorneys have a stronger shot at winning when they have their own theory of the case. And in this case, he's saying, well, we know what happened to the girl. It was an accident, and then she panicked or whatever, and then disposed of the body. The thing that's interesting about that, I think, from an ethics, and I'm not talking about a professional responsibility standpoint, I'm just talking like pure ethics, is it's almost as if the defendant were testifying without testifying.
Absolutely.
You know, so it's a really weird situation, because then the prosecutor, in theory, could sit there and say, oh, okay, we don't have any evidence of that.
Well, absolutely. And Casey Anthony does not take the stand. She did not testify on her own behalf. So I think that he might have pushed the limits in terms of what he got into. But yes, people like to typically hear from the accused, even though the judge reiterates to them that the defendant has no burden whatsoever. The defendant could sit there and not even give an opening, not even give a closing, and it's still up to the prosecution to prove each and every element of each and every crime charge beyond a reasonable doubt. The only one that typically, in let's say 90% of the cases, that has a burden is the prosecution. So I think that what he did here was give the jurors what they wanted to hear and present his client's version of events. Very likely, Casey Anthony never said to him, I'm guilty of killing my daughter. So long as he didn't have an admission from her, he was able to say some of what he said. I don't know about the entirety of it, but definitely a good portion of it.
Well, we're going to continue listening to the opening statements in the Casey Anthony case. We're going to have a live trial back next week. So in the meantime, this is certainly educational for me, because this is the first time that I've heard this start to finish. I know enough about the case, but it's the first time I've listened to the openings word for word. So we'll continue to listen in, and we'll be back in about 20 minutes.
The unique brand of duct tape that Mr. Aimberdick mentioned is right on there. We've all seen duct tape, but it's very rare when you see duct tape with a logo on it. And this duct tape has a unique logo of the company right on it. And that's what makes it so distinguishing. And you will find that when Kaylee's remains are found, there was duct tape with the remains. 3 pieces of duct tape with the same brand. And is it a coincidence that the only place in the house, you know, not on the pipes, not in the garage, not on some other, on some kind of repairs that may have been done in the house, the only place in the entire house that this duct tape is on this gas can. Just a couple of inches. But it's on this gas can that was coincidentally reported missing. Is that a coincidence? Or something more, or is there more to the story here? Well, on August 1st, right around this weekend, August 1st, August 2nd, George Anthony is at a Publix passing out flyers of his missing granddaughter that he knows is dead. He's passing out flyers and asking for donations, but a news crew is filming him. In fact, 2 different news crews are there, and he interviews with them. And right behind the donation jar is a roll of duct tape. The duct tape hidden right behind the donation jar. Mind you, this is first week of August. Casey has been in jail for 2 weeks. All you have to do is follow the duct tape, and it will point to you who put Kaylee's remains where they ultimately ended up. Or maybe not. And that I'll get into in a moment. Ms. Strain Burdick told you that the only one who had access to this duct tape was Casey Anthony. Well, that's not true. It's not true at all. Picture tells 1,000 words. He was at that command center. He was home on the 16th. The only person and the only piece of evidence, the only physical evidence that you will find in this case that connects Kaylee's remains to anyone at the home is this duct tape. And that's why these gas cans become such a critical piece of information and such a critical piece of evidence. You cannot deny it. You can see it. You can feel it. You can touch it. This is evidence. And this tells you.
Your Honor, I'm going to object to argument rather than open statement.
Continue.
Thank you, Judge. And this will lead you to the answers that you need. Now, most importantly, you're going to hear evidence that while at this public supermarket passing out flyers of his missing granddaughter, George Anthony met a younger woman by the name of Crystal Holloway. They became close. They started dating, or they had an affair, whatever you want to call it. He then began going to her house and visiting her. And on one day, before Kaylee's remains were found, her name is Crystal Holloway. Here's Fort Worth. And they began to carry on this relationship. This is the woman in the circle looking over at George at Kaylee's memorial is Crystal Holloway. Right around that time, George Anthony sent her this text. Well, he has denied and will deny on this stand that he ever had a relationship with her. But he couldn't get around the guard at the gate where she lives in, because that woman saw him coming and going many times at her home. And Crystal Holloway will tell you that one day they had a conversation, her and George Anthony. And George began to break down and cry. And she asked him, what happened to Kaylee? And he said, it was an accident that snowballed out of control. This is before Kaylee was ever found. This is while he is out passing out flyers, asking for donations to help find his missing granddaughter. George Anthony carried around this guilt for many, many months. It got to its breaking point on January 22nd of 2009 when he decided to try and take his own life. Fortunately, he was unsuccessful and the police found him. And we never got the answer in his suicide note. Again, a lot of insinuations, a lot of roundabout talk, but no direct answers. No concrete answers as to why he has all of this evidence, all of this information, and isn't telling anyone. I want to be clear about something. Absolutely 100% crystal clear about something. We are not, nor will we ever, say that George Anthony killed Kaylee, or that he had something to do with her death. And the reason's simple. It's not true. It was an accident. And despite how easy it is to point the finger and say there's something sinister here, and maybe play on your emotions, the fact of the matter is, this is an accident that snowballed out of control. This is not a murder case. This is not a manslaughter case. This is a tragic accident that happened to some very disturbed people. People with significant issues, unresolved issues, unresolved trauma. And while it's been fodder for the media, and these bizarre stories just go on and on and on, the fact of the matter is, it's an all too common tragedy, an unfortunate one. Now, I'd like to talk to you briefly about Mr. Roy Kronk, the name that you reviewed during the spring verdict's opening statement. Mr. Kronk is the person who found Kaylee's remains off of Suburban Drive. And I'm going to show you right now a brief diagram and the interesting circumstances surrounding Mr. Kronk and his discovery. Now, before I start, I want to tell you that Mr. Kronk, and again, we are not saying Mr. Kronk had anything to do with Kaylee's death, but Mr. Kronk is a morally bankrupt individual who actually took Kaylee's body and hid her. And anything that you derive from the scene off of Suburban Drive is completely unreliable because of the actions of Mr. Kronk. There was a $225,000 reward in this case, but it was for a live Kaylee. Mr. Kronk didn't read the fine print, and he thought he had himself a lottery ticket. Let me tell you and show you how Kaylee was recovered. First of all, the Anthonys live on 4937 Hope Spring Drive. Right down the block, around the corner, there's a wooded area. What's unique about this is it's the closest wooded area to the home. And it is the absolute first place anyone would look for a missing child. The first search party should have been and was probably there. Kaylee Anthony was found within 20 feet off the side of the road. She wasn't found in the woods. She was found off the side of the road and was missing for 6 months. Let me give you an example of just how far that is, actually, Mr. Tyler. Actually, this way. Now, you're 4 feet away from the actual wall. This is how far Kaylee was from the street, from where you're sitting. And if you take into consideration that there's grass that's about 5 feet, this is how far, if you were mowing the lawn, walking by on your way to school, or walking your child to school, walking your dog, this is how far away you would be. And for 6 months, with thousands of searchers looking for Kaylee, hundreds of people off Suburban Drive, every character with an agenda was down here looking. We had psychic dog handlers. I'm serious. We had a psychic dog handler. We had psychics, private detectives, bounty hunters, search volunteers, police officers. In fact, in October, there was 2 people called 911 because they heard of a screaming child in the woods. So police were dispatched, helicopters were deployed, and they searched this entire perimeter area. They didn't find anything. In September, they also searched this area. Volunteer searchers searched that area with a group called Texas EcuSearch. Then in the first week of November, again they searched this area. Well, police also searched that area, but there are no reports of it. The only reports of searches that we could find were from the Orlando Police Department, not the Orange County Sheriff's Office. But yet, on December 11th, when Kaylee was found, the sheriff came out and announced that they were all over that area, and it was probably underwater. So the state of Florida does the smart thing and gets a hydrologist from the University of Florida to come out and conduct a study to be able to show to you how much underwater this area was. Well, it turns out that that place was only underwater for 10 days. The rest of the 6 months, it was completely dry. Well, not completely dry, but it was dry. Now let me tell you about Mr. Cronk and his activities. On August 11th, Mr. Cronk is a meter reader, and he stopped off the Suburban Drive right around here with 2 of his co-workers. And right down the block, everyone was talking about the media frenzy over here. Now, this is August 11th. Kaylee's been reported missing for several weeks now. And there are about 5 or 6 news trucks parked outside of the Anthony home, and everyone's heard about this case, especially here in Orlando. One of Cronk's co-workers says to him, you know, this would be a good place to dump a body. They should search here. Mr. Cronk says, yeah, you're right. He then goes into the woods to urinate. And while he's urinating, he tells his friends, hey, I think I see a skull over here. And they start, oh, you're crazy. They start walking towards him, and they see a dead snake. And they get so distracted by the snake that they forget about the skull. Mr. Cronk will later be asked, how sure were you that you saw a skull? They'll say 99.9999%. I was certain. On August 11th, I saw a skull. Well, he doesn't tell his friends, forget the snake, come look at this skull. He doesn't come down here and get a news van and say, I found Kaylee. Does nothing. Goes back to work. Doesn't mention it again to any of his coworkers. Well, later on that afternoon, Mr. Cronk calls 911 and says, you know, there's 2 little areas that you can go in, and there's one long big tree laying down, and a bit further up, I saw something round and white. Not saying it's Kaylee or anything like that, but you may want to check it out. Okay? Officers respond, but they drive by, they don't see anything. August 12th, he calls again. And he talks about a suspicious gray bag, vinyl-like bag, even the material, vinyl. And he describes an area where someone ran across with a mower, but the weeds are still high, and a fallen tree that looks like someone tried to cut it with a white board. I'm sorry, someone tried to cut it, and there was a white board hanging across. A lot of details he's giving. Well, the police come out again, they drive by, they don't see anything. The next day, they tell him, why don't you come out tomorrow after work and you show us where exactly this happened. Well, he comes out and he meets a deputy. And the deputy's there to investigate a suspicious bag of bones. For some reason, it's not a skull anymore. It's a bag. The skull found its way into the bag. Deputy Kane arrives, and I'm going to go into a little bit more detail about what Deputy Kane said, but he doesn't find anything. Doesn't find the bag of bones. Doesn't find anything. September goes by. October goes by. November goes by. Mr. Crunk has the route of the Anthony home again. About a week later, he calls his son up. He has an estranged son that's in the Coast Guard. And his son will come here and testify and tell you, my dad called me and told me I found Kaylee's remains. Watch for me on TV because I want to be rich and famous. This is almost a month before he finds Kaylee's remains. December 10th, Mr. Crunk, his car breaks down and he has a bill of $1,084. This is significant because he's broke. It's time to cash in his lottery ticket. December 11th, the very next day, he has the route again. As luck would have it, he has to urinate and goes into the same wooded area and finds Kaylee's remains. Reasonable doubt is not sprinkled throughout this case. Reasonable doubt lives here throughout the entire case. You will not be able to trust a thing having to do with Mr. Crunk because he had control of Kaylee's remains for obviously several months. Where he found her, we do not know. Nor will we ever know. And the reason for that is because the police never investigated him. This was their three-legged pony, and they were going to ride him to the finish line no matter what. Mr. Crunk says that on the 11th, he goes to urinate and sees a plastic bag. Okay, he sees a plastic bag. He hits the plastic bag and he hears a thud. Then he takes his meter reader stick and he lifts the bag up and a skull rolls out. Again, somehow the skull may...
Welcome back once again to the Law News Network. I'm Aaron Keller. I'm here with Deborah Blum, and we're listening to Jose Baez's opening statements in the Casey Anthony murder case from 2011. We know how the case ended, but because we've got a little bit of downtime on this holiday week before we start our next case next week, which is the Holly Bobo case out of Tennessee, we thought we'd dip back into the archives and go back over some of the arguments that were made. This is a part of the opening that is a little more dry from an analysis standpoint. It's not as exciting to watch, but he's really making the case that the defendant, Casey Anthony, had suffered abuse as a child, and he really is trying to extrapolate some degree of sympathy and empathy, and he's convincing in a lot of ways. And I know a lot of people hate to hear that, but he did convince the jury. And he has a way about him that, in this case at least, really speaks directly to the jury.
Absolutely. You know, we just ended on him attacking what one of the witnesses was going to say and explaining to the jury why they can't believe that witness. I think he did an excellent job there. It is very important for jurors to be reminded that you have to believe the witnesses and that you have to be able to trust what they're saying. And if there are reasons why you shouldn't trust them, then you shouldn't believe them. And what does that lead to? Doubt. So
yeah, it's a slow part of this this opening, as I said, but he's really going through the state of the body. You know, it's detailed, and it does have a trajectory through it. It's not just like, hey, jury, you need to hold the prosecution to its burden and focus on them, not on me. He does have a counter narrative, and he did in the Aaron Hernandez case, which we covered a couple of months ago here on the Law News Network. So as a defense attorney yourself, do you always prefer the cases where you can develop a strong counter narrative?
I think that the jurors really want a counter narrative. So you sometimes just attack what the prosecution presents and don't have to give a counter narrative because you feel as a judgment call that it's strong enough to poke holes at what the prosecution presents. But you typically like to weave in your own narrative, your client's own version of events. And that's where what I was saying before comes into play. If your client admits to you that they are guilty, you can't then say they're not guilty and tell that to the jury, because you're crossing a line there that you're not allowed to cross. But again, in this case, I don't believe that Casey Anthony ever admitted guilt. She's given some bizarre interviews since the time that she was found not guilty, where she again denies guilt, says, I really don't know what happened during that time period. It's like she went into a fugue state.
Yeah, some of the interviews are bizarre, and there are a few people who are mad that she didn't sell her interview, because in theory, I guess she could have made money off of it, although most legitimate journalistic entities don't pay for interviews because the payment can influence the content.
Absolutely. You know, that's like the classic line that you hear in a trial. So it's similar with when somebody is appearing at a trial. When you have an expert witness, they typically receive payment. So as a defense attorney, you don't just have people come in and show up and testify on your behalf, but you're relying on those people giving a valid opinion and giving their analysis of what they saw when they reviewed the records that you asked them to review.
Yeah, and what's at stake in a criminal trial, or even in a civil trial, is drastically higher than what's at stake in a journalistic interview. So I remember when I was a journalist having people who saw things that were critical, like, well, I'm not going to talk to you unless I get paid about it. Well, we don't do that. You know, that's the way most news organizations would respond to something like that. So, you know, it's been an ethics issue that's been batted back and forth. And okay, well, even though there are some people out there that absolutely hate Casey Anthony's guts, to her credit, she, from what I understand, didn't get paid for the interview, that she did at least the first one. So,
well, she's certainly gotten a lot of notoriety from giving interviews. Her defense attorney got a lot of notoriety. Everybody here did. You know, maybe not the prosecution, but the defense, certainly.
Certainly. So we know the outcome of the case at this point, but have you picked up on anything special listening to bits and pieces of it here that really jumps out at you and says, now I understand why that was being said, because it ultimately led to this conclusion that far down the tracks?
Well, what jumps out at me is this hour-long plus opening where he's really educating the jury on Casey Anthony's version of events, or his version of events, and really starting to say, you cannot believe the witnesses, you cannot believe her parents, for example, because they're liars also. So I think that's really interesting. I don't know that at the time when I watched this trial, I wasn't doing legal commentary at the time. It was still very early on in my career, but I think that it's interesting that you have this dynamic where the daughter is saying, no, my parents are guilty to some degree, and it certainly drove a wedge in their relationship, which you could see to this day.
Yeah, certainly. So we know that there's bad blood in the family. We know that people are upset about about the outcome. I mean, well, we can understand the bad blood, just to dial that back a half a step again, because she's accusing the father of all sorts of abuse, so then all this dirty laundry comes out, you know, or at least accusations of dirty laundry. So, of course, that's going to cause all kinds of bad blood even within the family. Where does she have to turn? And it gives an indication, okay, well, she's living with the person who is the investigator in the case, as I understand.
Well, yes, I believe it's been verified that she's living with the former investigator in this case, which is peculiar, but a lot of things are peculiar. Something that I found interesting in Baez's opening statement is you don't know what goes on behind closed doors in the homes of Americans. Well, nowadays, with the use of surveillance footage everywhere and everybody having a cell phone that they record on frequently, you know a bit more what goes on in closed doors. So I think that the defense here had the benefit of this being year 2008 when this potentially murder of this young child was perpetrated, whether it was his client that did it or someone else, or an accident that was covered up. Nowadays, I think there would have been a little more, even though in the cases of youngsters that we covered here recently, the bodies were so badly deteriorated that they couldn't find a cause of death, or they couldn't link somebody to the actual killing because the body was not in a state where they could get forensic evidence from it.
So much has changed with the cell phone technology just in and of itself. You know, nowadays somebody can buy a camera that's slightly bigger than a couple of bundles of lipstick that can record a high definition video where people are recognizable. It's not just the blurry figure in the old surveillance video that we remember from the 80s and even into the 90s and the early 2000s. Now we've got high definition video with inexpensive plastic lenses that makes things recognizable, and it just changes the way evidence is gathered. I know of one police department upstate, and maybe you know of a few others, that actually has a database where they're asking people who in their jurisdiction to quote unquote register their surveillance cameras so that if there's a crime somewhere, the police automatically know where the camera is.
I just think that's scary.
Well, I think it is too, but and I remember looking at that and just telling a journalist I knew in upstate New York, like, you really ought to do a story on this, because in the fine print of the agreement, there was a copyright licensing thing that basically said, well, by licensing your camera, you're agreeing that the police co-own the copyright to the footage you record off of the surveillance camera that you tacked up in the front door of your business or your home. So you can't just turn around and sell it if it shows something interesting, like if a deer crashes into the window, can't sell it because they co-own it, and it just raises all sorts of ethical issues. It raises constitutional issues. You know, I mean, search and seizure wise, part of me wonders if it raises that issue, because if they're the co-owner of it, then are they engaging in an illegal search?
Well,
I mean, I can put it up myself and then give it to the police, that's one thing, but if the police purport to co-own
right, then it
what's
could be
recorded, I'd be raising an objection about that if I were in your shoes.
Absolutely. Well, I think that there's a concept that Big Brother is really watching us, and people from cases I've seen have surveillance footage of their neighbors, because now people fear their neighbors, and everyone has a videotape of what's going on in the neighborhood. When there's bad blood between two neighbors, it seems like people have gotten more violent as opposed to when we were growing up and things were generally more peaceful. So people are tape recording each other, and also in actually researching a lot of my cases and making search and seizure arguments and other relevant points, you find that you would like a strict interpretation of the Constitution. So the police aren't supposed to come into your home unless there's an arrest warrant or there are exigent circumstances. But if they enter your home, then that's a patent violation, and that's a case that the state of New York follows. And then there are reversals or scale backs on that. So when you have a Supreme Court that does not do a strict interpretation of the Constitution, you get a lot of leeway for the police. So this would fall under police leeway, and it really would depend on, if this went to the Supreme Court of the United States, whether they were strict constitutionalists or if it was a liberal or a conservative Supreme Court. And that's where people run into issues, because I agree that that's just like allowing the police to have material that they're not technically allowed to have, and they would usually need some kind of warrant to obtain it.
Well, we can continue the debate, but I know you need to run, so we'll let you go. Deborah Blum, always nice to see you here.
Always wonderful to be here with you.
All right. We're going to continue listening to some of the opening statements in the Casey Anthony case, and we'll be back to wrap the day up in about 12 minutes.
I say, yes, I told them. In fact, he does. He says later on, he says, I did tell the police, but they told me, keep quiet about it. You don't want to say anything about that. That will be what we call a conflict in the evidence, because the police will thoroughly deny that they told Mr. Kronk to shut up and not say a word about calling back in August. Well, several days later, they have to go straighten out this story. They can't have skulls rolling out of bags because, as Mr. A. Burdick told you, that duct tape to them is the only thing they have. The duct tape that George had. They can't have a skull because the mandible, where she was placed, was directly underneath in the proper anatomical position. Skull rolling out of the bag isn't gonna end up that way, and they know it. So they massage Mr. Kronk's testimony, and he changes it. He says, yeah, didn't roll out of the bag. I just lifted the bag and it was underneath it. But he clearly says it dropped out of the bag. He's on audio, a written statement, everything. Sworn statements. Sworn to tell the truth. Well, one of the first responding officers, when they arrive to the scene and he's there, one of the first things he says to them is, do I still get the reward even though she's dead? Second statement is, will my ex-wife find out about the reward if I get it? Mr. Kronk's boss will come and testify that when he arrived on the scene on December 11th, Roy Kronk was leaning against his truck, smoking a cigarette. And he turns to him and he says, Alex, I just won the lottery. The police want Mr. Kronk to stay quiet. They don't want these people getting at him. They don't want the media getting to him. So they ask him, please stay quiet. And his response is, Roy's got to eat too. Sorry, fellas. So what does Orange County do? What does the great Orange County do? They hire him a lawyer. And they pay for it. Orange County pays for a lawyer for this man to represent him. And then he becomes his media agent. And the very first interview that Mr. Kronk gives is to Good Morning America, where he licenses them a photograph of a snake. In exchange for this snake photograph, $15,000 and an exclusive interview with Mr. Roy Kronk, the man who found Katie's remains. Well, he gets his reward. He gets his interview. He becomes famous. But there's one thing's for certain. You can't ignore any of this. At all. In fact, one of the call from August 12th ended up landing on a detective's desk sometime around late August. And it ended up in front of a detective named Gerald White. And Gerald White will come in and tell you that once he got the tip, he went to the lead detective, Yuri Melich, and he asked him about this tip. Detective Melich looked at it and said, that area's been searched already. But yet we don't have any records of any police searches. But you're going to hear numerous people saying the police searched there. You're going to hear witnesses come and testify that they were trespassed, told to get out of that area because that area had been searched many times. Where was she? What did Kronk do with her? Why did he place her there that way? And can you trust anything this man has to say? And I would tell you, you can't. You will clearly see that you can't. The bright lights and the spotlight and the promise of fame and fortune took this man to take away all of the answers that you seek throughout this case. We would love to have more than just a photograph of the duct tape with George at Publix. We'd love to be able to tell you more and show you more, but we can't. And one thing you will know is that despite all of the ridiculous, stupid things that Casey did, that Mr. Aim Burdick told you about, there's not one piece of evidence, one single thread of evidence that links Casey to Kaylee's body. She's dumb enough to leave her on the corner, but smart enough to outwit the FBI, Florida Department of Law Enforcement, Orange County Sheriff's Office, OPD, every law enforcement agency that the prosecution could muster up, every alphabet, the Secret Service. They even autopsied the snake. That's how desperate they were. Yes, there was a snake autopsy in this case. They searched for every single thing they could just to try and, well, it's quite obvious. A high-profile case. They had already made an arrest. Casey was arrested within 24 hours of being questioned, when there were clearly signs that something was not right with this girl. Something was just not right. They jumped the gun. They immediately made an arrest. We'll worry about the evidence later. And this is their evidence. This is how they get to where we are today. And this is how they ask you to take someone's life. As I mentioned, they don't even investigate Roy Kronk. They took everyone's phone records in this case, and they never asked for Mr. Kronk's phone records. We filed a motion to try and get him, and he objected. He didn't want anyone looking at his phone records or his cell tower information to determine where he was during these months. And the police didn't want to go looking for it either. They weren't about to do that. They didn't confiscate his computer. We took his deposition. We asked him, can you turn over your computer to the police? We'll think about it. They did nothing to investigate this matter. We found his son. We did. We went searching for him. And we found his son, who told us, my dad called me. They didn't go finding his son. My dad told me, watch, I'm going to be rich and famous. They didn't want looking, and you're going to notice that throughout this case. There's certain questions they don't want answered. And they're not going to go looking for them. But they'll line up to sit here and tell you about Casey Anthony and her bad behavior, her inappropriateness. She's not acting right. And that's what this case is about. She didn't act right. They don't ask why she didn't act right. Only that day 1, you heard it, day 2, day 3, day 4. It takes an elegant prosecutor to come up and do these things and get you emotionally riled up. But there's still no answers. The swimming pool incidents, the witnesses, the independent witnesses that will come and tell you about this, there's no getting around them. No getting around them. These are people with no axe to grind. Now, I want to talk briefly about the investigation. I know I've touched on it, but you heard Ms. Jane Burdick tell you that on this day, on day 7, Casey Anthony was spotted on video at IKEA, or day 12, she was spotted at the Blockbuster or another place. Day 13, she's at Applebee's. Well, they sure did. They sure did do a thorough investigation on her. But yet they still can't come up with the evidence. This is Sergeant John Allen. He's one of the lead investigators in this case. He's about 5 feet from the road, and he's pointing at Kaylee's remains. But yet for 6 months, and all of that investigation, no one could find her. Look how close he is. She was placed there to be found, not to be hidden. But unfortunately, she was placed there by Mr. Kronk, and we will never know the answers. Now I'd like to talk about the car. Actually, before I go into the car, I want to finish up on Suburban Drive for a moment. There are 2 videos that you will see. There are plenty of witnesses who will come up and take the stand and talk to you about Suburban Drive and whether it was dry or whether it was not. And okay, maybe you can rely on them. Unfortunately, it wasn't until the defense raised the issue that she was placed thereafter that law enforcement wanted to shut that down. And that was in 2009. A year after is when they started going to these volunteers and asking them. That place was underwater, right? That place was underwater, right? And of course, all of these, everybody who's all riled up about this case and can't stand the inappropriate girl, all tell the police the same thing. Yeah, it was underwater. Yeah, it was underwater. But there are 2 videos that you will see. One from a woman named Gail St. John, the psychic dog handler that I told you about. Right around in early August, she has a video where she drives by the Anthony home and you see all of the media trucks and drives down towards and around the house, around the Suburban Drive, and says, I'm having a feeling. They get out, and she has her dogs walk, and you'll see the woman walking about 30 feet. It's dry, but it's right around the area where Kaylee was found. And most interestingly, you'll hear about 2 private investigators who 1 month prior to Kaylee being found were out searching right at the area where Kaylee was found. What's interesting is these 2 private detectives were working for George and Cindy Anthony at the time. This may be a coincidence. Maybe. One of the private investigators, his name is Dominic Casey. He worked for the defense briefly, early on in the case, and then he went off to work for the Anthonys. Dominic Casey will tell you that he was on the phone with a psychic. Actually, first he tells everyone that he was investigating a tip, that when Casey was a young girl, she would hang out in the woods, and that he was out there investigating. And the police said, well, wait a minute. Casey's not a young girl anymore. She's 22 years old. Why would you look to see if that's a teenage hangout? And then he changes the story and says, well, I was following up on a psychic tip. Well, it turns out this psychic was introduced to Dominic Casey by Cindy Anthony. It could be a coincidence. But on December 20th, when the sheriff's office decides to issue a search warrant of the Anthony home, one of the first words out of Cindy Anthony's mouth is I had people search that area and the body wasn't there. That video, you will clearly see the water, the area is dry. Now I want to talk about the car. As I mentioned to you, actually, if you need a break, we can take a break. Your Honor?
Can't see you.
I can keep going.
Members of the jury, you need your break now? Okay, you can continue.
All right. The car, as I told you, this car will be the subject of much debate. And you will hear evidence in this case that has never been admitted in a court of law throughout the United States. The air samples that Ms. Drain Burdick told you about. The hair has never been admitted in the state of Florida. The evidence that Ms. Drain Burdick told you about. As well as you're going to hear from a dog. While the dog can't get up there and testify, his handler is going to talk about the dog and what his dog allegedly said or reacted or alerted to. And we're going to get into that when we talk about the forensics. But one of the important things that I want to talk about is everyone talks about the smell of this car. And there's some things you don't know. Things you should know. And here they are. June 16th is the day Kaylee drowned. On the 20th of June is when Casey runs out of gas for the first time. Now, it's going to be the state's contention that Kaylee was in the trunk of Casey's car from the 16th through the 20th. Well, Casey runs out of gas, and she calls her boyfriend up, Tony Lazaro. And she does what she's always done. Goes and gets the gas cans. They break into the shed, they take the gas cans.
Welcome back, everybody. We've been listening to a clip from the archives. That's the opening statement from defense attorney Jose Baez in the Casey Anthony murder case out of Florida. The case, as you know, was heard in 2011 and ended with an acquittal on the most serious charges for Casey Anthony over the death of her daughter, Caylee Anthony. We're going to continue with our review of that case tomorrow here on the Law News Network. We're expecting to be able to carry a live case next week. That's the Holly Bobo murder case out of Tennessee, where one of several defendants is facing a death penalty trial over the death of a 20-year-old nursing student. It's a case with a lot of twists and turns, and some evidence on a crime that happened many years ago was not discovered until this past spring. So you'll certainly want to stick with us when we begin covering our live case next week. But in the meantime, a reminder that we're on the air here from 9 a.m. until at least 5 p.m. Monday through Friday, except when there's a holiday like this week. And we do stay late when we have live testimony coming out of a case that runs late, especially when it happens on the West Coast, because we here on the East Coast will stay late when we have a late trial out on the West Coast. So our review of the Casey Anthony case will continue tomorrow here on the Law News Network starting at 9 a.m. For now, this is Aaron Keller at the Law News Network, and for all of us here, have a good evening.